Lordship.
With my lords leave. My lords, this is a fresh matter, my lords. The DRT has dismissed the matter for default. Though on the same day, on the previous day, the DRT had permitted to.
When did you file it?
My lords,
When did you file the writ petition?
this was filed 4 days back, my lords.
Why it is not coming, she'll verify, but I'll not give any memo. Yes.
My lords, one clarification. If a file is ready, my lords, that may be.
Office objections already, yeah,
Yes,
office objections are compliant.
they are cleared.
Every file has to come. Why it is not coming, she'll find out. Take it,
Please,
yes.
please.
This is for the direction to the DRT for disposal of SA in the time bound manner, because it has been adjourned to June 1. That is, it's already, statutory time is already over. Therefore, for direction.
Will not, yes.
My lord,
Let it come.
matter got dismissed.
Don't take that file. Let it come. There is no urgency. for that.
Matter got dismissed, my lord, with the liberty to approach the DRT. My lord, I'm not given. Liberty was not sought, my lord. Liberty was sought, my lord, but the extension of time, the limitation, my lord, has not been sought. The limitation period, exemption of limitation period has not been sought, my lord. So, I'm seeking for. I have filed IA, my lord, in the disposed matter.
File?
We
File
have,
IA?
we have filed it, my lord, to get it posted.
How many
My-
times the matters will be listed?
my-
1 day for disposal, 1 day for
My lord.
liberty, 1 day for something
Liberty
else.
was granted at the time of disposal, but time limitation,
When the court has not granted section 14,
My lord, it
consciously
was
not granted.
My lord, it was not. We have not submitted on it, my lord, because before DRT they are not.
But I'm telling, whatever your submissions, it has to be done on the same day, like this repeatedly memos will not allow. Take it on Tuesday. Yes.
In respect of Securitization Act, my lord.
Huh?
Securitization Act and senior counsel from the Delhi is coming on Monday, and office objection is already been complied. It may be posted, and kindly it may be posted on Monday, because he's all.
Office objections are complete, she will look into it, it will come. I will not say it's Monday, Tuesday. Monday already there are 80 matters. I'm not going to
Monday
take
is
up any
coming
matter.
from Delhi. That's why humble request I'm
We
making.
can't take up, yes.
Lords, for being spoken to yesterday, one matter was disposed. Only small facts has to be brought up the notice of this court. Only section 14, your lordship asked me a question whether section 14 notice passed or not. But I had submitted, it is not passed. It was passed. Only that fact has to come on the order. That's
Then
the
why
only-
did you submit?
Lords, there's some 5-6 cases
It's
were
not
there.
fair, Mr. Lokesh. When you are appearing before the court and submitting, you have to be clear on facts. If you are not clear on facts, don't submit anything.
Absolutely, apologize. Lords, only one that
I
fact has-
specifically asked, long back, it can be again filed. Law, everybody knows. You don't have to tell the court what is law. Post it on Tuesday. Yes.
Lordship, list number second, because
Huh?
Home Mahesh is not in the station. Second list may be, that's why.
Times it will be adjourned.
Because he has gone to his.
No, it is not that. Tell him. If insurance company files appeals, 2013, 2014, every time the matter comes, dozen of times he takes adjournment, what will happen to the claimant?
This
Tell
time-
him that if he asks
Yes.
adjournment like this, I will impose exemplary costs and dismiss it.
This
The,
time,
the company has no right to, file the appeals like this and don't argue the matter.
this time
Last
only-
occasion, when the matters came up,
Yes, your lordship.
there were about a dozen matters in the list.
Yes, sir.
All the matters have adjourned.
Yes,
What
sir.
is his request again? If he is not able to do it, let him give no objection.
Because he
And
just
I'll order notice to the company. Today itself, I'll order notice to the
like
company.
that, your- because he has already informed. One time we can opportunity.
What
I will-
one day?
I will inform the same, what your lordship is conveyed me.
I am
will inform
next
the
week,
lordship.
all Mahesh matters will come up next week. I will issue notice to the company saying that company is not pursuing these matters. I'll dismiss it.
Please, your lordship.
2013, 14, there
Correct,
should
your
be
lordship.
some
I
rationale.
do agree with you, lordship, because only this time.
How many
lordship.
matters are there in the list today?
Okay, I know this. That's
How many
why
are there?
the 10 or 12 matters are there. I already seen the list.
Then in
That's
spite of so many matters being
Don't do
listed.
that.
Oh, No, I will not, tell him.
Not like that. your
I will
lordship.
not
For
adjourn.
Today,
I will
only
not.
for
I
today,
will
your
not.
lordship.
Yes, next, I have rejected,
Allah, for-
rejected, yes.
For today, your lordship,
No.
at least,
But
because of
MS
representation.
MSME issue, my lord, I said
Because
before
wife
this
is
one. Today matter
admitted
posted.
to the hospital. That's why she has taken the, otherwise I need not ask anything, your lordship. Simply because of some,
Please understand, he has his own personal difficulties not.
yes, he has to hand it over the other.
Or else you have to make
arrangements
alternative
also.
arrangements.
Correct, your lordship.
And eternally you can't seek time like this. What will happen to the claimant? I can understand it's a claimant's appeal. These are all your appeals.
Our appeals only.
Ah.
That's right.
Then entire proceedings was stayed right from 2013. We are in
Correct.
2026.
Already 10, 12 years already elapsed.
When I dismiss all these appeals, I'll dismiss with exemplary cause. I'm making it very clear.
this time, Your Lordship, because of this reason.
Yes.
Otherwise, he didn't ask.
And the time has not come. Let him come. Let them complete their out of
MSME
term.
matter, my lord, posted today. My lord, it's not got listed in the list. I request, my
What
lord,
is that?
my lord, there are two matters, my lord, MSME issues, my lord, assailed before this honorable court. My lord, this honorable court given an adjournment, my lord, our request made by the petitioner and given us a last chance, my lord, last occasion, my lord, they filed some documents. My lord, the one advocate got deceased. Advocate who filed a petition, my lord, one is, my lord, constitutional validity of, my lord, section 2O, and second one is MSME.
No,
issue.
I posted it after vacation.
Today, no, it's the date is there. I produced the, my lord, day out of the sheet also, both order sheet. Today matter is there.
Why is it not? It is.
Will it have it on?
Scan all the files. The persons are sending those files to the scanning line.
And tell them whatever scanning process, whatever has to be done, it can't be against the judicial orders. They have to do it when the matters are not listed. It will come on Tuesday. Take care.
Both orders also.
Yes, Mr. Musanna.
My lord, this matter was partly regarding KPI Act, my lord. So this may be posted on the next week, one of the days.
What is the urgency?
No, urgency only, my lord, because now property has already been sold. Purchaser, when every day he's coming to the bank, you take.
Next week, court is completely occupied. We can't take up matters which have no urgency. Your matter has no urgency. It will come after vacation. Yes.
It's fresh matter, my lords. I have filed an IA to permit me to cross the witness, but that IA is rejected, my lords.
Fresh matters, it will come. If it is not coming, inform the court officer. She'll find out. We will not give any memo for that. Yes, next. All the list.
This one page adjournment. Page number 2, serial number 4 to 6. Page number 3, 7. Page number 8, 8 to 12, 11. Page number 5, serial number 11, sir.
11. Serial number 11.
Then what about 11.1? You are not the.
I am for the petitioner 11.1. It has been influxed, but however, there's an appeal in the apex court. I request for an accommodation, let it be pending.
My lords, the appeals, whatever the IOC has filed, my lords, the Honorable Chief Justice has asked them to vacate the premises. So
what we do is 11, we will dismiss it as infractions. We'll call 11.1, then I'll record your contentions and then
Yes,
see
my
that.
lord. It may be
11
taken.
dismissed as.
Both may be taken up at the same time, my lord. 11 and 11.1 second.
He wants to withdraw, let him withdraw. What is your difficulty? Memo is filed seeking to withdraw the writ petition, dismissed as withdrawn. Only 11. 11.1 will be called. Yes, next.
Page number 5, serial number 12 to 15.
My lords, serial number 15, my lords. I appear for respondent number 1, my lords. There is some inconvenience, my lords. There is a demise in the family of my senior, my lords. Hence, he is out of station, my lords.
Have you informed the other side?
Please, my lords.
Yes. This is matter after vacation. Look at it if interim order is there, extend at the request of counsel to the respondent. Yes.
Please, great.
Page number 6, serial number 16 to 19, page 7.
My lords, serial number 19, my lords. My objections are ready, my lords. I will file it with the registry.
I am for petitioner.
No further adjournments will be granted.
It was for petitioner, my
No,
lord.
it won't be two, there will not be two orders for both of you. Either of you, if you have to.
It's ready,
no
my lords. I
adjournment,
will
no
file it
adjournment.
with the registry.
We will see.
Tomorrow also. Okay, my lords.
Why you have not filed it when the matter is listed?
My lords, officials were on duty, my lords. They were last week itself. I have sent it. Now they are on the way. They are getting, my lords. Even tomorrow or Monday.
Matter tomorrow.
Interim order extended. Interim order is.
Interim order all granted is extended till then. Yes.
Page number 7, serial number 20 to 26.
My lord, serial number 20, here for the petition.
Serial number
20, my lords.
20.
20. There's some inconvenience, my lords. There's some medical emergency in senior's family, my lords.
Whom you represent?
Prakash Constructions. Advocate Siriyar, my lords.
Have you informed the other side?
Yes, my lords, you have informed the other
This is matter after vacation. At the request of counsel, the petitioner, it is submitted that the same is already informed to the counsel for the respondent. Yes.
There are other dismissal matters. List number 2, page number 1, serial number 2, 3, page number 2, serial number 4, 5, page number 3, 6 to 11.
10, my lord. Serial number 10, my lord. I pray for time because in this case I have to produce the translation copies.
And no further adjournments will be granted. If adjournments are sought, the petition will be dismissed with exemplary costs. This is a MFA of the year 2014. Yes.
Yes, my lord.
Yes. What about 10? What do you want? Mr. Lathur?
Yeah, my lord. Yes, my lord. Translation copies, because the claim petition is dismissed, my lord. I have to produce the translation of the police papers and also the depositions.
I can understand. I can understand without a translation also. Argue.
Yes, ma'am.
Yes, next.
Till number 9 also.
9 also, Mahesh.
Connected matter.
This is also same, at the request of counsel for the respondent. This is matter. The next week, if the respondent seeks adjournment, the writ petition will be allowed. The MFA will be allowed with costs.
Page number 4, serial number 20 to 15,
Yes.
14 and 15.
14. 14 also same order. Appeal will be dismissed with exemplary costs.
15 also. 15.
Yes, 15 also.
Page number 5, serial number 16 to 19.
Number 17, my lord. Lordship, the appellant counsel, my lord, has some in personal inconvenience. May pray for 1 week adjournment.
Ask, counsel is Shivanagoda.
Yes, inform to other side also.
Why, somebody will be there, Pradeep or somebody represents matters.
Some Suguna Reddy, my lord, the appellant counsel in the second matter is some personal inconvenience.
So on her behalf, Shivanagoda is representing, or you are representing on behalf of?
Srimati Suguna Reddy.
This is matter after vacation, don't give the date.
Page number 6, serial number 20.
At the request of learned counsel appearing for the claimant. Yes.
Serial number, page number 6, serial number 20, 21. Page number 7, 22 to 27. Page number 8, 29, 28 to 32.
This in this also 29, 31.
29, 31 and 32.
In all these matters, same order.
Page number 9, serial number 33 to 37.
37.
34.
34, 35.
37.
All these matters of Mr. O. Mahesh shall be listed on next Thursday, on the Wednesday at 2:30. Yes.
Page number 10.
Serial number 37, madam.
37.
7. Praise for applicability.
Why? Why the time has not come for to argue a appeal of 2017?
Other side.
Huh?
Other side information.
Court has objection, not the other side. Why your appeals of 2017 also you are not? Yes.
He has engaged me.
Huh?
He has engaged me, but I am not well.
This is matter after vacation, don't give a date. At the request of counsel for the claimant.
Page number 10, serial number 38 to 40. Page number 11, 41 to 45.
44, my lord.
Yes.
Same advocate, my lord, is some inconvenience.
This also.
Yes.
This matter lists in the month of August. At the request of counsel the petitioner. Counsel for the claimant. Yes.
Page number 12, serial number 46 to 46, 47. Page number 13, all parted matters.
Parted matters don't call. Even dismissal also. Yes, call the list.
List number 1 for orders matter. Serial number 1, Shashikant Prasad, for petitioner.
Lords, memo filed, my lords, undertaking to pay within 180 days, my lord. 180 days, the bank statement which they have produced, that amount with interest will be paid, my
But
lords.
you are denying it all through.
Not denying, my lords, only the personal loan which they want to brought it within.
Yesterday, from the last 2 occasions, what was submitted before the court is, there is no such account, there is no proceedings are initiated, no notice is issued, nothing.
Yes, my lords. That account is totally different.
That is what they said, there are 2 accounts. That was denied.
According to the bank, my lord.
Client was there in the court the other day, he was also denying it that he has 2 accounts. Only
Please, my
one
lord.
account, and they have produced some document unconnected. That's what was the submission.
Yes, my lords. Now,
Then if that is yes, why are you paying the amount? Why will you pay?
that is with regard to the security interest which they have created on my dwelling house, my lords. That we are ready to pay. Other account which they are claiming, that will have lien, my lords, even after paying that amount is concerned. If at all they can convince or show that, my lords, that personal loan of that different account is there, then they will have lien on my house. Now, why they want to add to this, my lords?
What is question before this court?
That is with regard to the account 187, my lords.
No, what is the relief you are seeking in this writ petition?
That vacation notice
Page
which
6,
they have
sir.
issued, my lords. Page 6.
All these issues that the tribunal will decide, go there.
Please, my lords.
Yes.
My lords, within 180 days, we are willing to pay that account.
Not going into all these disputed questions for which account, how many accounts, whether this will have impact on that or not. All this tribunal will decide. Both of you adduce your evidence there.
My lords, the respondent bank admits that, my lords, by producing the bank account, their own statement shows, my lord, what is the amount due. I am ready and willing to pay that, my lords. Please just to grant me 180
And what
days.
if he is admitting? Let's see if he is admitting.
Yes, they have produced that statement account.
Your lordship may kindly take my memo.
Memo dated.
Lordship said, yesterday I filed.
Hmm.
Yesterday, your lordship said, directed me
Yes.
to file the memo. Your lordship could kindly go to page 6, my lord.
Yes.
Page 6. There is, this is the first account, my lord. Your lordship should kindly see in the right side, customer name is also the petitioner's name.
Hmm.
R. Ramachandra. Then, my lord, the balance is 30 lakhs plus, my lord, interest and also penalty. Your lordship may kindly see, my lord, discharge amount with penal on the right hand side, my lord, at the bottom. That is 61 lakhs, my lord. This is one of the accounts. Then, my lord, your lordship may kindly come to the second account, my lord, at page 12, my lord. Sorry, page 13, please.
Yes.
There also, my lord, the account customer name is R. Ramachandra. This is the second account, my lord.
Those 54 lakhs.
No, my lord, this is 5,46,000. So totally, my lord, it is coming up to around 66,60,000. That's
66 lakhs.
60,000.
This you are ready to pay.
My lords, may please to have.
And one more
the
submission,
yesterday
one
that-
more submission, my lord. Next page, if your lordship should kindly see page 14. They had, last time, my lord, they had disputed saying that there's only one account and 13.2 is also issued insofar as one account. Your lordship may kindly see at the top, my lord, account number.
This is for the second account.
No, this for both the accounts. There are two account numbers mentioned.
You are given note.
Combined action we are taking. At the bottom, my lordship may kindly see signature is also there. We have personally served it on them. They can't dispute it. And what they have challenged here is, my lord, vacation notice. 2 years they have enjoyed the interim order by depositing 7 lakhs. Your lordship may relegate them, my lord, to all liberties.
My lords may please to have page number 5 of their documents which they have produced. In that page number 5, the closing amount is 30,75,000. That we have filed a memo, my lords, undertaking to pay that amount with interest.
They don't want to pay interest is what.
You can't pay what you want to pay.
No, my lords, their own account statement, my lords.
Yes, go. We can't
Please, my
decide
lords,
all.
page number 5. Page number 5.
Please.
30 lakhs, right hand corner, my
Whatever it
lords.
is, whatever it is.
My
Go
lords,
to tribunal.
he is a senior citizen, my lord, 64 years, only house available, my lords. And I am ready and willing to pay that amounts, my lords.
Why are you not understanding? I can't direct the amount which you are willing to pay. According to them, they have issued the 13 notice and all proceedings in respect of 2 accounts. And in respect of 2 accounts, it's coming to 66 lakhs. If you are ready to pay
Yes,
that,
ma'am.
I'll pass orders.
My lords, one submission, my lords. That 3 lakh amount which they are raising as a personal loan, SARFAESI Act is not applicable for that.
That
My
will
lords.
be decided by the DRT. That I'm not going to decide that.
Please, my lords. And their document number 1 shows 30,75,000. Their own statement, my lords. I am willing to pay. And the disputed amount which is there.
Coming
No,
to
no, it's
penal
not in dispute.
amount is coming to 60 lakhs, not 30.
There is no dispute with
Please, my
respect to
lords.
the amount, my lord. I have produced the
My
closure
lords,
balance
The
also.
amount is coming.
They are trying to
with all
interpret, my
limits.
Yes, my lords. One submission, my lords, page number 5, the closing date may be looked into, my lords. 15/12/2025. The document which they are referring at page number 13 is prior to that. The total amount which they are showing is not as on this date. The account shows, my lord, as on 25 is 30 lakh 75. How they can
Lord,
dispute their
yeah.
own document, my lords?
No. what do you
61
say-
lakh is prior to that.
What do you say about the document which says 60 lakhs?
60 lakhs is prior to the account statement which they have produced. It shows
According to you, after that, the amount will reduce.
that we have paid
How
20
much you
lakhs
have paid?
odd has
No,
been
no.
paid.
My lord, they didn't, in fact, my lord,
please
they have
come.
not even.
The
My lord,
present
180 days, if my lord pleases to, he is a senior citizen, my lord.
So even for a senior citizen, law is the same.
I'm ready to pay, my lord.
If you're ready to pay 66 lakhs, then I will.
Then why they are not producing that statement, my lord, 66 lakhs?
Present writ petition is filed. Questioning the following prayer. It is a contention of the petitioner as petitioner has to pay an amount of, as per the statement given by them. The petitioner has to pay only 30 lakhs and odd
30 lakh 75,000.
and he is ready to pay the same within 180 days. Then counsel appearing for the respondent bank submits that the petition is having two accounts. The surface proceedings are initiated and the notices are issued under section 13(2) in respect of both the accounts. According to the respondent bank, the outstanding is 66 lakhs
My
60,000.
lords, one interference, my
The
lords.
same is disputed by the learned counsel for the petitioner.
My lords, 5 lakh, according to them, personal loan is 5 lakh 46,000. That is at page 13. If 30 lakhs plus 5 lakhs, how it would be 61 lakhs, my lords?
The petitioner has disputed the same, submits that it is only 30 lakhs and the petitioner is a senior citizen. And if the writ petition is allowed, unless the writ petition is allowed by setting aside this notice, that would cause a lot of prejudice to the petitioner. The discrepancies in the accounts and these disputed questions of fact, this court cannot decide. This court wanted to dispose of the writ petition provided the petitioner is ready to pay the amount. Now there is a dispute about whether the amount is 30 lakhs or 60 lakhs or whether the surface proceedings or maintainable can be initiated against the other loan. All these questions, the DRT will be in a better position to decide where the parties are will be able to produce the evidence before the DRT. In that view of the matter, this court has passed the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Petitioner shall have the benefit of section 14 of the Limitation Act. But an interim order is operating from
Lord, February 2024.
From February 2024, the petitioner shall have the benefit of the interim order for a period of 4 weeks.
My lords,
They do not.
lords, vacation, my lords,
Sir,
40
shall,
days, 40 dot, my,
approach the DRT within 30 days. Yes.
40 days if my lord pleases. My lord. 40 days to approach liberty for approaching
Within
before
40
the
days, they shall approach.
Obliged.
Yes, sir,
Lord.
till such time, there shall be the interim order or granted shall operate. Yes.
Lord, if they do not file, then my lord, we may be permitted.
40. When I said 40, it is 40.
Please.
There is no, if
And
not.
the connected matter is also similar, my lord.
What about this?
There also vacation notice is challenged.
Both the matters.
First matter, we gave vacation notice, it was stayed. Again, one more, my lord.
Common law.
Both, my lord.
Much obliged.
Cell number 2, M.A. Rajendra.
I am before a lordship,
What is question?
the challenging the order passed by the DRT. No doubt the alternative remedy is available at the DR 80 under section 18 of the Act. Here question is page number 56 of the order, my lord. Page number 56 of my petition.
To
wherein
set aside the sale certificate in favor of respondent number 2.
accordingly, IA number 849,
To quash the,
fund on the delay.
let's go to that, 155, say one, that order, page number.
155. Page number 56. Operative portion of the order.
What is the delay?
Delay is the delay application we are supposed to file in this along with this petition, my
So
lord.
any of this has to go
DR 18.
No,
Not DRAT, the connected matter with regard to the delay. That's a question of law.
yes.
This matter, the petition is before this court, questioning the order of the tribunal, where the tribunal has dismissed the application to condone the delay in filing the essay. This issue where there are two divergent opinions of the two division benches of this court, the matter is referred to the full bench. The matter is referred to the bill of full bench list along with those numbers you have. Yes. There are there. Yesterday we have mentioned it to keep it with you, that number. Yes.
Cell number 3,
Obliged.
Mahadev Shetty. Cell number 3, Mahadev Shetty.
Appear on behalf of the
Petitioner.
petitioner's counsel, my lords. May I seek for a pass over? my lords?
No. No passwords. Every day, this won't happen like this. I will call this matter at 11:45. By the time whoever is
I'll inform the
representing
counsel.
should be here, or else I'll pass orders.
I'll inform the counsel.
Yes. Not 11:45, call this matter. Yes.
Cell number 4 for the hearing on the interrupted application.
Appearing for the petitioner, my lordship.
Appear for the second.
My lordship is a petition challenging by the insurer, my lordship, on the ground of my lordship, interest on part of the.
Yes, that is not, the insurance company is not liable under the Workman Compensation Act. It is for the owner to.
My lords, in this matter, copy, like after the
I'll
disposal.
serve the copy, my lordship.
Please.
But issue is simple. Instead of coming it again, it is settled law that the insurance company is not liable to pay.
Please.
That is the owner who has to pay.
Because there was an insurance policy which was at the time of the incident.
It is to Workman Compensation Act.
Please, ma'am.
Interest they are not liable to pay.
Please, please. I'll
It's
just look,
simple. Where is that?
I'll just look into it.
I have a copy of the insurance policy, my lordship.
Take that. An order was passed on 23rd September 2022, whereby the appeal filed with the claimant was allowed. Directing the insurance company to pay the claimant a sum of rupees 1,84,170 to gather in the interest at 12% per annum from the expiry of 1 month from the date of the accident, and allowed the appeal. The insurance company has filed the present review petition stating that the insurance company is not liable to pay the interest. It is stated that Exhibit R2, the insurance policy, clearly mentions that liability of interest is not covered under the policy, and an order imposing interest component on the insurer is an error apparent on the face of the order. The counsel appearing for the respondent claimant submits that the court had rightly considered and granted the compensation with interest. As on the date of the accident, the insurance policy is in operation. Expire. Having heard the counsel, this court has perused the policy. As per the same, for which one you're relying on?
Endorsement of the bottom of the.
The endorsement in the policy shows that the cover provided under the policy shall not extend to indemnify the insured in respect of any interest and/or penalty which may be imposed on him on account of their failure to comply with the requirement laid down. Owner of the vehicle has contested this matter.
I need to verify. Yes, my lordship.
Who was the advocate for the owner of the vehicle?
For claimant, my lordship, Vinod Gowda, and owner of the vehicle is AC Balaraj, my lordship.
You are for the owner of the vehicle.
I appeal for the land owner. Does it matter?
That's what owner,
Please,
whoever,
please.
owner.
Employer.
Owner.
Claimant who appeared?
Vinod Gowda, my lordship. Advocate.
His name is also there?
Yes, my lordship. Yeah, on this, my lord, today is
Print
not
his name
mentioned.
also, print the name of, in his presence, we'll do tomorrow.
Yes,
Print the name of Mr. So-and-so, let's just matter tomorrow. It's a simple matter,
Please,
no question of law.
please.
Yes.
Chair number 5.
Oblige, my lordship.
Write the name and give. It's there. Yes.
Applying for petitioner in this.
Respondent number 3.
Yes.
I have filed also.
As I just
Filed an application for stay of the, which is granted.
Have
for
filed
this
application for vacating of interim order.
interim order. I
Who is for the petition? Who is for
In
the?
this, I am for petitioner.
I am for respondent number 3.
I am for petitioner, have challenged the annexure. Yes, my lord, there is an impugned order passed by the appellate tribunal under Senior Citizen Act, my lord.
Come to the cause title.
My lord, the respondent number 3,
So come to the cause title.
please.
You are?
Respondent number 3, I am the daughter of respondent number 3, my lord.
You are aged about 64 years.
Yes, my lord.
Your daughter of respondent number 3.
3.
Uh,
And other respondent number 4 to 8 are other children, my lord.
4 to 8 are other children.
Yes.
Hmm.
Respondent number 3 executed gift in my favor in respect of 2 dry lands, my lord, during 2012, my lord. And subsequently, daughters filed partition suit against brothers as well as respondent number 3 for partition in respect of other properties, including garden
Who has
land.
filed out of these respondents?
The appellant,
Who
Gangamma.
filed the suits for partition?
Yes. And another daughter, my lord,
Respondent number?
respondent number 6, my lord.
Hmm. Hmm.
Just a minute, I clarify my lord. Sorry, my lord, respondent number 6, Savitrama, yes, as well as respondent number 7, my lord, 3 sisters. Then subsequently, the application filed by the respondent number 3 before the tribunal assistant commissioner, contending that, my lord, the gift deed was procured.
You said will.
Gift.
No, you said the will is
Gift,
executed.
I told gift only.
Gift deed is executed when? What is the date?
That is 4/7/2012, my lord.
4/7/2012.
Yes,
When
as
is
per
the-
annexure
when
A,
is-
my lord.
When is the application before the?
It is gift for love and affection, my lord. It is been clearly stated in gift.
When is the application before the assistant commissioner?
Then subsequently filed, my lord, that
Date, year you can tell.
that is 2019, my lord, they filed.
What
During
did she- what did- What
2019.
did she say?
In that before tribunal, my lord, the specific contention by the respondent number 3 that the gift deed was procured playing fraud and under undue influence and misrepresentation. Then ultimately the application decided by the assistant commissioner and the order came to be passed, directing all the children except the respondent number 4 to pay 2,000 each to respondent number 3, my lord, totally amounting to 10,000. We did not challenge the order passed by the assistant commissioner. Then they preferred appeal.
Who preferred appeal?
The respondent number 3 preferred appeal.
What exactly she wanted? She wanted the gift deed to be cancelled and the maintenance to be
In
granted.
appeal, my lord, the deputy commissioner has cancelled the gift.
Which was not done by the primary authority.
Yes, my lord. That is the appellate authority. The so far as this aspect is concerned, then the first time it is at the instant of respondent number 4, my lord, this brother. Once partition suit is filed,
The order of the appellate authority straight
Yes.
away.
in Kannada, my lord, that's
Yes, what he says. Please come to that.
Page 130, my lord, operative portion. ಮಕ್ಕಳು ಅಥವಾ ಸಂಬಂಧಿಕರು ತಮ್ಮ ಹೆತ್ತವರು ಅಥವಾ ಹಿರಿಯ ನಾಗರಿಕರು ಸ್ಥಿರ ಅಥವಾ ಚರಾಸ್ತಿ ಪಿತ್ರಾರ್ಜಿತ ಮತ್ತು ಸ್ವರ್ಜಿತ ಆಸ್ತಿಗಳನ್ನು ಉಡುಗೊರೆ ಅಥವಾ ಇನ್ಯಾವುದೇ ರೂಪದಲ್ಲಿ ಪಡೆದುಕೊಂಡಲ್ಲಿ ಹಿರಿಯರ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ಹಾಗೂ ದೈಹಿಕ ಅವಶ್ಯಕತೆಗಳನ್ನು ಆಶ್ರಯ, ಬಟ್ಟೆ, ಆಹಾರ, ಔಷಧಿ
What was the reasoning
that
given by-
indicates that, my lord, it is the moral responsibility of children to look after the aged parents if they receive property from the parents. That is what the finding given by the Deputy Commissioner, and gift it came to be cancelled. Here, my lord, I would like to canvass the arguments on 2 points, my lord. Lordship kindly kind attention regarding section 23 of.
So all those past several orders on that. What do you say?
Yes. And one more submission, my lord. So far as allegation of fraud and undue influence is concerned, it will not come within the purview of the tribunal, my lord. That is settled law, my lord.
Yes.
The registered gift deed dated 4/7/2012 was obtained by the writ petitioner from the respondent number 3, that is his mother. She is aged about 81 years. Now she is also present before this honorable court. Subsequently, Your Honor, partition deed was effected on 5/7/2012 between respondent number 3, respondent number 4, and respondent number 8. Subsequently, Your Honor, the present appellant, writ petitioner, filed a partition suit before the first additional.
No, that he has already stated. All
Yes.
those facts are over.
Yes, Your Honor.
Yes.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, as per the stay, Your Honor, before granting stay, this honorable court directed the writ petitioner and others to pay monthly maintenance of 2,000, that is 4 lakh has to be deposited. Out of 4 lakh, 1 lakh DD is sent to Rangama, that is respondent number 3, and 3 lakhs is deposited before this honorable court. As on today, Your Honor, they are in arrears of 4,60,000.
They're not paying that. They're not
My
paying
lord, as
maintenance
per
to
the
your
order
wife,
passed by
to
this.
her mother.
As per the order, we
maintenance
have already
council-
paid 4 lakh, my lord. We undertake to pay the balance amount, my lord, but if you go there to pay, they are not accepting, my lord. I have produced several annexure also. When we send check also, they are not receiving.
Then do the transfer to her account.
I am ready to undertake to pay the balance amount.
Do you appear for everyone or you appear for only one?
I will pay on behalf of all other sisters also, my lord.
Monthly
I will collect it
maintenance
from them.
ಕಳಿಸ್ಲೇಬೇಕು.
Then we'll do one thing. Whatever is directed to be paid, you pay to come back, then we'll pass orders tomorrow.
Further, Your Honor, ಇದರಲ್ಲಿ we have seek for cancellation of the gift deed, not for maintenance.
That we will decide on the merits of it. There is law on that.
Yes.
Tomorrow, in this sense, I can draw DD for that. Monday, my lord. Monday.
Yes, list this matter on Monday. Get the DD for the entire amount.
Please.
Cell number 6,
Okay, for petitioner.
Devi Amarnathan.
If you have done Monday, the petitioner is in Australia, is coming on Sunday to settle this matter. There are one figure they mention as 2 crores 65 lakhs. My lordship directed them to give the statement. There they say 1 crore 76
Plus
lakhs.
everything
There
has
is
been,
a-
he has
Well,
contested
wait,
the
wait.
OA. There is a decree in
OA
OA.
judgment, 1 crore 58 lakhs is mentioning, 1 crore we have paid it, that is not the example. It amounts to 57 lakhs rupees only the due. He is coming on Sunday.
You are enjoying the interim order from the last 2 years. It is enough.
Melody.
Come on.
I am
will
for
take
settle-
up on
I am for
Tu-
money
I will
settle-
take up on Tuesday. If there is a settlement,
Yes.
settlement. If it
Yes.
is not, I
Yes,
will
yes.
dispose of this petition, go before the DRT and
Yes, yes.
settle your.
It was argued, Malot, the coordinate bench went to dismiss it, then it was referred to.
Tuesday, it will come. This is matter on Tuesday. On that day, if there is no scope for settlement, the writ petition will be disposed of by relegating the parties to the DRT. Yes.
Because it is an order passed by the, final order passed by the DRT. They'll have to go to DRT.
Yes, they will decide
make-
it.
I
What
will
is
make
the
message.
validity of that order? The matter will be decided on that day. We'll decide it. Why to send them DRT now? Yes.
Serial number 7.
I pay for the
Ramya
petitioner, my lord, in 7.2. Would your lordships kindly
Yes.
take this up at 2:30, my lord? Last time your lordships had directed that it be taken up at 2:30. It's not come in the order. This
But
that
today
matter.
there are MSME matters are listed. We'll have it after vacation. Look at it if interim order is there extend. After
Very
vacation.
well. If interim order can be extended, my lord.
Wherever there is, it will be extended.
My lords, if a date could be fixed. My lords, a date could be
List the
fixed.
matter on 10th of June.
Great.
Yes, next.
It was extended on 8th, Minutes. It was extended on 8th in this matter. The interim orders were extended. Your lordships have said so. Maybe it has missed in the order sheet. I've rechecked the video.
Look at it if before the date
It is on
there
8th,
extended.
Minutes. It has been extended.
Yes.
And we moved it for that purpose day before yesterday. Your lordships
Yes,
posted
yes,
it
yes.
today for
Next.
this purpose.
Serial number 8.
For respondent matters.
Bharat Kumar Shetty.
Account has been closed.
Memo is filed.
And
You
for
find a memo? No? Land counsel, no representation on behalf of the petitioner. Land counsel appearing for the respondent submits that the entire amount is paid and the loan is closed. Accordingly, petition is dismissed as, the said submission is taken on record, dismissed as infructuous. Yes.
Number 9. Kalyanath.
I picked up for the respondent number 3 minutes. I have already filed my statement.
Lord, the respondent has filed statement of objections. I want to file, my lord, counter to that. 1 week time.
This is matter after vacation.
Lord, the date may kindly.
The petitioner wants to file his rejoinder to the, it's submitted that the objections were filed and he wants to get instructions and file the joinder. List this matter after vacation.
Lord, the date are, please,
List this matter on 16th of June.
please, read.
Grateful.
Serial number 10. Rajendra MA.
Yes,
Here also, the DRT order
limitation.
on limitation.
Yes, Mr. Vignesh Shetty.
Limitation, my lord, I point. One,
It's not only, my lord, there are two petitions.
Hmm.
My lord, writ petition number 20936 of 2023 and my lord, writ petition number 23799 of 2023. There are two different orders passed by the DRT as held before this honorable court.
What is the first one? 20936.
My lord,
20936,
my lord
my lord,
permits, my
I
lord, I'll
directly
take
take the page
23799 of, it is the first
First,
order
let us
passed by
see
the
that
DRT.
is there with me, that order.
Please, ma'am.
Page number 61 of the operative.
Petition to condone the delay stands dismissed.
Yes.
So this will go along with that.
No,
No,
your
that
lordship.
is different order that I'll point out, my lord, this, it is not passed on delay. It is in respect of 23799 of 2023, my lord, it is passed on merits, not on delay.
But ultimately it says the delay petition is.
No, in respect of 20936 only on the delay.
That's what 20936 I'm saying.
Yes.
The same, like
No,
in the
but-
other.
No, one submission, I may permit, my lord, only one submission. This delay is occurred during the COVID period. Page number 76 of the COVID. The circular issued by the Honorable High Court of Karnataka, Supreme Court of India, and the government
In
notification.
that case.
When
we
such
have
being
to
the
allow
case,
petition.
I'll just point out because
No, when
the
such
set
being
of
the
facts are
case,
different here.
when such being the case, at page number 61, DRT is a creature of statute.
When is the order passed?
Yes, my lord.
When is the order passed in this?
9/5/2023, Annexure A.
9/5/2023. When is the IA filed?
9/5.
IA filed on 7/12/2021.
2021.
One.
That limitation is there till 2022.
I agree. I go down. I'm not on that.
No, if that's the case, whether this petition, there is a question of delay in this.
I
There is no delay.
Delay.
We'll set aside this order and send it back to the DRT to hear it.
I'll only, my lord, I board on, my lord, what my lords, my lord, because that COVID notification is there up to 2022 and before that, my lord, this honorable DRT passed an order. Here, my lord, the small issue is the petitioner, my lord, before going before the DRT, they've gone before the, my lord, honorable High Court of, my lord, Kalburgi. That one order I'll just point out.
Where is
My lord, that is at page number 86, Annexure E.
that? Yes. Then why one matter will go to Kalburgi, one matter will come to Higher
That I don't know, my lord. In fact, that's the same question my lord asked.
Your lordship, on earlier occasion also, whenever the matter was referred from the Kalburgi, Dharwad, we approached the DRT. The DRT passed the order. Against that order, several times we have approached Bangalore division.
But I have
Bangalore.
dismissed it.
But this question your lordship has asked, but on several occasions, The order has been passed.
Then if that's
That
the
is
case,
separate issue.
there should be a consistent view.
Yes, here in
For
the
this
question.
court, it is not maintainable, I'll dismiss it on the ground.
No, no, your lordship, because on the government notification is there, Supreme Court of India.
That will be decided before Kalburgi. You would have gone before Kalburgi bench. Why did you come here?
But on earlier occasion also in several
Not earlier
cases.
occasion. You go before the Kalburgi bench. Kalburgi bench gives you the liberty to go to DRT. You will go to DRT because, so according to you, if you go to DRT, you will file appeal in Madras High Court.
No, we can, DRT order can be a challenge before division bench of Chennai also.
Yes, yes.
Here, your lordship, if you are remaining.
Page number, my lord, 89.
If your lordship, both the cases, because it's a factory land and building, it's a primary security, that one more case is collateral security. No doubt, it is passed on merits.
All the properties, everything is situated within the jurisdiction of the Kalburgi High Court.
Yes.
Let the bench, let it go to Kalburgi, not here. We will not hear. This kind of, the practice will not allow. The present writ petition is filed, agreed with the orders passed with the DRT, dated 9th May 2023. Initially, petitioner has filed WP number 200977 of 2021. And that came to be disposed of by the Kalburgi bench on 4th October 2021, wherein the court has observed that it is open to the petitioners to challenge the auction and other collateral proceedings before the competent court. All contentions are left open for the petitioner to urge before the court having jurisdiction. If an appeal is filed before the competent court, the time consumed in proceeding the writ petition shall be set off while calculating the limitation. The property is situated, the bank, the property, the petitioner, all of them are within the jurisdiction of the Kalburgi bench of the Karnataka High Court. And already having approached the court, just because the DRT is in Bangalore, the petitioner cannot come before this court by filing the instant writ petition. Even on the earlier occasion also, this court has dismissed the writ petition which is filed in this manner. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to petitioner to approach the Kalburgi bench, the Kalburgi bench, and the petitioner shall have the benefit of section 14 of the limitation act.
Same connected matter.
The connected matter, my lord, there is no, my lord, it's not on delay. The order passed by the Honorable DRT at my lord, page number 26.
This is also same Kalburgi bench.
Kalburgi bench.
The issue is the same. Yes,
It is the same.
Yes.
It is a factory land and building, it's a collateral security.
Grateful.
11, still number 11.
11.1, I think, to be called.
Not in this case. I had filed for an eviction of the petrol bunk. Subsequent to the eviction, PESO has issued a notice to stop the running of the petrol bunk. Not the petitioners filed criminal appeal before the High Court. Not in the criminal appeal, the court directs them to hand over possession. They suppress that order of the criminal commercial appeal, and they obtain a stay over here, saying that we have preferred a commercial appeal against the judgment and decree of the trial court. So PESCO cannot cancel our license. And accordingly, an interim order is granted. Lord, that order is not maintainable at all for the reason we have now taken possession of the property through execution, subsequent to the order of the commercial appeal court order. Now we are in possession of the property. So there's nothing that survives for them to
Let's
get
see
a
what is
license.
the case that is sought before this court.
I'm not a party in this case, my lord. I was made a party in the subsequent case. They have withdrawn that.
The other one.
Here I will impede myself. And the only thing that.
Issue a writ or so and so, quashing the letter and order dated issued by
Yeah, order.
respondent number 3 in suspending the license of the petitioner. To not to take any precipitative action will hinder the operation and running of the petrol. Now, as far as prayer B is concerned, the position is already taken. It doesn't survive for consideration. Now come to this letter dated 1/12/2025.
Then annexure H, page number 77.
Page number?
77.
What did they say? Show cause notice was issued in compliance with the order of the High Court under reference 1.
It gives reference to the suit
No
that was
concrete
filed.
proposal was submitted in your defense. You are requested to show cause as to why. It's a show cause notice.
they've also cancelled our.
No, what is question now?
The same order in which they have
It's the
withdrawn.
same.
Your Honor.
Please.
One was filed by the dealer and one was filed by the agency.
Issued by the letter and order dated issued by respondent number 3 as per Annexure H is a show cause notice.
They challenged that and obtained a stay, my lord.
How can you come, you can question a show cause notice? You are hereby requested to show cause. How can there be a stay on this?
And they have suppressed the High Court's order, my lord. Problem is, they say commercial appeal we have filed, but they don't tell in the commercial appeal subsequently, the court says take position. That aspect is suppressed.
No, I'll say that we can't entertain this with
my lord,
petition if they
why-
want.
One submission, Your Lordship. However, in the commercial appeal, there was another IA that was filed.
No,
to
forget
ex-
about the commercial appeal. No, your question is show cause notice. You cannot question
I
show
was,
cause notice.
the previous show cause notices that was sent, I've also given a reply stating that there was some talk regarding extension of the lease.
High Court, as per the High Court order, they have issued a show cause notice. Again, you come here. Are you not supposed to respond to that?
As per the, Your Lordship, not as per the High Court.
Get it? Reference order of the honorable so
Order
and
of-
so, or whatever, commercial court.
Commercial court,
In
yes.
respect of OS number, the office
That-
complaints of so and so.
That is regarding the eviction suit. However, this writ petition being in pendency won't affect any, won't cause any prejudice, Your
First
Lordship.
of all,
This is
we
only-
shouldn't entertain these kind of writ petitions.
This is only not
No, no,
on
no.
regard
Show
any
cause notice, you
rights.
cannot come before the court. Whatever you want to submit to them, let them do what they want.
One request that I would like to make is, my lord, they moved the court hall number 1 just about 3 days back. There they seek that petrol, diesel and gas is there and they want to take use that petrol. The court has rejected saying that you can't get back into position. Lord, if they want, they can pump out all the petrol, diesel and gas.
And let us not extend the scope of this writ petition. What they have
So that
asked
they can
is.
give me an undertaking.
No.
I have taken, obtained the
We will
decree.
not, I'll not pass any order which is not part of this writ petition. Show cause notice can't be questioned. And the secondarily, it's already they have taken possession. That also, when once the relief of prayer number 1 doesn't survive a consideration, no other. The present writ petition is
Can I
fine.
make one submission, indulgence, Your Lordship? However, in that one submission, in the commercial appeal, the IA that was filed is again questioned in the apex court. However, if it is kept pending till there.
No, nothing. Whatever you want to do with this. You can't question a show cause notice and on that the writ petition cannot be kept pending. The writ petition is filed. Sing the following prayer. It is the case of the petitioner that the petitioner entered the registered lease deed dated 5/3/2024 in respect of the scheduled property with the respondents for a period of 20 years, which is valid till 4/3/2024.
Your Lordship.
It is stated.
In page number 78, my license has been suspended.
Where is that?
Page number 78, Your Lordship.
But what is questioned is only Annexure H.
I've 78, I've made it a part of Annexure H, that is the show cause notice as well as the order that is also given in page number 78. There's an order that says that 78, page number 78.
But that you are not questioned there, 78.
I made that as an annexure, that is Annexure H itself. It forms the part of Annexure H.
That was questioned in another writ petition which they have withdrawn today morning. It was being told that they have withdrawn that writ petition. That was Annexure A which was questioned in that particular. When they themselves
So
have
the
withdrawn,
proper confront of
that is the
so
order
and so.
dated, the
The
suspension
license
order is
number
dated
in the form of so and so.
1/12/2025, Your Honor. You're referring to that?
District is hereby suspended as an interim measure with immediate effect till 1/3/2026. It's only till 1/3/2026. That is also over.
That's also over. That was the one
My
which they
only
had
apprehension is, in case if my application gets allowed and I'm put back to position in any way,
got
again,
rejected.
I'll have to again challenge the same and come
No,
because my best.
it is an interim measure. That's still 1/3/2026. You keep quiet without even responding to the show cause notice.
Now,
And even that period is over. Now, as of now, it is like a writ petition has become infructuous.
In fact, the previous bench had suggested them to reply to that also, Your Honor. They have kept quiet, as your lordship rightly pointed out.
The
Liberty was given to them to continue replying.
Did you write?
ಹೇಳಿದ್ರು. Dependency ಇದ್ರೆ reply ಕೊಡಿ, we will consider it.
It is a case of the petitioner that the petitioner, that the respondent corporation, no petition, what is this petition corporation?
It's an Indian Oil Corporation.
The petitioner corporation is opening a site retail outlet of Indian Oil Corporation Limited to its dealer under the name and style of Mrs. Garden City Service Station, which is commissioned on 12/11/2004 on the scheduled property. It is stated that the petitioner is in possession of the property by virtue of the registered lease deed executed on 5/3/2004. Dealership agreement has been carrying out the operation of the retail outlet for the past 2 decades by installing several valuable machines, equipment and fixtures of the petitioner's corporation in the scheduled property. The petitioner, in pursuance of clause 9 of the lease deed, which provides for renewal of the lease period, issued a letter dated 6/9/2023 requesting landowners to renew the lease well in time, that is 3 months before the expiry of the lease. Furthermore, petition number 5 and 6 have acknowledged the receipt of the said letter and gave their reply dated 9/9/2023. After several rounds of litigation between the petitioner and the landowner instituted a mediation proceedings in PIM number 1513 of 2024, which also failed. Consequently, landowners filed a commercial suit, that is COM OS number 1503 of 2024. Before the Commercial Court Bangalore, seeking a direction against the petitioner to quit and deliver vacant physical portion. The petitioner is contesting the said suit. Has contested the said suit. The learned judge, after hearing both the oral and documentary evidence of both the parties, by judgment and decree dated 10/9/2025, allowed the suit filed with the landowners in part, thereby directing the petitioner to quit and deliver vacant physical portion and hand over the vacant portion of the scheduled premises to landowners, and also directed to pay damages of a sum of rupees 1,25,053 per month from 8/4/2024 to landowners for unlawful occupation of the property till vacating the property, and further dismiss the counterclaim filed by the defendant with exemplary cause. The petitioners carried the same in appeal before this court in COM AP number 591 of 2025. What happened in that commercial appeal?
21/11/2025, they were directed to hand over possession.
The court, by order dated 21/11/2025, to hand over the premises to the, in spite of stating all these orders, they have stayed in this.
They suppressed this order, asking me to take over possession. That
hand over the premises to the respondents. And the said appeal is pending consideration. Before, what is this again? COM AP number 597. Once they say it is 591.
We have filed for enhancement of
the landowners have filed the COM AP number, commercial appeal number 597 of 2025 before this court by the landowners, which is pending consideration.
We have taken possession through execution.
The respondent, it is stated that the respondent number 3, by letter dated 14/10/2025, issued a show cause notice to the petitioner for suspension of the PESO license on the basis of the judgment and decree dated 10/9/2025. The petitioner replied to the said letter by reply letter dated 31/10/2025, wherein the petitioner informed about the appeal pending before the High Court. Also informed about the renewal clause of 5 years in the lease deed. It is stated that the respondent number 2, without considering the reply of the petitioner dated 1/12/2025, suspended the license of the retail outlet running on the scheduled property with immediate effect. Hence, the petition is agreed with the order dated 1/12/2025 issued by the respondent number 3, and he has come before this court questioning the same. Then counsel appearing for the petitioner submits that. What is pending before the Supreme Court against your appeal?
I don't have the number of it. I will.
They file an appeal.
Excuse me, Lord, because I've taken position. What survey is
It is submitted that their appeal is pending before the Honorable Apex Court. And what about, and what else is pending?
Nothing else. Just to appeal.
The appeal is pending before the Honorable Apex Court till the said appeal is decided. Appeal is decided, this petition may be kept pending. It is submitted that once the appeal is decided, the rights will be crystallized. Then the order can be passed in this writ petition. Then counsel appearing for the respondent submits that the possession was already taken by the landowners.
on 12/3/2026.
12/3?
12/3/2026.
12/3/2025.
26.
26. The possession is already taken by the landowners.
Execution
And
1/4.
their appeal in execution petition.
In execution. 1/4.
In the execution
1/405.
petition, it is submitted that the appeal filed by the landowners for enhancement of the compensation is pending consideration before this court. The prayers that are sought in the writ petition is questioning the show cause notice and also the suspension of the license till, what is the date?
1/3/26. 1/3/2026.
1/3/2026. It is submitted that the writ petition has become infructuous as, and the other prayer is not to take any the coercive steps. Already the possession is taken by the landowner. Even the period of the suspension of license is also over. And the petitioner has not submitted his reply to the show cause notice. It is submitted that on all these counts, the writ petition has to be dismissed. Next, having other counsels on either side, there's a material on record. There is an repeated fact that the landowners have succeeded in the suit, in the commercial suit, and in the execution proceedings, the property is already delivered to the landowner. And as far as the proceedings initiated with the respondents with regard to the suspension of the license is concerned, that is also till 1/3/2026, and even that period, the temporary suspension period, is also completed. The petitioner so far has not given the reply to the court notice dated 1/12/2025. We'll give them the liberty. The petitioner is at liberty to give his reply to the show cause notice dated 1/12/2025.
Property is not with them. The property is not with them, even if they reply.
That's whatever you
And
want to
also
do.
to give my reply, the show cause was given on the same date and order was passed on the same date. Where does
The petitioner,
aspect
if at
of
all, if they fall, any cause of action survives for the petitioner can give a reply to the respondent, and the respondent can consider the same in accordance with law. Accordingly, the petition is disposed of.
Got one submission. Name of Mr. Shanti Bhushan to be deleted and my name to be continued.
Delete the name of Mr. Shanti Bhushan for R3. You are
R1 to
the
3.
shoot for R1 to R.
R1 to R. In both the writ petitions, one which is withdrawn and one with
In the withdrawn writ petition also, morning it is withdrawn. In that also,
CGSPC.
no, in that matter, your name is
EGSPC.
there and Shanti Bhushan's name is not there in that.
In the one which is withdrawn, Shanti
Yes,
Bhushan's
it's not
name
there.
is not there.
In this only it will,
Yes, ma'am.
only in this.
one contention of mine that the show cause notice and the order was passed on the same
And
day?
then in counsel for the petitioner submitted that, the show cause notice, because it's an interim, that can be done. He submitted that the suspension of the license and the show cause notice are done on the very same day, which is not permissible.
It is also stated in the notice, also suspension notice as an interim measure only, Your Lordship.
I just wanted it to be recorded. I said so, yes. Yes.
Till number 12.
Okay, for the petitioner. Well, in this case, the scheduled property, which was by will, father has gifted it to mother. Thereafter, after the death of mother, it will come to the petitioner. But mother is still alive. There is a partition suit pending by the other co-owners in 2019. There is an order not to create any charge or alienate. In the meantime, petitioner's friend, who is a borrower, he said he wanted a guarantor. He said, I am not yet a owner. I have to get the ownership after the death of my mother. But still the bank has taken his guarantee. and other co-owners are pending before the civil court. My lord, they want to action this property where other co-owners are there and the matter is pending.
How are you? Why did you give
That's
a
what-
property as
That's
a?
what the manager played. The bank advocate has given advice not to take this property, but the manager has played fraud, taken an advice by the other third party.
kind
No,
of
no, that
content-
I mentioned.
No, it's not about mentioning. How can you make these kind of submissions? Are they
Because-
legally
That the
tenable?
bank has to verify whether the property belongs to the
That they
petitioner.
will see, that they will.
That they're not done. That they're not done.
If they can't, they can't.
My last DRT order, my last kindly see the DRT
Yes.
order. DRT order. page
You
number-
say, no, it is like this. You say, I will give the property as a guarantee where I am not a owner of the property. Now, when if other co-owners are aggrieved by it, they will come. You are the person who has given the property as a security. Why are you coming?
No, because, my lord,
You
there is an
can't, you can't blow hot and cold at the same
No,
time.
no. The auction is of the entire scheduled property where on my guarantee they are taking it. That's why I'm telling my share because my lordship had turned to page number 27.
That is what, it is not for you. It is for your other co-owners who will come and file a petition. You can't file.
My lord, they are before the civil court matter is pending before civil
They are
court.
not aggrieved.
The
Why are you aggrieved?
The bank is also made a party now. The matter is going on before the civil court. My lord, turn to the.
We will not, we cannot entertain your application if it is a case of the other co-owners saying that you are not the owner, that is altogether a different case.
That
If
will
you are
be
not a owner of the property, why did you mortgage?
Well, I told them I'm not the owner, but the manager has played a fraud. And the bank advocate
Come
has
to
given.
the order, come
Well,
to
the
the
bank
order.
advocate has given an opinion that
Yes, should your
that cannot be
submission.
Page
taken.
number 17.
That the fraud phase is played by the bank
You
manager.
also
Why
will
should the
played a
other
fraud by mortgaging the property for which you are not a owner.
manager?
You also.
No, I said that I'm not the owner yet because I have to get the ownership after the death of my mother.
You have said so many, but you have signed. Ultimately, what matters is what is there on paper.
It is for the bank to verify.
We have to, if you argue on that, we have to say, take a serious note of it.
Yes, serious note against the bank
Serious
manager
note against,
also.
not against the
manager
bank,
also.
against you.
Against me also,
against
against the bank
petitioner
manager also who has played fraud.
But both we will take. Please,
Yes.
please come to the order.
Yes, madam, kindly.
Page number
to
17, madam.
27, madam, page number 27.
Come to para 6.
Madam,
We'll read the para 6.
para?
6. Or from para 16.
Yes, the applicant submitted the borrower with ulterior motives.
No, no,
and
para
with-
16. The essay is filed challenging the position notice.
Madam, which parent, madam?
Paragraph 16, reasoning part. At page number 25.
5.
But it is suddenly became 16, the above para is 9.
Even 10, 11, 7.
It is, it should be para 10. Yes. You got it? Page 25.
So there's some,
Internal page 9 of the order.
what has happened is, in my petition copy, 23 is there, then 26, page 25, then listed.
No, internal page 9 is not there. Internal page 9 of the order.
Internal page 9 of the order. That's not.
Give me your copy, Mr.
There's a
Even my
mistake.
page is, that page is missing.
You also don't have?
No, in that one page is missing in the petition. There, I think they're not given the copy to even to me also. What my
It
friend
is
is
there
saying.
in the
However,
court
my lord,
file.
it's a matter, maybe court file, my lord, however, my lord, my 13.4, my lord, my measure assailed before the DRT. Wherein, my lord, we produced, my lord, mortgage deed. In fact, it's matter of fact and their admitted fact that I created a mortgage and I given an original title deeds in favor of the bank. In fact, based on that, the Honorable DRT passed an order. In fact, mortgage deed,
No, what is the mortgage? What is the title document?
my lord, gift deed, my lord, will, copy of the will dated 7/8/2009 and a copy of the memorandum of deposit by way of will, my lord, the petition got a title.
How will he will get a title by way of a will?
My lord, subsequently he deceased and my lord did that.
During the lifetime of that
No,
person?
not the lifetime.
Huh.
My lord, after decease only.
When she died?
My lord, that I have to, my lord, verify.
She's not dead, she's alive. She's as a party in the civil court.
No, I'll just point out, my lord. I'll just point out in two aspects. It's a matter of fact, before the DRT, their
Go to the matter of fact.
Then, my lord, I may permit to-
Clarify one thing. When anybody basing on a will get a title to the property during the lifetime of the person. During the lifetime of the mother, how will the will be acted
My
upon?
lord, that is the case, my lord, have it tomorrow. I'll find out, my lord, what are the documents are there. Because, my lord, in
bank
fact,
is
before the
this?
DRT, my lord, we justified. My lord, kindly see the order passed by the Honorable DRT, my lord. We
Please clarify this. Clarify this and we'll understand
Yes, madam.
how classically
I'll
the
file my
bank
statement.
is.
I'll file my statement of objection in this matter.
The Lease matter has parted after vacation.
Grateful.
The respondent bank shall file it is a contention of the learned counsel for the petitioner that the bank has mortgaged the property, that is the will that is executed by the mother and the property documents, whereas the mother is still alive and the mother is contesting the suit. It is submitted that that in spite of this fact being brought to the notice of the bank has mortgaged the property and they have initiated the proceedings. A partition suit is pending before the court. The manager of the respondent bank shall file an affidavit before this court.
We'll file a statement of objection. There is subsequently one more
File an
original
affidavit
suit.
before this court. On what basis when the executor of the will is very much alive, basing on a will deed, how the bank has granted, how the bank has mortgaged the property and has taken the mortgage and how they have given the loan amount. How much loan it is given?
1 crore.
How they have given 1 crore amount. And what are the guidelines of the RBI in this regard? An affidavit shall be filed. Let's just matter on 4th of June.
Next week, I'll file my statement of objection by that time.
No objections. I want an affidavit from the bank manager.
Supported by affidavit. I'll place it in the next week itself.
Yes.
So that
This
it can
is
be heard.
matter on 29th.
Grateful.
One more submission, my lord. Civil court to the 19th, there is an order not
Interim,
terminated.
there is an interim order.
There is an interim order, not
Interim order,
terminated.
interim order earlier granted is extended.
Not in this court.
But I'll grant now.
Civil court has given an order not terminated.
Lord, I was-
Considering the fact
My
on
lord,
the
I
face
just
of
pointed
it,
one aspect.
on
before
the
some-
face of it, that the bank basing on a bill has granted the loan and initiated the proceedings during the lifetime of the the lifetime of the mother who has executed the will. On the face of it, there is the order of the tribunal is without considering any of these aspects, they shall be stay of all further proceedings.
Grateful.
Yes.
Cell number 13, Santosh VS for petitioner Vinay Bhatt.
I am for the petitioner, Your Lordship.
Yes.
In this case, I have challenged the Annexure D, Your Lordship. That is a possession notice. Possession notice, Your Lordship. Annexure D. My contention is that without classifying the loan account as a NPA, they have issued possession notice.
What is that?
My lord, we issued the 13-2, NPA has been classified, possession notice has been 13-4 has been issued. Section 14, we have taken the physical.
You have the documents to show that it is received by him, 13-2?
Yes, lordship. Yes,
Pass
yeah.
on.
13-2 is issued, if it is lordship permits, I can able to say postal receipt.
Important is whether the acknowledgement is received or not. Service is also important.
I'll just get it, lord.
Land counsel for the petitioner submits that without declaring the account as NPA, without issuing a notice under 13-2, no, they've issued notice under 13-4.
Yes, 10-7.
Huh?
10-7.
13-4 notice is issued. Land counsel appearing for the respondent bank submits that they followed the procedure. The counsel shall place before the court the acknowledgement to show that the 13-2 notice is served on the petitioner.
Till that time.
And the account is declared as NPA. Huh?
Till that time in order.
They'll not do anything.
No, no.
When can you get it?
My lord, next week, Monday, this also.
Unless this matter on Monday, there are so many matters. List it on Tuesday.
Yes, lordship.
No further, they list it on Tuesday. Till such time, no court system.
And also, Your Lordship, one more submission. In this case, the petition number 2 is the co-applicant. And with respect to her overdue account, that has also been as included in the present account statement.
We'll find out from you.
Cell number 14, C. Vinay Swami.
Direction the last hearing. So direct the second respondent RBI to file their objection, my lord, regarding MSME.
By the time Reserve Bank of India shall file their objections.
My lords, one humble submission, my lords. Your lordship has already heard the similar matter in WP number 5209 of 2026. And your lordship has reserved it
Yes.
on the very same matter, my lords.
lords, on 15th of April 2026. My lords, so far as my lords, I've sent it for the approval, my lords, of the objections.
So because we do have to have your response on that.
Please, my lords.
In the other matter which I have already reserved, they've already filed their response.
Please, my lords, I've just sent it for the approval, my lords. I just require some time, my lords, for the approval statement of objections, my lords.
When will you
The
get?
2 weeks, my lord, 2 weeks, my lords.
After vacation we'll have. This matter after vacation has started. Because similar matters are already,
Please,
so once
please.
your objections on record, we can pass on.
Please,
Yes.
grateful, my lord.
My lord, till session, let them be a status quo, my lord.
No, what is the,
They have gone to DRT and they
what
have
is this writ petition then, when they have gone to DRT?
No, it's a different
both
loan
are
account.
sister concerns.
Let's see.
Same partners, same scheduled properties are mortgaged for both the concerns. One concern is called Manjunath Traders. And Manjunath Traders, they have already gone.
No,
They have
let's see.
gone.
It is totally different, this thing, my lord.
To quash the first respondent's bank's letter dated.
MSME.
That is MSME, I have given a representation, my lord.
Now, who is the petitioner before this court?
That is Dinesh International,
Dirish International.
Represented by?
represented by the partner.
Who is before the DRT?
That is a Manjunath Traders, it's same, that is another partner is representing, Hitesh.
And the same partnership, same mortgage properties, which are mortgaged for
Sir,
that.
we are
proper loan
not
also, this
disputing the liabilities at all, madam. Only thing, my
Or
representation.
when you have already approached the DRT, why you are pursuing
my-
simultaneous
my lord,
remedies?
Go there.
There, I'm not, there is no dispute against my liabilities, madam. Only thing is my restructuring, I have given a representation for restructure the account as per RBI guidelines. Till today, we are,
Do you agree on the point that the secured asset in that, and then this is one and the same?
no, for that relief, I have taken separate this thing, my lord, in before DRT.
Yes.
For this,
You have not
they-
still answered my question, Mr. Counsel. I said the secured credit is one and the same on, secured asset is one and the same or not?
I'm here, I'm not disputing my liabilities at all, madam. My humble submission is, let them consider my
Do you want?
restructuring
do
my
you
loan
want
account.
Answer to the court's query or not? You have not answered till now. I said whether the secured asset is one and the same or not. One
Yes,
or not?
There, they are claiming it is a separate.
If you're
If
not
they are
interested
suppressed,
to argue, I can't help it. If you're not asking something, you have to answer.
let it be post after vacation. I'm not seeking any interview.
Is this matter after vacation?
And he says also he is not seeking for interim relief. Really,
I'm not giving any interim order.
Grateful.
As part of.
Cell
Yes.
number 15 adjourned. Cell number 16. Cell number 16.
My Lord's kind permission.
On the last date of hearing, this honorable court made a reference to Andhra Pradesh and Telangana High Court judgment. I am placing it on record.
What is this repetition?
My Lords, that was,
Point.
that, my Lords, as the petitioner, if I may be permitted to first make out my case. My Lords, this is the case where whether a society can be brought under the rigors of the Right to Information Act is what was the issue. In fact, my Lords, on the last date of occasion, like the learned counsel has just pointed out, my Lords made reference to a judgment of the Andhra Pradesh High Court. My Lords, that was in G. Rajendranath Gaud versus the government of Andhra Pradesh. In fact, I must humbly state it that my Lords also had an occasion to appear in that matter. Along with the memo of citations, I would place that matter for my Lord's kind consideration. Also. Yes, please.
Yes.
My Lords, before I go to the judgment, my Lords, of course, the issue has been on a larger, my Lords, on a more wide amplitude. It has been already covered in Thallapalam Service Cooperative Bank of the Supreme Court in the 2013 judgment. But my Lords, if I could just quickly go through the relevant dates, my Lords, in these two writ petitions. My Lords, there are two writ petitions filed. The first one being writ petition number 5068 and 5069. My Lords, in this writ petition, there were two impugned orders. One was an order passed by the public authority. And apart from that, my Lords, there was also a notification issued by the Karnataka State Waqf Board dated 7/6/2018. There were two issues that were impugned, my Lords, in 5068.
No, we are not, Before me, it is 43845.
Yes, my lords may see 16 and 16.1. There are two.
So what is 43845?
Yes, my lords, 43845, my lords, is an offshoot of 5068.
Give the other one.
That's the reason why, my lords. If my lords may just take 5068 for a moment, I will only make reference to the impugned order there.
Where is
If my lords may kindly take page 74, annexure L in 5068.
Yes.
My lords, that is a notification of the Karnataka State Waqf Board asking to appoint, my lords, public information officers in the institutions. In exercise of powers conferred under subsection 2 and section 5 of the
Appointed the concerned officers.
Please, that is all this is. My lords, on the basis of this, my lords may now come to annexure N, page 79. There was a pending complaint.
We'll read it. We'll read it to understand.
Please, my lords, I'll read it. My lords may annexure N, my lords.
Yes.
Mr. Mohammad Wazir Beg has submitted RTI application bearing number so and so, seeking information from Secretary Jamia Masjid and Muslim Charitable Fund Trust, SJP Road, as per board's notification dated 7/6/2018. That is what my lords just read in annexure L. According to the appellant, Mr. Mohammad Wazir Beg in the said institution has not furnished information sought within the stipulated time period. Hence, he has appealed before the undersigned in the capacity of the first appellate authority and Waqf officer, District Waqf Office, Bangalore Urban, South on 19/11/2018. In this regard, as per section 19(1) of the RTI Act 2005, the undersigned issued notice dated 10/12/2018 for hearing appeal on 17/12/2018, wide so and so. As per notice, the appeal heard on 17/8, the appellant was present and the respondent institution was represented by advocate Mr. So-and-so, who filed Wakalat Nama on behalf of the institution and sought time. Since the appeal has to be disposed within 45 days, a short time was given and the next date of hearing was fixed on 22/12. On the next date of hearing, the applicant as well as the respondent were absent and another date was fixed on 27/12. Even on 27/12, the respondent did not appearing for hearing, whereas the applicant was present and insisting that the information be provided to him and also sought the liberty to appeal. The undersigned.
Give the right to information act.
Yes, please. The undersigned in the capacity of first appellate authority and district waqf officer, district waqf board, hereby pass the order that the Jamia Masjid Muslim Charitable Fund Trust, Bangalore, comes under the purview of 2H of the RTI Act, and information sought shall be provided to the applicant without fail within 1 week, free of cost, as per the board's notification dated 7/6/2018. So, my lords, this order.
Come to 2H.
Please, my lord. My lords, just before I go to 2H, my lord, this order is what I had impugned in this writ petition, and it was, my lords, stay was granted.
Let's see. 2H.
Yes, please. It was stayed. Now, my lords, if I can go to 2H of the Right to Information Act. It's not opening. Just check this. My lords, just bear with me for a moment, my lords. I have actually culled it out even in the grounds. My lords, I'm so sorry. I'll read it out. No. My lords, 2H, public authority, means any authority or body or institution of self-government established or constituted by or under constitution, by any other law made by the government, by any other law made by state legislature, by notification issued or order made by the appropriate government, and includes body owned, body controlled and substantially financed non-government organizations, substantially financed directly or indirectly by the funds provided by the appropriate.
The judgment which you are having is what?
I may be pardoned, please.
So you are saying that there is some judgment you have come across. What is that?
Yes, that is DVA College case. This is much subsequent to the
No, there is no, why I'm saying is, this is a charitable institution.
But before that, I would like to make a
No,
reference
in
to.
respect of, I'm referring to a charitable institution. What has happened is, all the charitable institutions that are notified under the Charitable Institutions and Endowments Act.
Of
And
Andhra Pradesh.
when the information is sought by somebody, and when we said that we are not amenable to the Right to Information Act, then the High Court has decided that aspect and held that they will not fall under the
Yes.
Right to Information Act.
Yes,
That judgment I'm asking.
But please see how the judgment is worded.
That is, Mr. AGA, that is by one Justice Challa Kodanram. With regard to all temples have filed the writ petition.
Now, please, in that judgment, please come to page number 15.
Which judgment?
The one cited by my learned friend now. Page number 15, unnumbered paragraph number 4.
Yes.
Third paragraph
Page
from
number?
last. In the light of the above elaborate discussion,
No,
this
you
court,
said page number 6?
page number 15, 1-5,
1 minute.
third paragraph from bottom. Yes. Rajendra Gaud, I am sorry, Rajendra Gaud, I am referring to Rajendra Gaud.
Oh, Rajendra Gaud.
Rajendra Gaud. Page number 15.
1 minute.
In the light of the above elaborate discussion, this court is of the opinion.
This is the one. This is the one.
Yes. This court is of the opinion that the religious institutions like temples, church, mosques, which are not financed, funded by the government, do not fall within the purview of 2005 Act. Now, the corollary is, if they are funded by the government, then they fall under the Act. That is how
What are the issues that fell for consideration? Please come to page 39.
Yes. That is.
What is the purport and scheme of the Right to Information Act 2005? Who is a public authority as defined under section 2H
of the Right to Information Act, whether the temple falls within the ambit of scope of the definition of public authority. In
The
this case,
commissioner has the power to, in fact, I had formulated these questions
yes,
of law.
yes, that is what para 8 says. But then the question was not whether the public, the trust or temple which receives public fund. That was not the question here.
No, generally whether it receives or not is a question. The answer is it doesn't.
Yes, answer is, if
doesn't.
if it does not receive public fund, it is not covered by the Act.
Let's see what is that, how it is discussed.
Yes. Whether the commissioner has power to issue impugnment.
Can we come to 40 last paragraph? Page, bottom page number 40, last paragraph. On a careful examination.
So we are referring to.
In the judgment.
In the print I have, there is no paragraph number.
Not paragraph, bottom page number 40.
I may be permitted to read that paragraph.
On a close examination of.
On a close examination of section 2H, applying the tests laid down in the definition, it would be clear that the same does not fall under section 2H1 A, B, and C, as the temple is not established or constituted by or under the Constitution or by any other law made by the Parliament or state legislature. The establishment or running the affairs of the temple cannot be said to be either controlled, owned or substantially financed by the government. Though a temple could be said to be a non-governmental organization, as it does not depend on its finances in any way, much less substantially, on the government either directly or indirectly, the same is also outside the purview of section 2HD2. In this context, the argument of learned counsel N. Subbarao to bring a temple within the scope of RTI requires to be examined. Shri Subbarao makes a reference to the definition of a person having interest under section 218 of the 1987 Act to contend that a devotee is a person interested and keeping in view the objects of the enactment of 2005 Act, a devotee is entitled to obtain the information within the parameters specified under the Act. Further, under Section 6, every temple with the specified income is required to be registered as it has to maintain certain records in relation to the properties and various other aspects specified under the Act and under Section 2387. The State Government Commissioner Dharmik Parishad are entitled to constitute board of trustees and governing bodies, executive officer, person in charge for managing the affairs of the temple, which establish a deep and pervasive control of the government with respect to the affairs of the temple, thereby equating a temple to the public authority, state government as normally understood under Section 12 of the Constitution of India. My lords, to examine the above argument, that is the same argument that has been considered. If my lords may come further. At the bottom, my lords, the argument of the learned counsel so far as the power of the state or its authorities with respect to monitoring certain affairs of the temple cannot be denied. However, the question which begs consideration is whether, in the first instance, the institution itself falls within the definition of public authority as defined under the Act and not as understood either in general parlance or for the purpose of Article 12, 226 of the Constitution, which expanded the parameters of the state. Answer would be a definite no on account of statutory provisions restricting the scope and authority in the Act. So this answers point number 1, 2, and 5. The answer is a abrupt no, my lords. Why this distinction has been carved out, my lords, we'll have to fall back upon the earlier judgment, the 2013 judgment of the Honorable Supreme Court. My lords, it is also a part of the memo of citations which I have laid before my lords.
1 minute. Yes.
Please, my
The
lords.
first judgment.
Please, my lords. My lords, at page 13, para 2, my lords, there were conflicting views at that point in time arising out of the High Court of Kerala. My lords, I'll only read para 2 to give a preface of this judgment, my lords. Para 2 at page 13.
Yes.
A full bench of the Kerala High Court in its judgment in Mullur Rural Cooperative Society Limited versus the State of Kerala answered the question in the affirmative and upheld circular number so and so issued by the Registrar of Cooperative Societies Kerala, stating that all cooperative institutions coming under the administrative control of the registrar are public authorities within the definition, within the meaning of Section 2H of the RTI Act, and obliged to provide information as sought for. The question was answered by the full bench in view of the conflicting views expressed by a division bench of Kerala in writ appeal number so and so within the earlier judgment of the division bench in Talapalam Service. My lords, wherein the bench took a view that the question as to whether a cooperative society will fall under Section 2H of the RTI Act is a question of fact, which will depend upon the question as to whether it is substantially financed directly or indirectly by the funds provided by the state government, which
one submission, instead of spending time on this, it has been referred to in a subsequent judgment and interpreted differently. We may go to next judgment.
That is overruled. That is Talappalam case is overruled in the case of BAV College Trust and Management Society and others.
Where is that?
This is reported in 2019, 9 to Supreme Court 185.
It is easy. It is easy to refer.
The Talappalam case is referred in this case, madam. This is
You have a copy of it?
I don't.
Give him a copy.
I'll give it. Please refer
That
to
is
this copy.
subsequent judgment, para number 25.
This is a two-judge bench judgment.
This is subsequent one. DAV college is subsequent one.
And that is referred.
That is referred and deferred. Now, what is the question? Question involved was whether the fund grant.
One more judgment of Bombay High Court, full bench, which is the People Welfare Society of State 1 for 2024. There they have distinguished all these judgments, so that I'll place.
That also, please give it to, take that as. Yes.
Now, please come to DAV college judgment.
Yes, paragraph.
One.
Para 25 and 20.
Para 1 is whether non-governmental organizations substantially financed by the appropriate government fall within the ambit of public authority under section 2H of
Reading
the Right to
paragraph
Information
number?
Act. That is the question. Then discussion start from 14 to 18.
Yes, please read.
The section no doubt is unartistically worded and therefore a duty is cast upon us to analyze the section, find out its true meaning and reinterpret it in a manner which serves the purpose of the act. If we analyze section 2H carefully, it is obvious that the first part of the section 2H relates to authorities, bodies or institutions of self-government established or constituted under the Constitution, B, by any law of Parliament, C, by any law of state legislature, D, by notification made by the appropriate government. There is no dispute with regard to clause A to C. As far as clause D is concerned, it was contended on behalf of the appellants that unless a notification is issued notifying that an authority or body or institution of self-government is brought within the ambit of the act, the said act would not apply. We are not impressed with this argument. The notification contemplated in section D is a notification relating to establishment or constitution of the body, and it has nothing to do with the act. An authority or body or institution of self-government, if established or constituted by a notification of the central government or a state government, would be a public authority within the meaning of clause D of section 2H of the act. We must note that after the end of clause D, there is a comma and a big gap, and then the definition goes on to say, and includes any, and thereafter the definition reads as body owned, controlled or substantially financed. This is number 1. Number 2, non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government. The words and includes any, in our considered view, expands the definition as compared to the first part. The second part of the definition is an inclusive clause which indicates the intention of the legislature to cover bodies other than those mentioned in clause A to D of section 2H. We have no doubt in our mind that the bodies and NGOs mentioned in clause 1 to 2 in the second part of the definition are in addition to the 4 categories mentioned in clause A to D. Clause A to D cover only those bodies which have been established or constituted in the four manners prescribed therein. By adding an inclusive clause to the definition, Parliament intended to add 2 more categories. The first being subclause 1, which relates to bodies which are owned, controlled or substantially financed by the appropriate government. These can be bodies which may not have been constituted by or under the Constitution, by an act of Parliament or state legislature or by a notification. Any body which is owned, controlled or substantially financed by the government would be a public authority. This is an assertive statement. Then the next paragraph, as far as clause 2 is concerned, it does not, it deals with NGO substantially financed by the appropriate government. Obviously, such an NGO cannot be owned or controlled by the government. Therefore, it is only the question of finance which is relevant.
Come to paragraph number 22
onwards, but 25, my lords, is the important.
That is the relevant paragraph.
That brings us to the second limb of the argument of the appellant that the college/schools are not substantially financed.
And in that you find 48. That we will please come to. Next para, last para.
48. Merely providing subsidies, grants, exemptions, privileges, etc. as such cannot be said to be providing funding to a substantial extent unless record shows that the funding was so substantial to the body which practically runs such funding, and but for such funding, it would struggle to exist. The state may also float many schemes generally for the betterment and welfare of the cooperative sector, like the deposit guarantee scheme, scheme for assistance from NABARD, etc. But those facilities or assistance cannot be termed as substantially financed by the state government to bring the body within the fold of public authority under section 2HD1 of the Act. But there are instances where private educational institutions getting 95% of grant in aid from the appropriate government may answer the definition of public authority under section 2HD1. In our view, substantial means large portion. It does not necessarily have to mean a major portion or more than 50%. No hard and fast rule can be laid down in this regard. Substantial financing can be both direct and indirect. To give an example, if a land in a city is given free of cost or heavy discount to the hospital, educational institution or such other body, this in itself could also be substantial financing. This covers the case of the petitioner. The petitioner has received, in our case, a civic amenity site from Bangalore Development Authority.
My lords, that would not be.
No, let's
Please.
continue to read.
I'll continue.
Please.
The very establishment of such an institution, if it is dependent on the largesses of the state in getting the land at a cheap price, would mean that it is substantially financed. Merely because financial contribution of the state comes down during the actual funding will not by itself mean that the indirect finance given is not to be taken into consideration. The value of the land will have to be evaluated not only on the date of allotment, but even on the date when the question arises as to whether the said body or NGO is substantially financed. Whether an NGO or body is substantially financed by the government is a question of fact which has to be determined on the facts of each case. There may be a case where the finance is more than 50%, but still may not be called substantially financed. Supposing a small NGO which has total capital of rupees 10,000 gets grant of rupees 5,000 from the government, though this grant may be 50%, it cannot be termed to be substantial contribution. On the other hand, if a body or an
Para
NGO gets...
29 is important.
Yes. Another aspect of determining substantial finance is
29.
Next part.
While interpreting the provisions of the Act and while deciding what is substantial finance, one has to keep in mind the provisions of the Act. This Act was enacted with the purpose of bringing transparency in public dealing and probity in public life. If NGOs or other bodies get substantial finance from the government, we find no reason why any citizen cannot ask for information to find out whether his or her money which has been given to an NGO or any other body is being used for the requisite purpose or not.
Yes. Now you can make your submissions. Now the whole issue is whether you are receiving substantial funding from the government or not.
The site allotted to the petitioner by Bangalore Development Authority is substantial.
How much is the extent of the site?
My lords,
Number
I
one,
have taken property
number one,
which is
apart from-
recognized in the Kitab ul Waqaf. Today, my lords, is the BDA a party before these proceedings? Is my
Number
respectful
one.
submission.
Number
The
two.
BDA is not even a party, but this public authority is now making a submission that I have received. My lords, may kindly see annexure A and B.
Number one.
My documents are before this honorable court.
Number two.
My lords, I
the
am a
petitioner
society
has-
registered.
Let him
I am a
submit on that
society
and-
registered under the Societies Registration Act. My lords, may kindly see the
What
certificate.
is the nature of the?
My lords, I have no finance. I'm not receiving any finances at all by the government.
Tell the court, what is this society? What is this charitable trust?
Please, my lord, it's the Jamia Masjid Charitable Trust that was.
Is founded by?
My lords, it was registered, my lords, by trustees. My lords, they formed a charitable trust.
It's a private charitable trust.
Yes, please, my lords, private charitable trust, and my lords, it receives this land. My lords, may kindly see annexure B. Annexure B, my lords, is the Mysore State Board of Waqfs. My lords, there is reference to item number 109, which is the Jamia Mosque Sunni, Bangalore city. My lords, this is a Waqf property, and this Waqf property, the charitable institution enters into a agreement with the Waqf board, my lords, for that land. So to say that it is, I'm being substantially financed, my lords, is a pure question of fact. And to show how I'm substantially financed is, my lord, it lies on them. That, my lords, is not the case.
Forget about what they are saying.
Please.
For the understanding of the court, you please tell. Now, this is a public, it is a private charitable trust.
Please.
And what are the activities of the trust?
My lords.
And will you come under the, fall under the provisions of the Waqf Act? Or not?
Please, please.
If you fall, what is the control exercised by the Waqf on this institution?
My lords, the only control that is exercised on me are twofold. One is I am a society registered under the Societies Act. So accordingly, my lords, as required, I have to file my audited accounts before the registrar, which I have done. Similarly, section 43 also prescribes the same duty cast upon me. Yes, please.
Let's see.
That I have to go to the Waqf board. 44, my lords, is in chapter 6. It is maintenance of accounts of Waqf. My lords, may kindly see 46 is 44.
How are
is
you
budget.
defined?
46.
No. In the definition.
Please.
How are you defined as a Waqf institution?
Waqf institution.
Let's see. What is a Waqf institution as per the definition?
My lords, R, definition R.
Waqf means the permanent dedication by any person of any movable
or immovable property for any purpose recognized by the Muslim law as pious, religious or charitable, and includes a waqf by user, but such waqf shall not cease to be a waqf by reason only of the user having ceased, irrespective for the period of such user. My lords, may kindly see grants, including Mushratul Kidatam. My lords, these are all, they fall under the, my lords, personal laws. There is nothing of public nature at all, my lords, in the entire definition. My lords, as a
registered Waqf under the Waqf Act.
I'm a registered Waqf institution.
Under the Waqf Act. You are under the control of the Waqf. What are the control exercised by the Waqf board?
Yes, the only control, my lords may see, we'll get it from section 46.
40?
46. 44 is the chapter which requires me to maintain accounts.
Every mutawalli budget, it speaks about the budget.
Yes, my lords may see the chapter maintenance of accounts. 44 is budget, 45 is preparation of budget, and 46 is submission of accounts. Every mutawali shall keep regular accounts before the such and such day, following the date on which the application under section 36 has been made thereafter before. In every year, every mutawali shall prepare and furnish to the board a full and true statement of accounts in such form containing such particulars as may be provided by regulations by the board of all monies received and expanded by the mutawali on behalf of during the period of 12 months on the period ending 31st day of March. So that is the only duty that is cast upon me, and that is there is no action that has been taken upon me for non-compliance or anything of such nature. My lords, before we proceed further, my lords, we have to see the very inception of this issue. My lords, this is a disgruntled individual. It's a private complaint, my lords, that dates back to 2016. From 2016, this Mr. Wazir has been consistently troubling and harassing the board.
What is the information
That
he
is
wants
not
to
part of
have?
the petition.
It is very much a part of the petition. My lord may see my statement of my kindly see my narration to say that it is not a part of my. My lords.
What is the information he wants now?
Please. My lords may kindly take. My lords is in writ petition number.
Second one.
Please. That is 43845. My lords.
Yes. Yes.
Yes, please. My lords may kindly see F1 3/12/2016. This, like I
Page
said,
number.
page number 38, annexure F1. Like I said, this issue goes back to 2016, my lords.
Yes.
Yes, please, my lords. Mr. Mohammad Wazir Beg. This is the disgruntled individual. My lords, your esteemed organization so-and-so is a reputed organization registered in 1940. It is a proud movement of your teamwork, depends on the different personalities of the community so far. It is a fact that the state government is allotting lands for financial funds time to time. My lords, just a statement. As
So
per section
according-
2H, your public authority.
Pausing here,
Please.
land was allotted, but there are no financing, funds
My
were
lords,
not allotted.
My lords, even it is not fair to say that lands are allotted. My lords, a Waqf institution is not allotted. My lords, there is a manner in which a Waqf institution, my lord, it can only happen by way of a public auction.
You purchase a property.
No, my lords, I have entered into a lease agreement with the Waqf board, who gives you the Waqf institution. That is how the Waqf.
And that you pay something for that?
Yes, please, my lords. Yes. There is a nominal fee, a nominal rental that is taken, and strict stipulations are put on me that I cannot sublet a property, that I have to use it only.
Is it, but that is not what he's referring to.
That is the only land.
I'm referring to it.
That
One
is the only land that has been
one
given.
is- One is,
Saying that the
One is-
BDAs are allotted.
that is by BDA. Annexure F5
My lord,
is by
it's-
BDA.
1 minute, F.
F5, page number 44. English translation is at page number 47. After reviewing the application submitted by you, we are pleased to inform that a civic amenity site has been allotted to you in accordance with Bangalore Development Authority Allotment of Civic Amenity Site Rules, 1989.
Cost is there,
Yes, please.
1200, initial fee paid, 4,59,000.
It is at a concessional price this was.
It is granted at
But they have paid
throwaway
it, it
price.
is not
It is-
on
it is-
free,
it is a
free cost,
throwaway
they have not
price.
given it.
My lords,
It is at a throwaway price.
Now it is worth crores of rupees.
That is one.
Not now, as on the day.
No, even on that date,
My
it has
lord.
to be taken because
My lord.
DVA college judgment says that even on the date when an application is made for information, what is the value of the site that has to be considered?
That has to be taken into account.
Number one. Number two, the petition admits that it received a grant of 3 crores from the state government.
It's in para number.
Where is
Para number 8.
Para number 8.
8.
8 of the writ petition. Page number 5.
Para number 8 is page number 9.
Para number 8, in which petition?
In
43845.
Yes, I'm looking at it.
43.
Para 8 reads as agreed by the party.
Please.
Yes, agreed by the party. After some 10 lines,
what is the reading?
Karnataka.
Yes, please.
yes, Karnataka government of Karnataka, wherein it was proposed to allot a grant of rupees 3 crores to so and so education institution run by the petitioner and a grant of 3 crores to the Berry Association to construct a Sauhardha Bhavana, etc., etc. This amount has been received.
Is it correct?
My lords, I'll have to get instruction on that. But my lords, even then,
No, no,
just
you
by
are-
getting some, I will have to take
Having
instruction.
stated so in your affidavit.
My lords, I'll have to take
Why are you
instructions.
assertively saying that I have not received anything?
My lords, I'll take strict instructions on that and I'll come back. But my lords, my argument may be accepted that even if such grants are received, my lords, it would not change my nature from a Waqf institution to a public charitable, to a public authority to make me amenable to, my lords, the right to information. My lords, that is strictly what Talapalam has held. And my lords, the definition, now DAV's judgment that has been referred to and relied upon with so much intensity by learned
You have the
counsel.
copy of that, Mr. AGA? You have the copy?
Yes, I have. And,
This is fully covered.
there is one more judgment, the Century Club, where the club has granted a
Take
certain
that
land.
also. That also.
And there is one Nirmiti
Kendra.
Kendra,
Even
it was receiving around 1,000 rupees grant, held to be an institution under the RTI.
Yeah.
Nirmiti Kendra is an NGO, a non-governmental organization. Even then, this honorable coordinate bench of this honorable court held that it is a public authority.
Have you gone through this judgment?
I have it. I have.
Look at it.
Please.
I'll hear it on 29th.
I'm grateful.
Let's just matter on 29th.
A day earlier,
Give him those two sides, yeah?
may I request for a day earlier, 28?
Or I'll have it after vacation because
Very well.
this is matter after vacation as partner and take this, give him the citations. Other consistent part listed as parted after vacation on 11th of June.
Grateful.
Cell number 17.
Request 1 minute, ma'am. My case is not there today.
You can't make submissions in between.
Not-
Yes, next.
No, ma'am.
Number
My
17.
case is closed, ma'am.
Venkatesh Sharpati.
Case is closed, ma'am, already.
Huh?
Case is already closed, ma'am. Order has been passed. But the file is missing to be sent to family court from 7 months, ma'am.
I'm not having the family court roster.
No, ma'am. Here, the case was closed on September 25th, 22nd, ma'am.
But what is happening with all this file missing and they can't do the scanning like this? By hindering the entire process. No, that lady says 25 is, September 25th is the writ petition disposed of, but the file is not sent because the files are missing. Give it to the court officer.
I've given a letter to the registrar also.
Give it to the court officer. She'll verify and again find out from her. Yes.
I appear for respondent. So the petitioner matter arises out of not arbitration proceedings. Challenge is not to the order passed by the arbitral tribunal under section 29A. Matter requires some consideration, not the
So let's see what is the prayer.
interpretation of section 29A. But prayer
Question
is,
order
the order
passed by the respondent number 2. Respondent number 2 is?
the arbitrator, learned arbitrator, sole arbitrator.
Hmm.
It's at page 100.
It takes time.
Yes, ma'am.
My lords, short question, my lords. What has happened, my lords? From
Not,
5 years, my
We'll
lords.
have it after vacation because there are so many.
Could I
MPs are
request this, my
pending.
lords? From last 5 years, my lords, it's held up at my lords an order judgment stage, my lords. A short
But
question,
my
whether my
learned
lords
friend has
29,
taken- my learned fr-
29A would apply to the proceeding which has commenced.
My learned friend has taken more than a half a dozen adjournment. Kindly see the order sheet.
Kindly see, my lords.
Today, my lord,
Kindly
he
see.
cannot come and show
Every
that
time
5
he
years.
argues.
But
Let
to-
him not make submission.
to-
All that, my
let
lords,
the-
he has,
let
my lords, passed
the
over
order
the
sheet-
matter and never argued the matters. Let him not make any allegation against me.
But let the, not kindly see the order sheet. Not today, not tomorrow some inconvenience. Monday or Tuesday, your lordship may have it.
Monday and Tuesday court has lot of, because just before the.
Tomorrow there is some
Back
inconvenience.
end of the vacation, I can't take up this
Yes, I understand. Tomorrow there is some inconvenience. Kindly have it Monday or Tuesday.
matter after vacation.
Great.
My lords,
Cell number
emergency. my
Time is not there. 2019, you are waiting.
lords, last 5
This is
months,
a
my lords,
matter
we are
on
trying to
4th.
list out.
Call it 4th.
Passover matters.
Interim order has to be.
Intermod earlier granted is accepted.
Great.
Passover matter. Cell number 3. List number 1, cell number 3.
In this case, I am filing memo for that. I am writing it.
You're writing?
Writing it.
Memo.
What a minute?
Give it to the.
I will give it.
Memo is filed, saying to withdraw the writ petition dismissed as withdrawn. Yes, next.
Cell number 18.
Great.
No, he called
HBA.
17.
Okay, 17 or 10. After the
18,
process.
yes.
Cell number 18.
Appear for petitioner in this case.
Senior citizen.
Order, my lords, order passed at a senior citizen.
Look at, come to the cost item.
Please,
It is a, mother is the petitioner.
please, my lord.
Then second, it is son.
Respondent number 2 and 3 are sons, my lord.
When was the gift date?
Gift deed is of the year 2018, 13/4/2018, my lords.
13/4.
2018, my lords.
When did she approach the,
2019, my lords.
what is her case?
My lords, her case is that, my lord, she was supposed to execute a
will in favor of our children, my lords. But they have, by misleading, my lords, they have got the gift deed in their favor. So thereafter, my lords, immediately they tried to dispose her from the property, my lords. As such, she approached the court, my lord, looking for cancellation of the gift deed, my lords. My lords,
As it is well aware, my lord, because the contents of taking care of the petitioner is not written in the gift deed. So it is their case that in the gist of executing the will, gift has been executed, which cannot be dealt with the respondent number 1 in our case. Because there are
But you have
citations.
thrown her out of the house by after having the gift deed of the property.
No,
What
it
about
is-
that?
it was
Can
the
there be there can be an order directing you not to dispose of her?
Yes, I have not disposed of my lord, and I have complied with the order. Both the sons are paying monthly 3,000 each, and she has also given a separate accommodation in the same building. She is also enjoying the rents in the 3rd floor. And it is the property of the father where it was divided among the family members. And of course, the gift deed is with respect to the our share, my lord, our respective share.
Oh, already like others were having.
Yes, my lord, please. And their allegations is they wanted to execute the gift deed, will, and out of the will, they have got executed the
No,
gift deed.
is she led to, is she residing in the said premises?
Yes, my lord, please.
It is gifted to you, gifted to you people.
Yes, my lord, please. There are totally 4 floors, my lord. Ground floor, 1st, 2nd, and 3rd floor. She is residing in the ground floor.
That is what is gifted to you.
Yes, ma'am.
only
And you undertake,
Entire property is gifted to me, where I have taken a loan and we have constructed 4-story building, and she has been provided ground floor along with the rents in the 3rd floor, my lord, please.
is it correct?
my lords, there is an order of, that is the order of the.
No, is it correct?
No, my lords. The ground floor, my lords, is entire parking space, my lords. Only 1st, 2nd, and 3rd floor is the constructed portion, my lords. In pursuance to the order of the lower court, my lords, were directed to put up a construction in the basement floor for the extent of 15 feet, my lords. They have put up now a shed-like structure, my lords, and asking me to stay there, my lords.
What about 3rd floor?
3rd floor is there, my lords.
No, 3rd floor rents you are receiving.
No, my lords. I'm not receiving the rents, and they have not deposited
Please, my lord.
any amount, my
Please.
lords.
No, let them file an affidavit saying
Please, my lord.
that
I'll do.
she's
My lords.
residing in the ground floor.
Yes, my
Show
lord.
the photograph of the ground floor.
They have produced it, my lord, along with their
I have
objections.
filed my objection statement also on 1922, please.
Take that photograph.
Madam, put it. It's an entire fully furnished building. Along with the parking, there is a separate house to her.
No, if you see the ground floor, entire ground floor is parking. Where
Parking
from you
space,
see
my
the
lords.
building?
There is a house also, my lord.
Then you have to
Inside.
take the photo of that.
I'll do that, my lord, please.
So now, whatever with regard to cancellation of the gift deed, with regard to fraud and other things, that we cannot go under 23.
Please.
So what we do is, let them come up with an affidavit with regard to the 3rd floor, that being enjoyed by the mother, and what is the ground floor. That we record and pass orders.
Lords, I cannot stay in the parking space, my lord.
Third, then go and stay, don't
Lord,
give it
she's
for
aged,
rent.
she's aged about 80 years, my lords. She cannot climb.
No. I have given
3rd
the
floor, my
photograph
lords.
of on 1922. The
How
ground
will
floor.
she, how will she get, how will she can go to the 3rd floor?
No, the
There is one more building, my lords, residential building, my lords, from which they are receiving the rental incomes, my lords. There is one more building
in that
apart from
case,
this
she is
building,
also
my lords.
receiving rents from other premises also.
No, that's true.
Lord, I filed the photo on
Comfortably
1922.
having constructed a new house, you can't keep your mother in a
No, I have
cellar.
given the photo of the ground
No,
floor
it's
only.
like a cellar.
No. I have filed, madam, 1922 ಗೆ ಹಾಕಿದ್ದೀನಿ ನೋಡಿ objections. I have given the photos on 1922.
That's so unfair on the part of the sons. Yes. When did you file?
1922, minute.
1922.
My statement of objections of respondent number 2 and 3. page number 8, my lord, the photograph has been given, please.
Some partition you have done, some,
Put up a temporary
will
structure,
she
my
live?
lords.
That's,
There will be a water seepage of the car washing. Kindly see the below
the
portion, my
entire
lords.
plot belongs to her. You will construct a house. You will keep her in the cellar.
I'll find the fresh photographs to
Whatever,
show,
no,
please.
otherwise, I'll confirm the order of the commissioner.
Lord, I have also given the receipts for paying the amount regularly without any default.
Whatever it is, now there are 3 floors. Either you shift from first floor to third floor.
Third
for
floor,
the
there are
first floor.
rents and the entire rents has been enjoyed by the
That is also, where
petitioner.
is the document to show that?
I have already given it not on 1 to 20.
If not, by the next date of hearing, you have to provide her with the first floor. Or any other accommodation where she can live. Or why should she live in this kind of an accommodation? Why should she live in the
Lord,
cellar?
it was at the time of 22, now it is
No,
fully
cellar
furnished, my lord, actually.
without any light, without any ventilation. Why is she living like that?
Ground floor ఇచ్చిండమ్మా కింద 15 by 15 ఇచ్చిండనమ్మా కింద ఉండారమ్మా ఎప్పుడన్నా ఫోటో అంతా వేసిండనమ్మా మా అమ్మ ఉందమ్మా 15 by ఏసీ రాసిండ్రమ్మా కింద అమ్మకి అన్నది నేను రాసి ఇచ్చిండను 15 by 15 ఇచ్చి బాత్రూమ్ అంతా టాయిలెట్ అంతా సపరేట్ గా చేసిండమ్మా మా అమ్మ పెట్టలేదమ్మా మేము లోన్ చేసి కట్టిండేదమ్మా ఈ కెనరా బ్యాంక్ లో నెల 50,000 కట్టాను.
Ask him not to say all this.
Please. I'm sorry, my lord. Please.
By next time, you get all the details.
I'll find, please,
With
ma'am.
regard to where is she staying and what about, the better accommodation for her?
Please, please.
What is her age?
80 years.
80.
Recently, she has undergone heart
Your duty,
surgery, my lords.
it's a duty to take care of the mother, not that giving her some kind of unhealthy.
I'll just have better
Now
affidavit.
she is
ma'am.
living
The
under
respondent,
pacemaker, my lord.
it is submitted with the land counsel appearing for the respondent that the mother is staying in the cellar of the building where they have given accommodation to her and the entire third floor she is receiving the rents. The same was disputed by the land counsel appearing for the petitioner stating that in the cellar there would be water seepage and it is not well ventilated, and it denies the fact that the third floor rents she is not receiving. By the next date of hearing, the respondent shall file an affidavit before the court with regard to the accommodation that's given to the mother and with regard to the rents that are being paid and any other material in support of the same. Further, it is made clear that it is a duty of the children to provide a decent accommodation to the mother, and whatever are the steps that has to be taken by way of an affidavit that shall be stated by the next date of hearing.
Please.
Basing on that, the orders will be passed. When do
Please.
you want?
After vacation only, my lord.
This is matter after vacation has parted.
Please.
Number 19, 20 adjourned, 21. N. Sriram Reddy.
But this is the matter where on 22nd, your lordship had dismissed for 21st, it was called, there was no representation. On 22nd also, it was listed for dismissal. Lordship had dismissed it. Again, today the matter is listed. When the list came out to me,
No, it is not dismissed.
it was dismissed for DNB, my lord.
No. They've come and mentioned, they have come and mentioned about it. So I said, the court has no intention to dismiss the matters. We all only want it to be heard on merits. There is no representation with the this matter for dismissal on 22/4. I think on 22/4 it is, they have came and mentioned after that. So then I
The
said.
problem was that day evening when I returned the mail, the recalling was also not within, I'll have to go back and re-mail it to the department. And today again, there is
Again,
no-
I'll post it today. Today also there is no representation.
It
No
should be the same
representation on
order.
behalf of the petitioner. Where on the last occasion, when the matter was dismissed for default in the forenoon, a mention was made in the afternoon. And again, the matter was posted today. Today also, there is no representation. Tomorrow, list this matter for dismissal. Yes, next.
For dismissal, it will be listed.
Tomorrow.
Deeply applied.
22. Puttagowda K.
20.
Telugu GB.
22, I have been requested by the petitioner counsel for a passover. She just, Suvarna Lakshmi just informed me and went, my lord. She requested for.
Passover, yes, 23.
Cell number 23. Cell number 23. Nagarajas.
I'm appearing for the petitioner in this case. Kindly list this matter after vacation, your lordship.
They have already taken adjournments.
Senior is inconvenient and he has to go.
Let it be passed over, madam. They have already taken adjournment twice. It's a short question.
Your lordship, kindly have it on next, or at least on next week, your lordship.
I'll adjourn it, but I'll not extend the.
Senior
interim order.
citizen gift
When
deed,
other
my
side, when other side is insisting, you have to argue. 23 matter, you have the advantage of the interim order from the last 3 years.
ಏನು ಇಲ್ಲ senior citizen
Has
gift
to
deed
go-
condition
That's
ಇದೆ.
what I'm saying.
He has to go to Devanali, your lordship. He's in Devanali, your lordship.
Tomorrow, come tomorrow.
Tomorrow.
Yes, tomorrow.
Tomorrow.
He did not come to the court. Why should
ಅವ್ರು
he?
ಅಲ್ಲೇ ಅವ್ರ ಪಾರ್ಟಿನೇ ಅಲ್ಲ ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಅವರು.
Over
I am for
years,
the
but will
senior-
not come to the court. Yes,
He is not a
tomorrow.
party.
Number
I am
25.
the father of the family,
25.
and these people have blackmailed me.
Madam,
and
24.
taken all the duplicate, this thing, and they are going
Yes,
to sell
next.
my property without my permission. They have spoiled my
We
family.
will see. Your advocate is there. Yes.
Lord,
Tomorrow.
25, I'm appealing for the respondent.
Petitioner, your lordship. Petitioner, your lordship.
25, madam.
Canara Bank has to.
25, Lord.
24. 24. Your lordship, Canara Bank, no, council is present. The council who is displaying the name of the Canara Bank is trial court lawyer, your lordship. That's-
Yes, Canara Bank. So Vignesh Shetty, where is this Ramanand Achar? He doesn't come to the High Court?
Actually, your lordship, he is practicing at DRT.
DRT.
Yes.
I'll inform to the council and
He comes to the High Court?
I don't think so. Whether he's coming to High Court, I'm not seen.
Does this matter after vacation?
Please, Lord.
Or let him serve a copy for me, my lord. I'll inform the
I
branch.
already served copy.
Till number 25.
No representation on behalf of the respondent bank in 24. Record that. Yes, 25?
Till number
25,
25.
I'm appealing for the respondent
For
in this
petition
matter,
on my
my
lord,
lord.
my lord, one request, my lord, one-time settlement ready to pay, my lord.
Lord, one
Annexure
submission.
F and F2, F3, my Kannada version document, my lord. I read already in letter, my lord.
My lord, I would like to make
I read
one
to pay, my lord,
submission.
one-time settlement.
Let's, what is she saying? We'll hear.
My lord, in this matter, they have challenged the sale notice. Now the auction has been failed, the writ has become infructuous.
Yes. Please come. The writ petition is filed, seeking the following prayer. When counsel appearing for the respondent submits that the act auction could not be held for want of bidders. Hence, a writ petition has become infructuous. When counsel for the petitioner submits that they are seeking one-time settlement. If they're seeking at one-time settlement, they're always at liberty to approach the bank, and the bank will pass orders in accordance with law. In that view, the matter, the petition is, this court is passing the following order. In the light of the fact that the auction had not taken place and the writ petition has become infructuous. However, the petitioner is at liberty to approach the bank seeking one-time settlement, and the respondent bank can consider the same in accordance with law. Next.
Till number 26. Madhav Balaji.
Appear with the petition on this. Not in this matter, my lord, what has happened. But I take not a loan that comes to be, my lord.
What is questioned before the court?
My lord, question before the court is the action of the bank, my lord, in appropriating my deposit amount to a different loan account.
Direct the respondents to appropriate the sum of rupees.
My lord, that is the deposit made in the
With the
before the
petitioner.
DRT. They utilize for a different loan account, my lord. What, may I just explain the facts of the case? Your lordship, what has happened, you know, I have taken two loan accounts.
So why can't you ask to file the same application before the DRT? Why should you come here?
My lord, it's only because of the
No,
fact that it's
by
exceeding
virtue of an
jurisdiction.
order passed by the DRT.
Please, my lord.
According to you, they have appropriated that amount to a
Please,
different account.
Please, my lord.
You should be asked by the, you
Your
should
lordship
ask the
will see what
DRT.
I have issued a notice to them, my lord. They issue a response to that. Your lordship will see that annexure
Matter pending
capital.
before the DRT?
No, my lord, it's disposed before the DRT, please, my lord. What happens, my lord, before the
Yes, what do
DRT?
you say about this?
Lord, kindly come to my lord, page number 21. The letter, my lord, which I said before this honorable court, either, my lord, they would have given a representation to the bank. It is just, my lord, I said that it is an account become an NPA. My lord, I'll just point out, my lord. Letter dated 19/1/2026. Reply to your notice dated 24/11/2025, so and so, so and so. I given, my lord, how account become NPA. Initially, your loan account has been classified NPA on 31/8/2023. You are repaid 9,05,170 on 26 so and so, which is adjusted to your account with your Worthur branch number dated so and so. you have again repaid rupees 13 lakh rupees on dated so and so. Out of so and so, 50,000 rupees is adjusted towards the account with our branch dated so and so. Rupees so and so has been adjusted towards the account with the Club Road Koramangala branch on dated so and so. As on 31/5/2025, your account has become upgraded to standard status. After that, due to non-payment of EMI, again your account has been classified non-performing asset on 31/10/2025. The calculations are system generated and you can check the outstanding with your latest statement of account. Bank will initiate the appropriate action against surface and other action. My lord, here the bank indicated my lord tableau number 5 or my lord 5, the account become a NPA on my lord 13/10/2025.
26/3/2025. There is an order by the DRT.
DRT to deposit some money.
DRT proceedings are in respect of which account?
Not account bearing number, that is the account not before the Vartur branch, that is 248730100001304. Your lordship will see the DRT petition proceedings.
So in respect of that, when they pay a certain amount,
Please.
in respect of a certain proceedings arising out of a particular account, how can you do
No, my lord, either my lord, the subject properties, my lord, kindly come to page number 45. I think my lord, that is the one, I have to take instruction on that effect, my lord, maybe not to take a record.
instructions? Simple, very simple issue.
I understood, my lord, what my lord
That
is.
too, as pursuant to a court order, an amount is paid. Then it has to be apportioned to the particular account. But can't through some other, whatever, he may be having 101
I'll take an
accounts.
instruction, my lord, have it
Yes.
tomorrow or Monday.
Then counsel appearing to the respondent bank shall give specific instructions with regard to the amount that is paid by the petitioner pursuant to the orders passed by the DRT. Yes.
My lord, they're not willing to take possession, my lord, of my property. That
Tomorrow.
No, so far it is not even.
No, they have
Tomorrow
issued.
I'm taking tomorrow.
Please, 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 please,
Grateful.
please. Grateful, please.
Matter, serial
Much
number
obliged.
27, 30 case.
Lordship, I'm appearing for the petitioner in this
Waiting for
matter.
respondent 3, your lordship.
At the outset, I apologize, my lord. Yesterday, I could not appear in the matter.
Yes, yes.
I'm grateful for.
Our court is happy that you have appeared today. Yes.
But the petitioner is a inspector of police against whom order by the Human Rights Commission was passed, my lord, at Annexure A. And the review order at Annexure A1 has been.
Direction quashing the order passed by the respondent number.
The Human Rights Commission order as well as the review order is what we have sought for quashing in the present petition. I'll briefly narrate the facts. The petitioner was working as a inspector in the Mysore Rural Circle. There were 8 FIRs that were registered at the time against
sub-inspector.
Against
No.
the complainants.
By him.
Complainant is the wife of the person who's allegedly been tortured. So against him, there were 8 FIRs registered, all for chain snatching. All these 8 FIRs, all for chain snatching. There was a gang that was operating in Mysore who would snatch the chains, then go to the respondent's husband's shop and sell it illegally over there or deposit with him. In all the cases, the FIRs that have been registered, as of today, in the page number 51 has the full list of the FIRs. In all of them, the gold that was.
Who is the complainant before the Human Rights Commission?
The wife of the person.
Shop owner.
Wife of the shop owner. All of these
The
matters.
shop owner is the Chinese national.
Pardon, Mala?
The shop owner is a Chinese national.
No. Chain snatcher.
Chain snatcher.
Chain snatcher. He has in 8 different occasions, all these different, how this gang would operate is different persons at the same time would operate in coordination. They would snatch the chains and all of them would meet at a common point, collect all the snatched chains and deposit it with the husband of the complainant. All of these matters, in all of these matters, the police have recovered the chains and the complainants through which the FIR came to be registered, all of them have also recovered these chains. Trial is still going on. In 7 of these matters, charge sheet has been filed. It's still in the trial
What is the
stage.
complaint before the Human Rights Commission?
Complaint before the Human Rights Commission, my lord, is that the petitioner and a few other policemen went to the shop of the complainant's husband and has taken him illegally from his shop and have beaten him and subjected him to third-degree torture in the police station. That complaint was raised. In the complaint,
Complaint was dated
the
28/7/2018, my lord. 8/7/2018.
2018. When was the incident taken place?
The incidents vary from 2017 and 18
2017?
and 2018. my lord. The
Okay, when is the latest incident?
latest incident was regarding this particular FIR was in July itself, July 2018.
June, my lord. In the FIR, it is mentioned June.
So now after, what did you do? Was he arrested? The husband of,
He was arrested and then subsequently released on bail. In the order sheet is also produced. my lord.
he was taken to the magistrate.
He was taken to the magistrate and in the,
And before the magistrate, did they say so?
no, that is one of my contentions. Before the magistrate, when asked whether he was subject to any ill treatment, he has
Nothing-
specifically said
nothing
he
has-
is not
nothing
subject
has
to any
been
treatment.
stated. Then,
One of the other grounds I'm urging a lot is that the petitioner and two other policemen were found to be guilty of third-degree torture by the Human Rights Commission. And when they went on review, the two other policemen, the charges against them were dropped. The
so
human rights
what is found by the Human Rights Commission against you?
against the petitioner is
Is it in English or Kannada?
It's in Kannada.
All in Kannada.
Kannada.
I appear for the first respondent, human rights. My lords, on 28/7/2018, he was taken, the complainant's husband, the third respondent's husband, he was taken by the petitioner and he was subjected to third degree in the police station. All the medical report is also produced by the respondent herein. And they also say that it was assault and he was beaten. I have also produced, my lords, color photos are not there, but I have got these photos. It will
No.
be- Yes,
Human Rights Commission is next.
yes.
He was he was taken to the magistrate on inquiry by the magistrate.
Not that, my lords. There are two occasions on some other, on 13/8, yeah, on some other date also. He was not taken to for inquiry. They take him to another room and he demands gold from him, the petitioner, and he was again tortured and then he was produced. It is not immediately he was taken. That is what is the contention before.
So according to you, apart from the incidents which were narrated here, there are on other occasions he was taken.
He was once on 28/7/2018.
And what is the material before the commission?
Medical reports are there, my lords, and his photographs, what he was subjected to, and there is a complaint also which was, and my lords, there was an inquiry held by the commission, DYSP, on this. A report was submitted. My lords, because my inconveniences, they are all in Kannada.
What is
On
the
Monday, I
DYSP?
can.
What did the DYSP say?
My lords, they have submitted sent to the DYSP commission directing an inquiry to be conducted on and a report to be submitted on this, and accordingly ADGP, my lords, of the commission has submitted a letter dated 2/8/2019 enclosing DYSP's report with attachments, that is medical reports and all. And on examining DYSP's report, it was found that on 5 PM on 13/8/2018, personnel discharging duty under Mysore South Circle, CPI Karim Router, that is a petitioner, my lords, and complainant's husband Mohammed Hafiz were brought from his house and produced before the CPI. And the CPI investigated Mohammed Hafiz. This is what they have given the report, and there was a third degree torture. And other two were, review was filed by them. Then the inquiry commission was, again, the review was heard, and they came to conclusion that they were not there at that time. Therefore, my lords, they were only produced. They asked and they were also produced. But those CPM constables, my lords, they were not involved. Only this petitioner was involved.
They brought him to the place, but he bet him. No,
Yes.
It is because he has not assaulted the person, then his review petition is allowed.
He has not, actually, he just, when we was asked to bring him, he took him there. That's all. Otherwise, he was not, because what happens, my lords, again, on 13.
Yes, this is smart application. This next. Delete from the caption for dismissal. This 28.
Case number 28. Case number 28.
Annexure B, my lord, is under challenge.
What is annexure B?
Endorsement, my lord.
Huh?
Endorsement, my lord, it is issued, it
Endorsement
is civil in
stating?
nature.
Your Lordship, the interim order is to be extended.
Intermodal grant. Yes, 28.
Page 20, my lord, that is the endorsement.
Directing the respondents 2 and 3 to protect the property of the petitioners.
Yes, my lord.
In pursuance of the complaint dated 10/3/2023. What is this prayer?
Yes, my lord, civil in nature. They have to remove the board which was put up in the petitioner's
Huh?
property. They want to remove the board which was put up in the petitioner's property. It is civil in nature, my lord. Endorsement is issued, that is challenged before this court.
And they don't even ask to register the complaint.
Yes, my lord.
The writ petition is filed seeking the following prayer. A writ petition cannot be filed seeking a prayer of this nature, where the court cannot direct the respondents to protect the property of the petitioners in pursuance of the complaint dated 10/3/2023. The petitioner's remedy is elsewhere. When the matter came up yesterday, there was no representation on behalf of the petitioner. Today also, there is no representation. The matter is listed for dismissal. Today also, in spite of the fact that the matter is listed for dismissal, today also there is no representation. Accordingly, the writ petition is dismissed as not maintainable, and this court cannot grant such a prayer.
Case number
Yes.
29.
This matter, my lord, we have issued an endorsement, my lord.
Take that.
The petitioner has given a complaint against the daughter, my lord. Notice was issued.
Who?
Petitioner has given a
Take
complaint
what
against
is
the
it
daughter,
for
my lord.
music?
Acting on that complaint, my lord,
Tell him. Yes.
the notice was issued, my lord. And the given statement, my lord, it is a family dispute. We will settle the dispute before the competent court, my lord. Recording that statement, my lord, the endorsement has been issued. And
So
same
the
has been
link
forwarded to the
that is
petitioner
sought
also.
is consider the complaint filed by the petitioner and take appropriate action.
Yes, my lord. Acting
Now
on
you have
the,
issued a endorsement stating that it is a civil dispute.
no, my lord, acting on that complaint, my lord, notice was issued to the daughter of the petitioner because the complaint is lodged against the daughter. Lord, she gave a statement that it is a family dispute. We will settle the dispute before the competent court, my lord. Recording the statement, my lord, the endorsement has been issued. That was accepted by the petitioner himself, my lord.
Who is saying? The present writ petition is filed, seeking the following prayer. The matter was listed on the last occasion as there was no representation. The matter was actually listed today under the caption for dismissal. Today also, there is no representation on behalf of the petitioner. Leonard HCGP appearing on behalf of the respondent submits that the mother has given a complaint against the daughter. The police have,
Father.
father has given a complaint against the daughter, and they have issued a notice. On receipt of the notice, the daughter has appeared before the police and has given a statement that they will settle the dispute between them before the family court and civil courts. Recording the statement of the petitioner's daughter, the respondents have issued an endorsement dated 7/4/2023 stating that the complaint is closed on the basis of the statement given by the complainant's daughter. It is submitted that hence nothing survives for consultation, considering the fact that already an endorsement is given and the disputes are civil in nature. There cannot be any direction as sought for by the petition, the writ petition, according to dismissal. Yes, 30.
Case number 30.
Yes, sir, petitioner in this case, Lord.
Yes, sir.
Lord, in this case, Lord, the petitioner questioned the demand notice dated 4/12/2024 issued under Surface Act, Annexure C, page 21, Lord,
Yes.
31. Lord, originally the loan has been awarded by one Meena on 25/3/1998.
Have you given your response to 13-2?
Pardon me?
Have you given your response to 13-2? Why should you come here? You should tell the bank whatever you want to
Lord,
say.
that, invoking the provisions of Section 3, the Surface Act itself is not maintainable.
No, that you can tell them. If you tell them, they will withdraw it. If they don't do it, then you can come.
But because that notification itself is very clear, my lord. For that reason, I filed the writ petition, my lord. Kindly see.
Why have you taken this pains of coming to the court and waiting here from 2024?
Lord, there is an interim order has been granted, my lord. Kindly
Whole
see.
problem, no.
Kindly see the notification, my lord.
No. By this time, the same notification, mentioning the same notification, have you given a reply to them under 30?
But they are not considered, but because
Where have you-
the reason
where
that I
have
have
you
not
given-
given the reply, reason is this, my lord. The loan has been sanctioned in favor of one Meena in the year 1998.
Where is the reply? Where is the reply you have given to them?
But reply I have not given, but I am not the borrower. The originally the property, the loan has been availed by one Meena on 25/3/1998. Thereafter, she has passed away. During her lifetime, she gifted this property in favor of her daughter. So thereafter, I purchased this property. After a lapse of 26 years, the demand notice has been issued. No. The originally loan was sanctioned on 25/3/1998. The demand notice was issued on 4/12/2024, Annexure C, page 31. But considering that only this court has granted the interim order. For last occasion, because of his non-appearance of before this court has adjourned for today, my lord. And also this, the provisions of surface is not applicable because the amount is only, Lord, kindly see Annexure C, page 31.
What is, how much is the amount?
Lord, Annexure C, page 31, Lord. Demand notice there. Loan availed by this one original Meena is only 2 lakhs, Lord. Page 37, page 31. The amount is mentioned at page 34.
This is matter as first matter on the top of the list tomorrow. No representation on the last occasion, this today also on behalf of the respondent. Heard the counsel for the petitioner for dictating orders. First matter tomorrow. Top of the list. Yes. Delete from the caption dismissal and post it for dictating orders.
Caption dismissal, but some errors are in the, I am coming regularly. Last occasion and this occasion also.
It is deleted now. Tomorrow it will come for dictating the orders.
Much.
List number 2, for orders matter, serial number 1, it be Somapur. K. Srinivas for Adjournment.
What is this mediation report? Who moved the memo?
It was referred to the legal.
Huh?
It was referred to the legal.
Correct. Why you moved the memo? You moved the memo?
I have moved the memo, but it is this, because it is the petition is dismissed in the trial court. Petition, when the matter is dismissed to the trial court, may not be compromised to the court unless and in the local adalat. So that it is better to be referred to the court. I asked the legal board.
Where is the counsel for the respondent? Tell him, ask him. Yes, too.
As day 1 week's time. Next week.
Then why should you move a memo?
Next week, man.
Why you moved a memo? There should be some reason, isn't it? This is matter after vacation.
Serial number 2. Serial number 2, Gurdev Prasad KT for appellant. Swami.
Yes, what is this correction?
In the judgment dated 6/11/2025.
Yes.
At para 4 of the judgment, the argument of the learned insurance company advocate is that in view of the new act, the pay and recovery concept is not applicable. And subsequently, I filed an application for being spoken.
What do you say?
Yes.
My lordship, a similar kind of issue, my lordship, pending before division bench on apex court, my lordship.
But this subsequent order dated 15/12/25.
That order
has
is
not come in
recalled,
the
my lordship.
original order. Recalling your lordship has passed the order to recall the earlier order. That portion has not come in the earlier order. That is my submission.
When it has come? At the judgment date, it is recalled. After the issue is decided by division,
Correct.
when the appellant can move this matter.
That has to be come in the
No,
original
what they
order.
do is, there are 2 ways of it. Only this will be uploaded.
Yes.
Then that is sufficient.
But in the original order, that has not been mentioned.
This is such a simple issue. You could have asked again for that. Why?
Unless in the original.
This is why it is not corrected in the order. Appellant can move this court. That's what I said. We'll see. Send it to the chamber. We'll see. Yes, next.
Cell number 3. Cell number 3. K. Suresh for appellant.
Yes, Mr. Suresh. Yes. Call him.
Sir Suresh, sir.
Cross objection copies to be received, Your Lordship. We are unable to.
2012 matter, cross objection copy, now you want. What will be there in that cross objection copy? You can argue the matter itself. Pass over.
Cell number 4.
WhatsApp him that copy.
Not us. We represent R1 and R2.
R1, R2 is?
It's the wife and daughter
Yes.
of.
Next.
There is difficulty with because the cross objection copy we have also not received.
Yes, next.
Cell number 4.
Then even if it is not received, it's fine. Yes, 4.
My lord, I'll appear, my lord, it may kindly be passed over. It may kindly pass over, I'll do.
Yes. 5.
Cell number 5. Aegis Raike.
Presenting respondent, my lord. Claimant appeal for enhancement, my lord.
Appearing for appellant.
Take that.
Trial court has.
It's a case of death or injury.
Injury, my lord.
Injury, my lord. The trial
Come to
court
the
has-
chart. Come to the table.
Table, take it. Table.
What are the injuries?
My lord, the crush injury to left hand with the total.
Para 12 page 6 may kindly be looked into, my lord.
Para?
12 page 6.
Has a sustained crush injury of left hand
Yes, my lord.
with total amputation of thumb and
Thumb
middle
and
finger.
middle finger.
Left humerus fracture.
Yes.
With the petitioner 60%. Pain and agony. It has to be enhanced.
Please, ma'am.
How much? Yes, Mr. Venkatesh.
My lord, 55,000 is already granted now. For one fracture, 40,000 and remaining is 15,000 additionally.
Crush
Also.
injury to amputation of 2 fingers. Humerus
Another
fracture.
10,000, my lord.
Altogether, how many fractures now?
No, fracture is only one, my lord. Amputation of finger is only
Finger,
the
2
issue.
fingers. Yes, 55 is granted. We'll
Please.
grant another total 80,000. Yes, next. How many days was in hospital?
7 days, my lord.
17 days, my lord.
17, 7 days.
Two.
We'll grant 17,000. Medical expenses as it is,
It's granted, my lord.
1,27,152. Then coming to the loss of income during laid up period, how much is taken?
My lord, as per chart, 7,000 should have been taken, my lord.
How much is
But
taken?
learned judge has taken 8,000, my lordship. There's-
Your appeal is there.
No, I am not in appeal before this court, my lord.
Let's continue that.
Please.
So, how many months it is given? Not given. During laid up period, only 10,000 is given.
Also.
So, court has taken 8,000,
Yes, my lord.
24,000. Because conveyance, rest nourishment, for total altogether 22,000 is given, but we are granting only 17,000. Then coming to the loss of future income. What is the age?
He is aged about 28 years, my lord.
What is the disability according to the doctor? 67%.
67% to the limb, my lord.
Court has taken?
MESCT has taken 10%, my lord. It is true, my lord. There is a percentage is less. 21% it comes to my, 22% it comes to my lord.
It's coming to 22%.
Please.
8,000 into 12. What is the multiplier?
17, my lord.
17 into 22 divided by 100. It comes to 3,59,040. Loss of amenities, how much is granted?
Amenities,
30,000, my lord.
30,000 is already granted, my lordship.
That is reasonable.
That is reasonable.
Next, loss, any future operation or anything?
No, nothing as said by the doctor, my lord.
There are future medical expenses are already granted.
Yes, my lord.
15,000, that way will continue. Disfiguration, marriage prospects is also granted.
Yes, my lord.
It comes to 6,92,192 against 4,52,352. Please come.
My lord, one submission. Interest granted learned MACT is on higher side, my lord.
How much is granted?
8% is granted, my lord.
6% will.
Please, my lord.
Agreed with the award passed in MLC number 770 of 2012, dated 25th October 2013. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. Extract. Then counsel appearing for the claimant submits that when the claimant had sustained amputation of 2 fingers, a crush injury, amputation of 2 fingers, and also femur fracture and the head of pain and suffering, the court has not granted a reasonable compensation and the head of pain and suffering. Coming to the loss of future income, and the doctor has deposed that the disabilities that is sustained to the whole body is 67%. The court had taken only 10%. Further, on the head of loss of income during the later period, court had granted only 10,000. Further, on all other heads, the compensation that is awarded by the tribunal is not reasonable. Next part. Then counsel appearing for the insurance company submits that the court has granted the interest at 8%.
Yes, my lord, 8%.
Which is on the higher side. And further, it is submitted that on all the counts, the court has already granted compensation on the higher side and no interference is called for. Next, having heard the counsels on either side, there is the material on record. Under the head of pain and suffering, considering the crush into the amputation, the crush injury and the amputation of 2 fingers and also a fracture, this court is granting 80,000. He was in hospital for 17 days. Under the incidental expenses, this court is granting 17,000. Medical expenses, the court has granted the same as per the evidence and no interference is called for. Coming to the loss of income during the later period, the court had taken the income at 8,000. Considering the injuries for a period of 3 months, this court is granting 24,000. Coming to the loss of future income, when the doctor has deposed that the limb disability is 67%, the court without any basis had taken 10%. Hence, 1/3 of that would come to 22%. Hence, this court is taking disability at 22%. 8,000 into 12 into 17 into 12 by 100 is 3,59,040. Coming to the loss of immunities, future medical expenses, disfigurement and marriage, the court has already granted reasonable compensation. No enhancement is called for. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,92,182. Accordingly, the appeal is partly allowed, enhancing the compensation from 4,52,352 to 6,92,192. The entire amount shall carry 6% interest. Yes.
No place.
Yes, next.
Cell number 6, Rajaram R.
Paso. 7.
7. Cell number 7, Prasanna DP.
For R1.
And for the appellant in this case, the owner's appeal challenging the liability matter. The tribunal has fixed the liability on the owner, even though he was not the owner on the date of accident. The accident.
The document is transferred by the date?
No, my lord.
Your
Then-
lordship. Your lordship,
Document is not transferred to my name, my lord.
Not, no, that's what I'm saying. That is in the name of the,
Some other person, my lord. My previous seller, my lord. Document is standing in the name of the my seller, my lord.
what is that, Mr. Ravi Samprati, what is that judgment on that?
Yes.
Ownership is not transferred.
Registered owner.
In the event it is the registration certificate is not transferred. The,
In whose name it stands, he is liable.
He is liable to.
That's the my case.
You are who?
I'm
You
for the
represent who?
claimant.
Huh?
Claimant.
You're for the claimant. And what about that owner? He is there, he is represented?
Yes, your lordship. Your lordship, what had happened? The accident took place on.
No, that no issue with your, this thing. Where is the other, is he served?
My lord.
No,
The owner in whose name the
No,
property?
they have not made him as
They
the
have not
party at
made
all.
the party.
Who appears for the, you appear for the claimant?
Claimant.
Then we'll remand the matter.
MU Punacha for R2. Punacha.
Yes.
That counsel.
The R2 is who? You are representing Punacha.
No, your lordship. R1, Prakash MH.
R2 is who? Insurance company.
Insurance company, my lord.
The present petition, the present appeal is filed, agreed to the orders passed and appeal is filed with the petitioner. Appeal is filed. by
I
the
pay for the second respondent.
Who is the
I pay for the
alleged,
second. Sorry.
who is the owner of the, owner of the offending vehicle? I told you, MVC number 2255/2007 dated 10th January. Appeal is filed by the alleged owner of the so agreed by the order passed in MVC number 2255/2007 dated 10th January 2014. It's a case of the claimant that on 17/2/2007 at about 3:55 a.m. The claimant was proceeding in the vehicle as in a goods tempo as a loader and unloader. The vehicle was proceeding on a Bangalore-Kolar road. The driver of the vehicle, by driving it in rash and negligent manner with high speed, lost control and dashed towards the tree, which was on the left side of the road. The vehicle was fully damaged and the claimant suffered serious injuries. The tribunal has said that your respondent number 1
Yes, please, ma'am.
before the tribunal.
Before the tribunal.
The claimant,
No,
the
respondent number 2, my lord, before the tribunal. Insurance.
you are expert.
No, my lord, I have contested the matter, and previously also it was once remanded to the trial court, my lord. Again, the trial court.
Based on service of notice, initially respondent number 1 alone appeared and filed written statement denying all the allegations made in the petition. Respondent number 2 had remained ex parte.
No, my lord, I have contested.
Again, that was appealed before this court, your lordship. Then it was remanded saying that he didn't have a sufficient opportunity to.
Then what? Where is the next order?
Then
That
it was
order is the
again.
question.
That's
It was
the-
remanded back, and it was again contested, your lordship. In that phase of time.
No, this order, in this it says that he is ex parte.
Yes.
He's not referring to the earlier order.
Please.
Initially the petitioner, initially the respondent, the owner of the vehicle, the appellant owner of the vehicle has remained ex parte. Thereafter, MFA number 7/669 of 2009 was filed before this court, and the judgment was set aside, and the matter was remanded back to the court. There is no, the court has observed that in the written statement it is stated that the insurance policy has been issued in respect of the offending vehicle and the same was in force as on the date of accident. The case was the claimant was traveling in a goods vehicle as gratuitous passenger and policy does not cover the risk of such gratuitous passengers. As such, the court has fixed a liability on the owner of the vehicle. According to the appellant herein, he is not the owner of the vehicle. As on the date of the accident, the vehicle stands in the name of one
Hindu.
One Hindu, my lord.
Sindhu.
Sindhu.
Name of one Sindhu. as he is the registered owner of the vehicle, the petitioners ought to have, the claimants ought to have impleted them. And in the light of the settled law, he cannot be made liable to pay the compensation. It is an admitted fact that the said Bindu is not a party to the proceedings before the MSCT. And counsel for the respondent claimant does not deny the fact that the said Bindu was not impeded as a respondent in the claim petition. In that view of the matter, this court is of the view that the order, the award needs to be set aside and the matter has to be remanded to the court. Accordingly, the court has passed the following order. The award dated so and so, passed with MACT dated so and so, is set aside and the matter is remanded back to the MACT. The claimant shall implead the owner of the vehicle, they implead the registered owner of the vehicle, one Bindu, as party respondent to the claim in the party respondent. This case is of the year 2007. The trial court shall give priority to this case and shall dispose of the same as expeditiously as possible, and even that the record shall be sent along with it forthwith. Yes.
And amount deposited, permit me to
Amount
withdraw the amount.
deposited, it shall be sent back, or you want to withdraw?
Withdraw, my lord.
The amount in deposit shall be withdrawn by the owner of the vehicle is permitted to withdraw. Where is it? Here you deposited, or?
Here, my lord.
Is permitted to withdraw. Yes, after the.
Anita madam. Anita madam. ಇದು ನಾಳೆ ಇದೆಯಲ್ಲ ಸಿಟ್ಟಿಂಗ್
ನಾಳೆ ಇದೆ.
ಅನಿತಾ ಮೇಡಮ್ ಪಾಸ್ ಅವರ್ ಎಷ್ಟಿದೆ?
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಏನಾಯ್ತು ಮೇಡಮ್?
ಅನಿತಾ ಮೇಡಮ್ ಪಾಸ್ ಅವರ್ ಎಷ್ಟಿದೆ?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಏನಾಯ್ತು? ಸೀರಿಯಲ್ ನಂಬರ್ 6
ರಿಮಾಂಡ್ ಆಯ್ತು ಸರ್.
ಅಲ್ಲ 6.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಏನೋ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಓಮಹೇಶ್ ಅವರು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14. ಮೇಡಮ್ ಅವರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಏನೋ ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್. Court officer?
Your Lordship, one submission. The previous matter, second is seventh matter. A time bound may be fixed so that because it's a very old matter.
Expeditiously.
Within 3 to 4
Problem
months.
is like, no notice has to be served on
Please,
him.
Your Lordship, because the matter is very
No,
old.
that's what I said, 2007, as expeditiously as possible.
Please, please.
Pass over. 20? How many passovers are there in the first? Huh? Only one passover. Yes.
I appear for the petition.
20?
I appear for the respondent, Lord.
Yes.
But, on the last date of hearing, your lordships directed me to file translated copies.
Yes. What is the writ petition about?
My lords, Annexure L is under challenge, my lords, whereby the respondents have imposed a penalty on the public information officer, who's the petitioner herein, to the extent of 10,000 rupees for not providing information. My lords, the application herein, my lords, was made by the third respondent. Second respondent. My lords, on 18/12/2021. This was under section 6 clause 1 of RTI.
Yes, yes.
My lords, for asking for approval and power sanction to one Sonin developers. My lords, then I communicated through Annexure B on 14/1/2022, which is within the period of 30 days, that, my lords, please provide the RR number. If your
No,
lordship
for asking that, why will you require for 45 days?
My lords, at that particular point of time, we have looked through the records, my lords. There was nothing registered as Sonin developers. My lords, what is forthcoming from the records is
18/12 to 14/1. That is how many days? Less than 30 days.
Please, my lords.
What did you tell him?
I'm sorry, my lords, to intervene. The application is dated 30th of November 21. Endorsement was given. Yes, at Annexure A. And the endorsement was given on 14/1/22, my lord. That is beyond 30 days.
No, my lords. Your lordships can kindly take my lords annexure A, page number 15, 18 December 2021. The application date might say anything, my lords. He submitted it on 18 December 2021, which is not disputed.
18?
18/12/2021.
Yes,
Date
so-
of application might say 30/11/21, but he submitted it on 18/11, 18/12.
No, basing on what you're saying that.
My lords, the acknowledgement at the bottom, my lords.
Have you seen that, page 15?
My lords, I have seen that. Now I see that acknowledgement also. Lords, but however, the application dated 30/11/2021.
Then in that case, it is less than 30 days.
Yes, it would be less than
Then
30
we have
days.
to set aside that order.
Lord, thereafter, my lord, the information was provided much later. Even if the endorsement is concerned, endorsement, what they say is, they give an endorsement calling upon the applicant to provide the RR details. That's all the endorsement. Information was not provided. Thereafter, the applicant was driven to file the first appeal. My lord.
The petition is find fault with, on what ground? On the ground that
My lord, not only
application is
this.
stated- Huh?
Not only this. Thereafter, what happens, my lord? Information was provided, my lord. It was provided, my lord, only on 10th of May 2022.
10th May 2022.
2022.
When was the information provided by the applicant?
My lord, information was not provided by the applicant at no point of time. What happens, my lord? Endorsement was given by the petitioner calling upon the applicant to provide the RR details. It was not provided by him. Thereafter, the applicant would approach the first appellate authority. The first appellate authority, my lord, on 8/3/2022, passes an order directing the petitioner herein to provide the information. That is on 8/3/2022. It's only thereafter the petitioner herein would make efforts to get the details of the zoning developers, and thereafter he provides the information only on, my lords, on 10th of May 2022. At no point of time, my lords, the second respondent gave the RR number or any other details.
So from the date of order is on 8/3/2022.
But if
the information-
if the date of application is taken into consideration, my lords, application,
So
this
then if that-
exercise could have been,
No,
this
no, if that
exercise
is the
perhaps
case-
could have been, my lords.
So we'll set aside that order.
Lord, I leave it to the court, my lord. I represent the commission. I'm for the
Yes,
first respondent.
Yes. Where is the order?
It's annexure
Translated copy of the impugned order.
L, my lords, at page number, commences at page number 19.
Page number?
19. Dated 29/9/2022.
This is impugned.
Please, my lords. That's one more point, my lords. I have produced annexure M.
Let me read
Please.
this. The date is shown as 17/12/2021. The appellant has filed an application seeking information on 17/12/2021. Where from this date has come? Or there's something wrong with the translation?
Translation is right, my lords. He is written it in the main order as well, even in the vernacular language. That is what is mentioned. In fact, there is no whisper about my reply. What justification I have given, not a single line has been extracted.
And what else you're saying?
My lords, if your lordships in the same memo, my lords, takes annexure M,
Page number?
27. The very same, my lords, applicant made an identical application regarding power sanction. Even here, our reply was that you provide us the RR number. When he went on appeal, the same reply is considered and no penalty is imposed.
Please come. The present writ petition is filed, seeking the following prayer. The facts of the case are the second respondent herein has filed an application in section 6(1) of the Right to Information Act, seeking information in respect of approvals made and power sanctioned, accorded for power sanctioned to Sonin Developers LLP projects, 22nd Main BBMP, Ward number 187, JP Nagar, 5th phase, Bangalore, along with all the supported documents. The application was made. The application, though stated as 30/11/2021, but it is submitted only on 18/12/2021. Pursuant to the said application, as with the said details, the information cannot be provided. Requested the second respondent to provide revenue register number, and if the second respondent is not satisfied with the complaint, he can appeal to the third respondent by communication dated 14/1/2022. Then the second respondent has appealed before the third respondent on 11/2/2022, stating that the reply of the petitioner is misguiding and information is not provided. The third respondent, pursuant to the appeal, by communication dated 8/2/2022, requested the second respondent to visit the office on 4/3/2022 at 3:30 p.m. for looking into the matter. Thereafter, the third respondent, pursuant to its proceedings stated 4/3/2022, communicated that the petitioner shall provide the information as sought for by the petitioner dated 8/3/2022.
Sorry, that date might be wrong, my lords, from my end. Typographical error from my end. 16/12/2021.
14/1. It's not 4/1, it is 4/3. 14/1/2022. As sought for by the communication dated 14/1/2022. The petitioner, in furtherance of the communication dated 28/4/2022 to the third respondent, transferred the application of the second respondent for approval of the file in the name of one Ravi Kumar and others, within brackets Sonin Developers, and for providing information. Subsequent to the approval of the third respondent, the petitioner, by communication dated 10/5/2022, provided the entire set of documents pertaining to the information sought. The second respondent, however, approached the appellate authority under section 19(3) of the Right to Information Act, complaining about the information not having been provided by the petitioner. A notice was issued on 21/7/2022, summoning the petitioner to appear before it on 16/8/2022 at 11 a.m. The petitioner appeared and submitted that there is no dereliction of duty, but it is the grievance of the petitioner that without considering the explanation provided by the petitioner, the first respondent herein by its order dated 16/8/2022 imposed a penalty of ₹25,000 upon the petitioner on the ground that information provided by the petitioner was not in time. Agreed thereby, the petition is before this court. Learned counsel appearing for the petitioner submits that though the application is dated 30/12 30/11/2021. What is that?
30/11/2020.
30/11.
That's correct, my lord. Yes.
30/11/2021. But the same was given to the petitioner on 18/12/2021. And immediately on 14/1/2022, the petitioner has sought for certain information, has sought for the RR number, because without that information cannot be given. The counsel submits that without giving the said information, he has preferred an appeal. And finally, the information sought was given. However, on the ground of delay, now the cost is imposed by the first respondent without even considering this fact and considering the date that is mentioned in the petition, the first respondent has imposed the cost. It is submitted that the said order of the first respondent is contrary to the facts on record, and the order needs to be set aside. When counsel appearing for the first respondent submits that the first respondent, considering the fact that there is delay in giving the information and considering the fact that an application that's filed in the month of November was finally information was given in the month of May. And as per the act, the information is supposed to be, it has to be given within 30 days, has imposed the cost of rupees 25,000. And there is no illegality with the said order. This court, as having heard the counsels on either side, peruse the order passed by the first respondent. In the order, it is categorically mentioned that the applicant had filed an application seeking information on 17/12/2021, and as per the rules, the information should have been provided within 30 days, but the information was provided to the appellant after 120 days. Considering the point seriously, and by considering that respondent has deliberately delayed in providing the information, in exercise of the powers conferred under Section 21 of the Right to Information Act, the first respondent has imposed a penalty of rupees 10,000. A bare perusal of the order impugned reveals that the first respondent has failed to consider, having observed in the order that the petitioner has sought for information, and without furnishing the said information, an appeal is filed, and also without considering the fact that the application is dated 18/12/20 or 20, has only considered the fact that it is beyond 30 days and imposed the fine. In the considered opinion of the court, the order impugned is passed without appreciating the case of the petitioner and the facts of the case, the submission of the petitioner as well as the facts on record. When the petitioner has asked the applicant for the details, and as he failed to furnish the same, and the first communication that is given by the petitioner is within 30 days from the date of application. On all these grounds, the order impugned cannot be sustained accordingly set aside, and the writ petition is allowed.
Grateful, madam.
Grateful.
Serial number? Yes. Yes. You're on what ground?
This is a collision between RE and the car. The occupant of the car died. The policy issued in respect of the car is an act policy. Therefore, the insurer is not liable to pay the compensation. That's the ground.
What is the law on this with regard to this act policy?
Act policy does not cover the occupant of the liability of the occupant of.
No, there is a Pending. No, that Delhi High Court order, after that it is some,
This court has also taken the view, my lord, but the same matter is referred to a larger bench before the appeals court.
no, might be. Let them decide whenever they want to decide. What is referred to the larger bench? What is the position?
Delhi High Court says that when a company is liable, that is under the.
That's what, after Delhi High Court's order, you have issued the communication to all the companies.
Subsequently,
Other coverage, it is not the occupants of the car. It is act policy, it is a private.
No, what was that issue?
and,
1 minute, what was that issue?
What is that?
Basing on the Delhi High Court's order, you have
Challenge
so,
before the Supreme Court.
That is pending before
That
the
is
appeals
the
court.
only pending before the court.
any stay is granted.
Yes, sir.
It is.
Huh?
It is granted.
When is it?
So we are taking the time on that ground only, my lord. Several matters are.
When is this 2012 appeal
Yes.
2004
and
actually.
MBC of 2005? So unfortunate.
And one other ground, my lord, one other ground is also that there was a parked lorry in the middle of the road. It was parked without indicators, and that this Maruti van went and hit the parked lorry, and the liability or the contributory negligence ought to be fastened on the Maruti, instead of the Maruti van, it ought to be fastened on the lorry.
That's your appeal.
That's the additional ground raised by the insurance company of the Maruti van. I am for the owner of the Maruti van, cross objector. I'm sailing with them, that is the insurance company. I'm saying that the lorry ought to be held liable.
Who appears for the lorry?
Insurer appears, but
Who is the
owner is
insurer?
served, Ashok Patil.
Where is he?
Appearing for?
No, we will fasten the liability on the lorry and dispose of these appeals. Yes, what do you say?
When we see the appeal grounds, what they have urged is that it is an act policy, therefore they are not liable.
Yeah, that is one ground.
Yes.
No,
There
where
is
the
no other
accident.
ground not except that.
Uh-huh.
There is no other ground except that. The FIR and the charge sheet is on the driver of the Maruti van.
But in the criminal case, he is acquitted. My lord. The driver of the Maruti van, in the criminal case, he is acquitted of his offences charged.
Who is the claimant?
My lord, claimant, my lord, they are.
We appear for claimant, wife and daughter of the deceased.
Deceased.
Who is the inmate of the car?
Inmate of the
Yes.
No, is it that ground taken that because the vehicle is parked on the road without parking lights, it has happened?
The insurance company has taken
Not ground, he not here. It should be the case of the claimant before the tribunal.
No, ma'am.
No, my lords.
That's not. Then how can the insurance company take that now?
In the first instance, they have filed the claim petition against the owner and the insurer of the car. Then they got amended the claim petition, adding the owner and the insurer of the lorry also.
Oh, that is.
That's how they have
yes.
come to become parties, my lord.
Then what is the finding on that? Has the court considered that aspect?
And then court held that, the tribunal held that it is only due to the rash and negligent driving of the
At what
car.
time the accident has happened?
12 in the midnight, my lord.
At 12 p.m.
Midnight.
12 a.m.
12 a.m.
Is it the fact that the vehicle was parked on the road?
No, ma'am, it was on the left side of the road. That's 15 minutes.
Whether
Yes.
left side of the road, you
Extreme
really
left side
can't
of the road.
park.
Yes,
Huh?
extreme left side of the road.
Extreme left side of the road, with whether the parking lights are on or not.
That aspect has to be gone in the trial, it's not here.
No, but that was considered, it seems.
It is not, it is not considered.
No,
Only
no.
minutes
It is their
It
case,
was said that it was parked on the extreme left side of the road.
and because of it, the accident has caused.
But the FIR and the charge sheet.
No, I
both
can
are not
understand,
against
but all this are in Kannada.
The driver of the car has been acquitted because he stated that the lorry was going on the.
That is there.
Yes,
That
lorry was flying on the
no,
road.
no, that judgment is there.
Yes, my exhibit
Let us see
P5.
that.
Exhibit
Please take
P5.
that. If that is there, it will cut the issue.
ಅದರಲ್ಲಿ ಇವರು ಕಾರ್ ಡ್ರೈವರು
Look at it, the
ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ
judgment in that case.
ಎಕ್ಸಿಬಿಟ್ P5. It is stated that from the opposite side, a vehicle which was coming with high beams. Therefore, the driver of the lorry could not drive and he immediately parked the lorry. Therefore, this car went and hit. P5, P5. Good. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಇದರಲ್ಲಿ ಇದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಹಾಕ್ತಾರೆ. R5, sorry, R5. Good. Sorry. One day.
Which para?
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್ ಅವ್ರ ಹತ್ರ ಇದೆ. ರವಿಚಂದ್ರ ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಅಲ್ವಾ? R5 ನಿಮ್ಮ ಹತ್ತಿರ ಅಪೀಲ್ ಕ್ಲಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸರ್.
You can read, you take this.
Yes.
Read over.
Exhibit P24 is the judgment in the criminal case lodged against the Maruti
He's
van
reading
driver.
that. He has a copy.
P24. There, my lord, the driver of the Maruti van is exonerated.
No, what I want to know is what did he say and what is the finding?
The finding is that, my lord, the PW1 has been held to be hostile, my lord, and it's not as per the charge sheet. Therefore, the court says that there is no sufficient proof to hold that the driver of the Maruti van is guilty as charged by the police. That's the finding.
So it is not on merits.
My lord, but all the other things are considered. Amanat and the spot major is also considered, my lord.
What it says?
The court says that the prosecution has failed in view of the spot major and these eyewitnesses deposition, my lord. The prosecution has failed to prove the charges as against the Maruti van driver. It has considered the spot major and it has considered the seizure major.
The driver of
and
the
the
car,
evidence of the witnesses, eyewitnesses.
the driver of the car has given the evidence in that he stated that ಬೆಂಗಳೂರಿನ ಸ್ನೇಹಿತನ BH ಕೃಷ್ಣಮೂರ್ತಿಯನ್ನು ವಾಪಸ್ ಹಾಸನಕ್ಕೆ ಬೋಮ್ನಿ ಕಾರ್ನ ಎಚ್ಚರಿಕೆ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವಾಗೆ ಚನ್ನರಾಯಪಟ್ಟಣ ಟೌನ್ ಸನಂ ಹೋಟೆಲ್ ಮುಂಭಾಗ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 48ರಲ್ಲಿ ರಾತ್ರಿ ಸುಮಾರು 12:30 ಸಮಯದಲ್ಲಿ ನಿಧಾನವಾಗಿ ಚಾಲನೆ ಮಾಡುತ್ತಿರುವಾಗ ನನ್ನ ವಾಹನದ ಮುಂದೆ KA 13A 8881 ಸಂಖ್ಯೆಯ ಲಾರಿ ಚಲಿಸುತ್ತಿದ್ದು ಹಾಗೆ ಎದುರುಗಡೆಯಿಂದ ಒಂದು ವಾಹನ ಪ್ರಜ್ವಲವಾಗಿ ಲೈಟ್ ಅನ್ನು ಹಾಕೊಂಡು ವೇಗವಾಗಿ ಬರುತ್ತಿದ್ದ ಪ್ರಯುಕ್ತ ಮುಂದೆ ಹೋಗುತ್ತ ಲಾರಿಯ ಚಾಲಕನು ಮುಂದೆ ಚಲಿಸಲು ಗಾಬರಿಗೊಂಡು ಇದ್ದಕ್ಕಿದ್ದ ಹಾಗೆ ಯಾವುದೇ ನಿಲುಗಡೆ ಸೂಚನೆ ನೀಡದೆ ರಸ್ತೆಯ ಮಧ್ಯದಲ್ಲಿಯೇ ಬ್ರೇಕ್ ಹಾಕಿ ತನ್ನ ವಾಹನ ಇದ್ದಕ್ಕಿದ್ದ ಹಾಗೆ ನಿಲ್ಲಿಸಿರುತ್ತಾನೆ. That means the opposite vehicle coming with a high beams. Therefore, the driver of the lorry was taken aback and he just stopped the lorry. Therefore, this car coming behind the lorry dashed the lorry. That is the evidence of the driver.
What is the charge sheet? What is the case of the prosecution?
Charge sheet is against driver of the car.
No. They say that because of his negligence, the accident has happened.
Yes.
They don't mention anything about the lorry and all in the charge sheet.
They do
No,
mention.
no.
They do mention.
Please come. This is matter. When? In the month of July, it is submitted that the issue, whether with regard to the liability of the insurance company in Act policy, whether the inmates of the car are covered or not covered, is pending consideration before the apex court. Yes. Serial number?
Will I appear for the?
You're on what ground?
My lord, before that, may I make one submission? My lord, may kindly see the order sheet dated 14/7/2024. The court specifically said in the cross objection, notice shall be issued, because the matter was heard for some time, I bring to my lord's notice. If my lord also feels notice is not necessary, I will argue, there is no difficulty about it. Your lordship may kindly see the order. There was a specific order that notice shall be taken.
There is no need to take.
That I will leave it to my lords. If my lord also feels that way, I will leave it to my lords.
Order dated.
I only want to bring to my lord's notice. In fact, the matter was argued.
Cross objection.
After the matter was heard for some time, this order was made. Now, my lord, if it doesn't want to take
So
steps,
appears for respondent number 2 and 3.
notice is not served.
In your case, what happened in?
Notice has been served, my lord, in my cases.
Main matter.
The court also observed that.
The Honorable Court held that there is no need to take notice for R.
There is no need to issue notice to R2 and R3 by
Yes.
order dated 14/7/20.
Subsequently, my lord, the order may kindly be seen. The matter was argued, or after matter was heard, the court felt that notice shall be issued.
Whether that order is recalled?
My lord, notice, they have also taken steps once. Now the matter is
Asking, when there is an order dated 14/7/2021, without recalling that order, how can there be some other order?
my lord, that order was not recalled, but this was brought to the court notice and then this order was made. I will leave.
In this order, nothing mentions about the earlier order.
Yes, my lord. And my lord, they have also taken steps once. I only brought to my lord's notice. This is what has happened.
Who are this respondent number 2 and 3?
Owner of is insured and other vehicle insured owner
Liability is on whom?
and both. So
That is why, my lord, the court said, since
I understand,
One is-
liability is on whom?
an insurance company and owner of the other vehicle. Both are served in the main appeal.
Uh.
So
one is the brother of the complaint, my lord, who happens to be the owner of the two-wheeler. Brother of the claimant.
Tribunal apportioned negligence party 60.
Let's see. Argue.
Yes. My lord, this is the pillion rider of a two-wheeler, my lord. The two-wheeler was going on the very left side of the road. My lord, the car comes from behind and hits the two-wheeler. The complaint, my lord, is against the four-wheeler, Omni car. My lord, may kindly see the complaint. Nowhere, my lord, there is not even a whisper about the negligence on the part of the car, two-wheeler. Now, my lord, after the
According to them, the car came and
from behind
and
and
dashed
hit the
the
two-wheeler.
TVS moped.
Yes.
Ah.
Now, my lord,
Charge sheet is filed against whom?
the car.
Hmm.
There is no allegation of negligence on the part of the two-wheeler.
On the part of?
Two-wheeler, motorcycle which was going ahead, even in the complaint, my lord.
Not had.
Now,
Para 16 lordship, see the finding of the tribunal is perfectly.
my lord, I am referring to the complaint. The complaint.
It emerged from the side road, that two-wheeler, and entered the national highway.
No, there is no dispute that you're referring for the claimants.
Please, ma'am.
Claimant is the claimant, it's a case of death or injury.
Death, my lord. He was a pillion rider.
He was a pillion rider.
This is. And para 16, lordship, kindly see, para
And
16.
complaint is against the
Car driver.
car driver.
Car driver, and he was examined. There is no evidence from the two-wheeler. Para 16 lordship, before that lordship, I bring the lordship. Para 16 of judgment, internal page 9.
May.
Now the question of, may I read?
Yes.
Now the question is, who has to take and do care in the occurrence of accident? Driving in high speed is not a negligent act. Driving without due care and caution, is taking reasonable care at the time of occurrence of the accident is the negligence. Ultimately, driver of the car was proceeding on a national highway. If sketch is perused, it goes to show that towards southern side of the road, near accident spot, there is a land of Ramesh and Babu Raj, and the evidence there is Uru Bagilo, that is village entrance and show that there is an entrance to the village near the accident place, the probability of the condition driver of the car cannot be ruled out. On the date of accident, the driver of the TVS moped joined the main road from the village entrance without observing the car coming from the eastern side on highway. No doubt there is a negligence on the part of the car driver, because when there is a village entrance, the driver of the car ought to have more cautious while driving his vehicle. But at the same time, driver of the TVS moped also would have been cautious at the time of joining the main road. Though in this case, the charge sheet has been produced and police recommended speaks that the case has been registered against the driver of the car. But in these proceedings, the petitioners have substantiated their case by leading convincing evidence and proved their case independently. But the petitioner has not led the evidence provided TVS moped. There is no impediment for the petition to lead the evidence.
With this, in this discussion, why the court has assumed so many things and fixed contributory negligence?
Not
That is
composite.
only because car did not
Composite
have
negligence.
insurance.
Composite negligence on the part of.
What I'm saying.
But that's what the TVS rider all of a sudden entered from the side road to the national highway and obstructed the car. That's how accident happened. So tribunal considering all these things, party 40% of the two-wheeler and 60% of the car driver fixed negligence. So in that ratio, compensation would also.
The probability in the contention, admittedly, the driver of the car was proceeding on a national highway.
Please.
If the sketch is perused, it goes to show that towards the southern side of the road, near accident spot, there is a land of so-and-so. And even there is that shows that there is an entrance to the village. The probability in the contention, it can't be like this. The probability in the contention of the driver of the car cannot be ruled out.
It actually kindly say a sketch, spot sketch that indicates.
No, because there is a probability of that. That can't be a reason for the court.
Not probability, man. That's proof.
So that is what is observation. The probability in the contention of the driver of the car cannot be ruled out. On the date of accident, the rider of the TVS moped would have joined the main road from the village entrance, observing the car coming from the eastern side on highway.
That's what.
No doubt there is a negligence on the part of the car driver. Whose case is this?
This is their case. But my case is entire negligence on the part of the TVS rider, because he entered the main road without observing the car coming from east.
For that, what is the evidence that you have adduced?
Driver of the car was examined.
And that is his self-serving evidence itself is not sufficient. What apart from that, what is the other evidence?
Apart from that, I am the claimant here. So the tribunal rightly observed party 60 fixed liability and both the car.
That's why you don't have to argue on that now. It's for the court to decide whether it is whether there is a composite negligence or the negligence alone on one driver.
Yes.
It has to be decided by the court.
Please,
as far as the claimant is concerned, you have nothing to say. Either of it, you will get the money.
Please.
Yes. Who appears for your insurer of which vehicle?
Of the motorcycle,
Huh?
two-wheeler.
Car is not insured.
Not insured.
That is the reason why, my lord, I am saddled with the liability.
Car is not insured.
As far as your appeal is concerned, forget about his appeal. As far as your appeal is concerned, he is already served.
My lord?
He's already served.
Yes, he is served. In my case, he is served. My lord, after hearing all this matter, my lord, the court thought how to consider all these aspects.
In your appeal, he is served.
Yes.
In your appeal, he is
Now,
served.
my lord, may I address, my lord? As far as what my learned friend said, all that is, my lord, the presumption of the tribunal. In fact, there is no crossroad. Your lordship may kindly see the sketch. There is no crossroad. I don't know how the court can presume. Sir, you submit Madila and Bidi. Private somewhere. My lord, may kindly see it's a national highway. On all the sides, it's fenced. My lord, the accident spot may kindly be seen. It is on the extreme left side. And my lord, what the tribunal says is, there is one word, my lord, what it says is, Uru Bagilu Ramesh Ravara Jamino. My lord, Uru Bagilo means, my lord, it is the name of that person, Uru Bagilu Ramesh. My lord, may kindly see that. Our Jamino, though, it is not Uru Bagilo. My lord, got it? The word may kindly see Uru Bagilo anta ide. Uru Bagilo refers to the name of that person. Uru Bagilo Ramesh Ravara Jamino. It is not the door of the village, entrance of the village. I don't know, my lord, your lordship may kindly see the sketch. On both the sides, there is the clear markings. And my lord, your lordship may kindly see, it is on the extreme left side.
I am looking at the sketch.
Yes,
Come to the sketch.
Sketch only, my lord. It is
Where
on
is
the,
that? Car is there, car is on the left side.
on the spot, my lord, spot is mentioned. A round mark, my lord, got it round marked. Apagatada sthala. It's also on the extreme left side. My lord, I just could not have moved to the left at all.
Where is the bike? Where is the two-wheeler?
May.
It's not that I'm saying where is the moped shown. Give that. Give that. Where is it written?
Hardly 2 to 3 feet.
And where is the opening?
There is no, my lord, the opening, no opening. That is why I said the word Uru Bagilo Belad is interpreted as though it is the entrance to the village. It is the name of that person. Uru Bagilo Ramesh is the name of that person. That is interpreted as saying it's an entrance to the.
It appears to be a, there is no entrance to enter from the main road.
I don't.
Look at it. And apart from that, all those observations or might be, would be, probability. There is no way shown.
There are accident spots here, Mela.
Hmm?
He has entered from this place here. The village side road. The two-wheeler emerged from the side road and entered the main road. Even there is a fire also disclosed that.
No.
So he was a plain rider.
From the sketch, I'm not understanding that. That he has come from the side road, that we can't understand from the sketch.
FIR and charge sheet it is disclosed.
It's not in the FIR, not in the charge sheet.
What is stated in the FIR?
Well, they came from behind and it.
Not behind.
I'll read out, Mela. I'll read out the FIR itself. I'll read out, Mela. Mela, it is in Kannada, may I?
Yes, read and translate.
Yes, Mela. Mela, this is complaint is by Venkatach.
Do you have the copy?
I don't.
Give him that. He will.
Yes.
You read. He will read.
ನಾನು ಮೇಲ್ಕಂಡ ವಾಸವಾಗಿರುತ್ತೇನೆ ದಿನಾಂಕ this is given by the brother of the.
Now, from that, what is relevant, you read that sentence and tell entire, you don't have to read.
Yes, Mela. ಕಾರನ್ನು ಅತಿವೇಗ ಮತ್ತು ನಿರ್ಲಕ್ಷ್ಯದಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಾವು ಬರುತ್ತಿದ್ದ ಮೇಲ್ಕಂಡ ದ್ವಿಚಕ್ರ ವಾಹನದ ಹಿಂಭಾಗಕ್ಕೆ ಡಿಕ್ಕಿ ಹೊಡೆಸಿದನು. The court said only read the relevant portion. I leave it to you, please.
Yes, you tell what is the relevant.
The entire this was relevant, my lord.
I tried to read that.
Only with regard to whatever you are submitting, how he has entered into the main
ದಿನಾಂಕ
road.
15/7 ಸಂಜೆ ನಮ್ಮ ವಾಬತ್ತು TVS ದ್ವಿಚಕ್ರ ವಾಹನವನ್ನು ಸಂಖ್ಯೆಯಲ್ಲಿ ಶ್ರೀಸಂದ್ರ ಗ್ರಾಮದಿಂದ ಕುಂಬಾರಹಳ್ಳಿ ಗೇಟ್ ಬಳಿ ಇರುವ ಮಂಗಮ್ಮನ ಮುನಿಸ್ವಾಮಿಯವರ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪೂಜೆ ಸಲ್ಲಿಸಿದ್ದು NS4 ರಸ್ತೆಯಲ್ಲಿ ಹುಡಗೂರು ಗೇಟ್ ಸಮೀಪದಲ್ಲಿರುವ ಕೋರ್ ಶಾಲೆ ಸಮೀಪ ರಸ್ತೆ ಎಡಗಡೆ ಬರುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಹಿಂದುಗಡೆಯಿಂದ ಒಂದು ಕಾರು ಚಾಲಕ ಕಾರನ್ನು ತೀವ್ರ ಮತ್ತು ನಿರೀಕ್ಷೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ನಾವು ಬರುತ್ತಿದ್ದ ಮೇಲ್ಕಂಡ ದ್ವಿಚಕ್ರ ವಾಹನಕ್ಕೆ ಹಿಂಭಾಗದಲ್ಲಿ ಡಿಕ್ಕಿ ಹೊಡೆದನು. ನಮ್ಮ ದ್ವಿಚಕ್ರ ವಾಹನ ಹಿಂದುಗಡೆ ಕುಳಿತಿದ್ದ ನಮ್ಮ ಮಾವನಿಗೆ ಶ್ರೀನಿವಾಸನಿಗೆ ಹೇಳ್ಬಿಟ್ಟು. So it from behind, that is the evidence of the FIR. Raised by one Venkatachalapati.
So there is no mention about all this story, what the judge is visualizing.
But he is not an eyewitness. But
whoever it is, where from the wait, let me ask him. I understood what your contentions are.
He is not an eyewitness who lodged the complaint, Mela.
Is it mentioned in the charge sheet?
Since he is.
And where from the court is inferring all that is the question now.
Charge sheet. driver of the car was examined.
Driver though, he will say what he wants to say. That can't be the basis.
And effectively was not cross-examined.
Charge sheet is exhibit P7. Please read exhibit P7.
Exhibit P7.
Don't have to read everything, only with regard to the manner in which
Yeah,
they have narrated the incident.
ದಿನಾಂಕ 5/7/1 ಸಂಜೆ 5:30 ದೋಷಾಪಣ ಪತ್ರದಲ್ಲಿ ಕಂಡ ಓಕೆ ಕಾರು ಕೋಲಾರ ತಾಲೂಕು ಹುಡುಗೂರು ಗೇಟ್ ಬಳಿ ಕೋರ್ ಕಿವೇಗ್ ಮತ್ತು ಅಜ್ಜಾಗದ ಮಾಡಿಕೊಂಡು ಬಂದು ರಸ್ತೆ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ಡಿಕ್ಕಿ ಹೊಡಿಸಿದ ಪ್ರಯುಕ್ತ ವ್ಯವಹಾರ ಹಿಂದೆ ಕುಳಿತಿದ್ದ ಶ್ರೀನಿವಾಸ ಮಂಚಿಯವರು ಅಷ್ಟರಲ್ಲೇ ಮೃತಪಡಿದರು ಹಾಗೂ ದ್ವಿಚಕ್ರ ವಾಹನ ನಡೆಸಿದ್ದ ವೆಂಕಟಾಚಲಪತಿ ಅವರು ಎಡಕಾಲಿನ ಮಡಿ ಹಾಗೂ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲದ ವಾಹನವನ್ನು ಚಾಲನೆ ಮಾಡಲು ಕೊಟ್ಟು disclose that it was the two-wheeler was
I think it's all, the moment you look at the finding, one can understand what it is.
presumption that the tribunal has come.
Then you are on what other ground? You are seeking enhancement.
Enhancement.
Yes.
Accident of the year 2011.
Yes.
And tribunal has taken income 5,000.
How much is supposed to be taken?
6,500.
What is the age?
The age of the deceased was 30 years. 30 years. At least some negligence could be fixed to some extent made, because negligence on the part of the two-wheeler also.
You can't.
And future prosperity are not considered.
1 minute, so 6,500 plus 40% future prospects, 2,600. It comes to 9,100. How many are the dependents?
2 dependents, minor son and wife.
1/3. Comes to 6066. What is the multiplier?
Multiplier, that is 6, 17. 17 for 30 years.
30 years, the multiplier is 17.
17.
$13,79,464.
Submission. Some negligence could be attributed to the two-wheeler rider, my lord, at least some extent.
Why some? If you have the evidence.
There is no absolute negligence on the part of the car driver, because the collision. Collision is between two vehicles. So there should be.
There is no collusion. Second vehicle as car went and dashed to the moped. Because moped is having insurance, we cannot fasten the liability without any evidence.
Some extent, my lord, because that.
The appeal is filed by the insurance company, agreed with orders passed, award passed in MVC number 6143 of 2011 dated 7th November 2012. The claimants have filed MFA crop 1119 of 2018 seeking enhancement of the compensation. It's a case of the claimant that on 15/7/2011 at about 5:30 p.m. deceased was proceeding as a pillion rider on TVS motorcycle. At that time, a Maruti Suzuki car came from the same direction in a high speed in a rash and negligent manner, went to the wrong side of the road and dashed against the TVS moped. Due to the impact of the said accident, the deceased, who was a pillion rider on the motorcycle, sustained grievous injuries and succumbed to the injuries on the spot. Accordingly, the police have filed a charge sheet against the driver of the car. The MSCT by order impugned has held that the accident had taken place because of the negligence on the part of the driver of the car as well as the rider of the moped and driver of the moped, and fixed the liability on both the vehicles at 40 and 60%. When it comes to the compensation, the tribunal has awarded the compensation as per the table given below, para 23. The court had considered the income at how much?
5,000.
5,000 and granted the compensation as per the table given below. When counsel appearing for the insurance company submits that the tribunal has fixed the liability on the two-wheeler when there is no evidence, and the police evidence and all other evidence points out at the negligence on the part of the driver of the four-wheeler. It is submitted that such a finding is more on assumptions and presumptions, and there is no fault on the rider of the TVS on the rider of the two-wheeler. It is submitted that as there is no negligence on the part of the two-wheeler, the appellant insurance company is not liable to pay the compensation. Though notice is served on the respondent owner of the vehicle, there is no representation on the owner of the car, no representation on their behalf. When counsel appearing for the claimant submits that the court, considering the evidence of the driver of the car has and the manner in which the accident has taken place, has rightly fixed the composite negligence on both the vehicles. It is submitted that no other evidence is adduced by the driver or the insurer of the insurer of the two-wheeler to show that there is no negligence on the part of the two-wheeler. It is submitted that the court had rightly fixed the liability. Then coming to the compensation, it is submitted that this accident has taken place in the year 2011 and the court had taken the income at 5,000 and ought to have taken the income at 6,500, and on this count the compensation needs to be enhanced. Having heard the counsels on either side, produce the material on record. The first contention is with regard to the liability. It's a case of the claimant that while they were proceeding on the road, while the deceased was proceeding as a pillion rider on a two-wheeler, the four-wheeler came from behind and hit the two-wheeler. There is no other evidence except the evidence of the driver of the car that there is a negligence on the part of the rider of the two-wheeler. Even the police records are pointing out at the negligence of the driver of the four-wheeler. This court has perused the findings of the court. The court observes that the police documents show that the car driver has been charge sheeted, but the driver has appeared before the court as RW2, and he has reports that on the date of accident, the rider of the TVS moped came from a village road to join the main road without observing his car. Thereby, he has contributed for the occurrence of the accident. The court has further observed that the car was proceeding on a national highway. If the sketch is perused, it goes to show that towards the southern side of the road, near accident spot, there is a land of Ramesh and Babu Raju. And even there is a, what is that? There is a
interest to the village. entrance to the village. Village entrance, my lord.
There is an entrance of the village, that there is an entrance to the village near the accident place. The probability in the contention of the driver of the car cannot be ruled out. On the date of the accident, the rider of the TVS moped would have joined the main road from the village entrance without observing the car coming from the eastern side on highway. No doubt, there is a negligence on the part of the car driver, because when there is a village entrance, the driver of the car ought to have been more cautious while driving his vehicle. This court has perused the charge sheet, the sketch, and none of these findings, all the findings of the court, are more on assumptions and presumptions. The court cannot give a finding stating that the rider of the TVS would have joined the road from the village entrance when the other records are contrary to the same. In that view of the matter, the finding of the tribunal fixing that there is a composite negligence on the part of the driver of the two-wheeler cannot be appreciated, cannot be sustained. And this court is of the view that the accident had taken place because of the rash and negligence on the part of the driver of the car. The car is not insured. Hence, the liability is on the owner of the vehicle. Then coming to the cross objection, where as this is an accident of 2011, the income has to be taken at 6,500. Deceased was aged about 30 years. Future prospects at 40% will come to 2,600. Then the total income is 9,100. As there are two dependents, 1/3 has to be deducted towards the personal expenses. That is 3,033. And his contribution to the family would be 6,066 into 12 into 17 under the head of loss or dependency, 12,37,464. Consortium, 48 into 296,000. The funeral expenses, 36,000. In the light of the law laid down in so 10,000. Altogether, the claimant is entitled for an amount of rupees 13,79,464. Accordingly, the appeal of the claimant is partly allowed, the appeal of the insurance company is allowed, and the amount in deposit, the insurance company is it here or before the trial? The amount in deposit, the insurance company is at liberty to withdraw. The appeal of the cross objections filed by the claimant are partly allowed by enhancing the compensation from 7,25,000 to 13,79,464, and the amount shall be paid by the driver, by the owner of the car. This next. Which one? That is on condition. On condition. Is it condoned or yet to be condoned? Look at it. The cross objection, the delay, whether it is condoned on condition, look at it. Yes, next. No, by order dated so and so, notice is it is held to, the court has passed an order that notice to them is not necessary, as they have already been served in the main appeal. Yes. No representation for dismissal. Yes. Dismissal after vacation. Yes, 7.
I'm appealing for the respondent number 2, my lordship.
Where is it?
The claim petition was dismissed, my lordship, and
no representation. This is matter for dismissal after vacation. Yes, 11.
In the case of injury,
Anita.
claimant sustained head injury,
Follow.
seeking for the enhancement of the compensation.
Huh?
Seeking for the enhancement of the compensation.
Case of death or injury?
Case of injury, my lord. He sustained
Come to the table. How many are,
reasoning in para 13 of the
how many are
judgment.
the injuries?
Para 13 of the judgment, my lord.
Yes, Mr. Ravi Samrat. How many injuries?
Majorly head injuries.
Injury.
He had suffered fracture of temporal bone, parietal bone. Doctor is examined, but the doctor has not assessed the disability.
Yes,
According to him, there is disability or no disability?
We don't.
sustained
Doctor has not
disability. He has
stated
undergone
anything
3
about the
surgeries,
disability.
my lord.
That is true, unless and until it is stated by the doctor, we can't consider. If you want, I can remand the matter.
No, my lordship. And he has inpatient for the period of 147 days, ma'am.
All that we will consider, but
But
about.
doctor has stated that is required
also-
one more surgery. It will cost about 1 lakh to 150, 1 lakh
That we will
50,000.
see, but not about disability.
Yes, ma'am.
So pain and suffering,
Pain and
45,000.
suffering 45,000 is awarded.
45,000 is granted.
head injury.
So 45,000 is granted. Another 30,000, 75,000 rupees.
And towards
Then how many days he was in hospital?
147 days, my lordship.
Huh?
147 days.
Is it so?
Yes, ma'am.
Yes, ma'am.
In 3 different hospitals.
Then he requires that much of money, 147 days.
No, Lord, what happened is he has produced the medical bills to a tone of around 6 lakhs change. But the tribunal has granted only 3,55,860 because there was some inclusion of the advance bills and ambulance charges.
No, I am on incidental expenses. He is there in the hospital for
Incidental expenses, I leave it to your
147, so the 1,000 we are giving, so it would be 1,47,000. Then
Medical bills, we are both are sit together and calculate it. And as per the medical bills, it is required to be enhanced another 1,45,000.
have you seen that?
Please,
It
I have
can be.
made my calculation.
So 3,55,860. It will become 4,55,860.
4 lakh, 1,45,000 is additional
Additional
amount.
is 1,45,000.
1,45,000.
Okay, how much it will become?
It comes to 5,04,000.
5 lakh?
4,000.
And towards attendance and conveyance, no compensation.
1,47,000 I have granted.
Yes, ma'am.
You don't want?
Yes, ma'am. Yes, ma'am.
Yes.
And towards attendance and conveyance, though it has been mentioned as 15,000 in the findings recorded by the tribunal, but is not mentioned in the paragraph.
How much is mentioned?
15,000. It is
So we
required
will carry only 15,000.
No.
Then why are you arguing on that when I am saying 1,47,000 is granted?
Yes, ma'am.
Next,
Next to income during laid up period only 40.
loss of income during laid up period. So when he is in hospital for 147 days, that is how many months?
Around 5 months.
5 months.
Another 3 months, 8 months. Which year is the accident?
2011.
2011.
11.
$52,000.
Towards amenities, no compensation is awarded.
Amenities will come when there is disability.
Marginal amount required to be awarded, my lordship.
What do you say?
Some reasonable amount.
Huh?
Some reasonable amount. Anyway, he is
Not
not.
generally, what is meant?
No, generally, even in the absence of disability, also the amenities will be granted.
It can be granted.
Yes.
Oh, what is the head amenity?
But the amenities is a head where he will not enjoy the happiness of the life. Normally.
For that, there should be something to show that because of these injuries, he had sustained some.
What happened is it has become a routine practice of granting compensation on the amenities also.
Somehow I find it strange, without fixing the future loss or future disability. No, somebody has sustained injuries and he'll be all right. Where is the loss of amenities unless and until there is a disability? You want me to grant?
I leave it to your lordship.
30,000.
Future medical expenses, as per the doctor evidence, he required one more surgery.
What do you say? What is that head
But
surgery?
he may require one more surgery, but
And
he
it
has not
costs about,
produced any
one-
document. It is only his oral
1 lakh
statement.
to
that
1,50,000.
requires some.
No, to the head. we will
No,
enhance
we
it
do
by
not
another
know whether,
20,000.
we do not know whether he has undergone the surgery. It is 2011 accident and the
We'll grant
petition
it
is of the year
another 20.
2012.
No, in all the cases, we are not having any information whether they're going or not.
Doctor evidence is very clear, my lordship.
We will grant another 20.
As per the evidence of the doctor, it,
Evidence of the doctor, what is just oral, anything else he said, how it is going to be that much.
taking consideration of the nature of the injury, is sustained fracture.
We are going to have substantial increase now. Coming to 8,68,000 against 4,70,860. Please come. What is the finding with regard to these bills?
That bills, that is what the tribunal has observed, that some of the bills are advance.
So we have to say that this court has.
Yes, advance bills we have deducted.
Even after deducting the bills, it should not be that, it should be this.
No. After deducting the advance bill and the ambulance charges, it comes to 5,04,000 rupees.
Please come. Agreed with the award passed MSC number 88 of 2020, dated 2nd August 2014. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 17. When counsel appearing for the appellant claimant submits the claimant has sustained a head injury under the head of pain and suffering. The amount that is awarded by the tribunal is not just and reasonable. When he has produced a bill to show that he has spent an amount of rupees how much?
5,04,000.
Where is it forthcoming in the order?
The total bills that are claimed is 6,11,054.
6,11,054.
6,11,000.
11,054.
54.
Though he has spent the amount of so and so towards medical expenses, the court had granted only 3,55,860. It is submitted that he was in hospital for 147 days towards the incidental expenses. Though in the order it is mentioned as 15,000, it is not forthcoming in the table. It is submitted that for 147 days of hospitalization, the petitioner has to be compensated for the same. Coming to the loss of income during the later period, court has granted 40,000. It is submitted that he was in hospital for 8 months. Then coming to the future medical expenses, the doctor has given the evidence that it requires 1
lakh to 1,50,000.
1 lakh to 1,15,000 for the future medical expenses. Under the head of loss of amenities, no amount is granted. It is submitted that on all the counts, the compensation needs to be enhanced. When counsel appearing for the respondent insurance company submits that the court had rightly considered and granted compensation and there are no grounds to intervene. Next, having heard the counsels on either side, there is the material on the court. There is no dispute about the fact the petitioner has sustained head injury. He was in hospital for 147 days. Considering the same on the head of pain and suffering, this court is granting 75,000. Incidental expenses for 147 days. This court is granting 1,47,000 towards medical expenses. When coming to the medical expenses, this court has perused the order passed and the finding of the court with regard to the, what is that? Where do you get that finding?
Findings recorded in page number para 14, my lordship. Page number 22.
The court has found fault with certain inpatient vouchers and deposit receipts which are included in the final bill. This court has perused the bills that are placed by the claimant and after deducting the amounts in respect of the repeated bills, the medical expenses would come to 5,04,000. Coming to the loss of income during the later period, this court is inclined to consider consider 8 months for the same. 8 into 6,500 is 52,000. Coming to the amenities, this court is granting 30,000. Future medical expenses, this court is of view that the amount that is mentioned by the doctor is on the higher side, and this court is granting 50,000. In the light of the law laid down in make law also so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 8,68,000. Accordingly, appeal is partly allowed, enhancing the compensation from 4,70,860 to 8,68,000. The enhanced amount shall carry 6 months of interest. Yes, next. Well,
12 Mellon I appear for the respondent case artist, 6th respondent.
you're the
6th respondent case artist.
I'm the financial. The vehicle was financed by the appellant. Now the liability has been shifted on the appellant. My lord, here the active insurance policies were there, and there is an observation by the court that for the non-jointer of the parties, one of the respondent has filed the objection saying that the insurance company has not been arrived as a party. And thereafter, my lord, regarding the insurance policies, the court below has observed.
The vehicle involved in this accident is, what is the vehicle?
Tempo, my lord.
Tempo is involved.
Tempo is involved.
You are financed for the Tempo.
Please.
Who is the insurer of the Tempo?
Insurer of
According
the
to
Tempo
them.
are
According to them, ICICI Lombard is the
insurer. You are not.
We are not a party to the proceeding before the MSCT. Now they are produced the old policy, which is old. In order to trace my respect submission matter may be remanded to the particular this thing regarding liability aspect is concerned.
Please.
Only liability aspect.
Claimant, you appear.
I am for claimant. Initially permitted
I represent case artist.
The amount in deposit is permitted to withdrawn by the claimant.
Without deciding, how can it be agreed with the award passed in MSC number 3 of 2019 dated 3rd September 2012. The fourth respondent. You are which respondent? Tata Motors.
Respondent number 4 in the case.
Respondent number 4 in the claim petition, who is a financier who has financed the vehicle, the offending vehicle, is before the court. It is submitted that the vehicle is insured by the ICICI Lombard Insurance, and the insurance company was not a party before the MSCT. Land counsel appearing for the insurance company submits that the insurance company is denying the liability. The insurance company is never a party to the proceedings. Basing on which policy they're saying that the vehicle is insured with the respondent is not known. If the matter is remanded to the court, if an opportunity is given to the parties, then the liability can be decided by the tribunal. This court finds force in the argument of the land counsel for the insurance company. Accordingly, this court is passing the following order. The award dated so and so, passed in so and so, is set aside and the matter is remanded back to the trial court. All the contentions are left open, and the MSCT, without further notice, the party shall appear before the MSCT on 8th of June, and the court, by considering the respective contentions of the parties, by giving reasonable opportunity, shall dispose of the matter as expeditiously as possible, but not 6 months, but not later than 6 months. Yes.
Obliged.
Second respondent.
Yes.
For the appellant.
Enhancement.
Not,
Claim petition is
dismissed. Claim petition is not dismissed. I dismissed against the insurance company, my lord.
On the ground?
On the ground that, my lord, there is an implication of vehicle and there is collusion between the claimant as well as the respondent number one, who is the owner, my lord. My lord, only on the basis of the private investigating officer's report and his deposition, my lord. My lord, kindly appreciate, it's a case of death, Lord, of one Ashok in the road.
Read that finding.
Yes.
Which paragraph?
Lord, just.
First issue.
My lord, first issue is held that the offending vehicle, my lord, the tractor and trailer which is involved in the accident, my lord, because of the accidental injuries, my lord, is succumbed to injury. That is, the issue is held affirmative. But while fastening the liability, my lord, court finds that, my lord, relying on one judgment.
Let's see, where is that, that paragraph?
Yes. Not so far as issue number one, it is only in one paragraph. I'll read it. Not paragraph number 12. Lord, RW 193 denies the involvement of the said vehicle in the accident. RW 1 has not entered the witness box. He has remained absent before this court.
Are you reading?
Paragraph number 12, my lord. RW 193 denies the involvement of the said vehicle in the accident. RW 1 has not entered the witness box. He has remained absent before the court throughout, but the allegation of the petitioners that involvement of the said vehicle is not denied with the respondent number 2 in material particulars. So also the respondent number 2 is also not an eyewitness to the accident. Therefore, in the absence of any evidence of respondent number 1, it cannot be stated that the cause of because of the rash and negligent driving of the driver of the tractor and trailer, the said accident has taken place. If at all these factual features are read together, it can be stated that petitioners are able to establish issue number 1 with legal and acceptable evidence.
Then come to that finding.
Yes, ma'am. The reasoning regarding liability, my lord. Lord, paragraph number 19 of the judgment, my lord.
Yes.
So far as liability is concerned, a serious objection is raised with the second respondent alleging that there is a false involvement of the said tractor and trailer being owned by respondent number 1. It is alleged that the collusion between respondent number 1, the said vehicle was been falsely implicated. So far as the issuance of the policy in respect of the offending vehicle and its validity on the date of accident is concerned, it is admitted the respondent number 2 is the investigating officer, has come before the court and stated that this vehicle has been falsely implicated. He has submitted his report marked as exhibit P13. He has produced some photographs marked as exhibit P2 to R2 to R12. Evidence of R1 and 2 is at properly denied by the petitioner. Except the denial in the cross-examination, nothing is elicited. The counsel for the respondent number 2 submits that as the fraud is committed by the petitioner in collusion with the compensation implicating the alleged offending vehicle.
Where is the finding? Where is the finding? It cites 2-3 judgments of the Supreme Court, and whatever your investigating officer says, that can't be a gospel truth.
Let him read the complete judgment, please.
No, I've seen it. I've seen the entire until 22.
Here is the case. Case registered against the unknown vehicle, please, my lord. Unknown vehicle. This is also unknown vehicle, unknown person. Please.
From the findings I'm asking. Now court talks about the liability. Then para 20. After that 22, entire 21. It is about extracting the judgments. Then 22. In view of these judgments, it cannot be stated that petitioners are paid in claiming compensation. So therefore, in view of the judgment of so and so, is liable to pay the compensation. What is that finding? No basis for that.
This vehicle not at all involved this vehicle, please.
Who has to say that?
Please, my lord.
Who has to say that? Court has to say. Where did the court say? Look at it. You can read the judgment and.
I have read the judgment. That will explain, please, my lord. All annexures in Kannada.
This you. No.
Please,
First of all, you show me the finding, then you explain.
Case and registered the unknown vehicle, please, my lord. The person is also dead person is unknown person.
To this judgment by stating the facts, you have to only rely on this judgment and tell the court that the court is right. Show to the court. If not, this judgment has to go.
This vehicle is given only for the purpose of this case. The owner of the vehicle has given the state.
You also accept that there is nothing on the finding is not given by the court. First of all, let's clarify that, first you clarify that aspect. No finding is given.
No finding is given in this regard, please, my lord. Only on apart from very important thing is, my lord, in all the police documents where the unknown person, they have nobody's come forward to the receive the body. Therefore, with the help of the complaint given, extent took place in between the 2:30 to
Then set aside
3:30.
and remand.
And one more
Can be
submission.
done, my lord, one submission, my lord. The accident, my lord, has taken place.
No, the report of that officer
Yes.
is in English or in Kannada?
English, my lord.
Give that. But this order can't be sustained.
That apart from, please, my lord, they have not produced any single document to show they are legal heirs
That
of
is
their
what the
deceased.
court should say.
Please.
That's what the court has to say, not you, not this report in that exhibit
R13, my lord.
R13.
Yes. But the actual background of the case I'll narrate, my lord. The
Charge
accident.
sheet is filed against whom?
Charge sheet is filed against the offending vehicle, my lord, which, my lord, the trial court has come to conclusion that this particular tractor and
Then
trailer.
what is forthcoming in that charge sheet with regard to any collusion?
No, my lord. No, absolutely no. My lord, kindly, at around 3 AM in the morning, my lord, the accident takes place.
We'll understand, that will make the things clear.
Yes, my lord.
R6.
R13. Lord, 3 AM, my lord, accident takes place. My lord, some unknown persons pass on the information to the police. My lord, immediately, within 15 minutes, my lord, it is in the jurisdiction of the city. My lord, within 15 minutes, my lord, the police came to the spot. And thereafter, my lord, they register FIR against the unknown person. My lord, thereafter, on the very same day, my lord, on 11/4/2011, my lord, the person who passed on the
Got it.
information.
Let me just look at this. When you were taken to the hospital?
Not on the way, my lord, he died on the spot.
No, he must have been, for the postmortem, body must have been taken to the.
Yes, my lord, on 11/4/2011, my lord.
Immediately.
Immediately, my lord, because.
In there it is mentioned that hit by a tractor trailer.
My lord, in the postmortem report.
Medical records, this name is mentioned immediately.
Yes, my lord, medical record regarding the inquest merger, my lord, it is mentioned that he met with an accident involving, my lord, tractor and trailer, my lord. There are two eyewitnesses to the accident as well, my lord. They have been made as CW 11 and 12 respectively as the charge sheet witness.
No, the owner of the vehicle and the petitioner, father and son.
My lord, it is not been proved according to them. My lord, even.
Deny that fact?
Yes, my lord.
No, in the postmortem,
he-
no, in the postmortem, what is the name of the father?
Name of the
Father, in the postmortem, postmortem report is marked as exhibit,
P5, please.
exhibit,
P5.
P4.
Unknown Ashok
P4.
and Puttegowda answer.
1 minute.
P4.
Kapani Gowda.
Ada.
English ಅಲ್ಲಿ.
Postmortem report. P5.
Son of Kapini Gowda,
Kapani Gowda.
Yes, madam.
Ashoka,
ಅಶೋಕ unknown ಅಂತ ಹೇಳ್ತಾರೆ.
son of
Kapani Gowda.
Kapini Gowda.
Please.
And what is the owner of, insurer of your vehicle? Who is the insured?
Puttegowda ಅಂತ ಏನೋ is.
Then how can he be the son? Your office, your investigating officer says insured Puttegowda and accused. What is accused?
Well, accused number is a different, please.
What is accused? Who is accused?
My lord, the accused, my lord, is the son of this owner, my lord, owner of the vehicle.
Ramegowda, please. Ramegowda is the accused.
Ramagowda is driving the vehicle.
Please.
Yes, my lord. And
He's the son of the insured.
Son of
insured, yes,
the-
my lord.
Insured. And those so-called eyewitnesses, they are going for work for the painting work by 2 to 2:30 early morning, please, my lord. They have not examined.
Can anybody believe these kind of reports?
Please, my lord.
Can anybody consider these kind of reports?
This company official evidence, please, my lord. He recorded the CD also. Kindly, the CD is also there in the file, please. Kindly play it and see it, please. He recorded all the statements of the son, his brother of the deceased, father of the deceased, mother of the deceased, sisters of the deceased. They told that this body is not belongs to us because when he was working at
Forget
Bombay,
about it.
some
What he
oil,
says
some
is,
soot to the.
Mr. Puttagowda said that Ashok was died due to murder or hit by unknown vehicle.
Please.
The vehicle was untraceable, hence insured vehicle was given for the case. Again, I inquired about the relation between deceased Ashok and Ramegowda. Insured Puttagowda said that the Ramegowda wife Sharda and Ashok wife Radha were sisters. They were daughters of Jairam Gowda of the village. Even the statement of this Ramegowda was also videographed.
Some photos.
Puttagowda.
Photos also kindly see, my lord.
Photos are
It's
there.
as good as a murder.
Photos are there, my lord. No videos, my lord. Specific.
CD is there. CD is there. The file is there, please.
CD is there, my lord.
Let him play and see the CD, please. I don't mind.
Let it be played, my lord. I have no objection, my lord. But
What happened to the criminal case?
my lord, criminal case, it has.
It must have, something must have happened by this time.
Yes, my lord.
Get that. It appears to be fishy, though the court has not discussed. This is matter after vacation.
One submission, they have not put any relationship through these claimants are not put any relationship. Kindly remand the matter. We will examine that with eyewitnesses, summon the eyewitnesses and also cross-examine.
Yes, my lord. It may be, my lord, I'll also examine the two eyewitnesses are there.
Please come. The present appeal is filed agreed with the order passed in MSC number 1029 to the 2011 dated 10 September 2013. The claim petition was filed compensation for the death of the deceased in the accident. It is a case that on 11/4/2011 between 2:30 a.m. and 3 a.m. A tractor and trailer owned by the respondent number 1 driven by his driver came in a rash and negligent manner and dashed against the husband of the claimant and husband and father of the claimant. Because of the injuries sustained, the deceased died on the spot. The tribunal, basing on the report given by the investigating officer appointed by the insurance company, has held that that there is a collusion between the owner of the vehicle and the claimant, and only held that the owner of the vehicle is liable to claim the liable to pay the compensation and dismiss the claim petition against the insurance company. Agreed thereby the claimant is before this court. Then counsel appearing for the claimant submits that the court, except discussing the judgments of the apex court, has not given any finding and only held that there is a collusion and that such a finding needs to be set aside. Next parallel, counsel appearing for the respondent insurance company submits that the investigating officer, the person who has done investigation on behalf of the insurance company has placed before the court all the photographs and also the CD showing the conversation which is recorded by him. And as per that, the owner of the vehicle has also accepted the fact that the vehicle is implicated. Next para, implicated, and the court has rightly exonerated the insurance company, having heard the counsels on either side. The material on the court. The court gives a finding that there is a collusion between the driver of the vehicle, between the owner and the claimants, except giving a finding and relying on certain judgments. No other findings are given by the court. When counsel appearing for the insurance company has drawn the attention of the court to the report of the investigating officer. The court has failed to discuss the report of the contents of the same content of the same report, and also the claimants have and they have also not examined any witnesses in this regard. In view of the above, this court is of the view that the order under challenge needs to be set aside and the matter has to be remanded back, giving opportunity to all the parties to prove their case. In that view of the matter, this court is passing the following order. The award dated so and so is set aside. The matter is remanded back to the MSAT. Accordingly, MFA is allowed. The parties without further reference shall appear before the court on 8th of June, and the court shall consider all the contentions are left open, and the party shall reduce evidence on all the aspects, and the court shall dispose of the matter within 6 months from 8th of June.
Obliged.
Huh? 15th, 16th, what happened?
For the first respondent.
Yes, Mr. Shivanagowda. Where is he? Was here?
He was here.
Yes.
In this case, insurance company appeal challenging the liability on the ground that manner there is no policy issued by the insurance company on the date of accident. But they have mentioned one policy number in the claim petition that was not issued by us. Therefore, we have filed the affidavit stating that we have not issued any policy. Let the policy particulars, the policy copy furnished before the court, so we will verify. On the other hand, the owner of the vehicle has appeared before the court. He has not filed the written statement or the policy copy before the court. Therefore, madam, in absence of the policy copy, I am not in a position to say that it is issued by me. The particulars.
How the court has held that you are liable?
There is no basis. That is the reason.
My lord, I may be permitted to pass on this.
Take it.
Your lordship may kindly see column number 3. The date of accident is 29/7/2013. Your lordship may come to column number 10. 28/7/2013. The policy was taken on 28th. The accident took place on 29th. There is a coverage of policy.
His details were there.
It is not placed before the court.
Accident
to say that, my lord.
Where from you are getting this?
We got it subsequently. It is not placed before the honorable.
Verify.
Let them give the particulars, my lord. According to our particulars, my lord, this vehicle is not
insurance
insured.
company submits that. The particular, they have no particulars about the insurance policy. And it's a case that the The vehicle is not insured by them. They are counsel for the,
This, in this, my lord, there is no policy at all. If ye produce any policy copy, then I will verify it.
no, from this you can also find out there is a number.
No, my
SN.
lord, this is not there. Your lordship kindly say, let him produce that policy
I don't
copy.
have the policy. Let
That
him
is the
ascertain whether
problem.
the policy is issued by them or not.
Oh, 1 minute. With these details, can something be ascertained or not?
This is already mentioned in the claim petition. This
Already mentioned.
particular, which was not issued by us. No, if they had any policy copy, let them produce.
Where is the owner of the vehicle?
He has appeared before the court, but he has not
What
filed
about,
written.
what about before this court?
He has appeared. Yes, Girish.
Who, where is he?
Let the direction may be issued to them to produce the policy copy.
By the next date of hearing, the counsel for the respondent number 2 shall place before the court the insurance policy, if any. This is matter on 10th of June.
10th, beyond that date, I'll not be, 10th.
Want it in July?
June 10th, okay, madam.
Huh?
10th, okay, madam.
Next.
Can you be taken up next week?
Next
Here on behalf of Krishna Kishore.
After vacation. Yes, 19.
My lordship, I'm appealing for the respondent. My lordship. It's the owner and claimant appeal, my lordship.
Ravi Sampati, all of you, all the insurance companies, at least till 2015, what are the appeals pending from your respective offices? Give the list. Because the insurance companies' appeals are more important than the claimant's appeals. Because the amount, there is a stay order by the court. At least, I think till 15 we should complete. Yes.
In
Yes.
2914, my lord, I am for appellant, 2914 of 2016. And 8618 of 2015 is filed by the claimant. 2914 of 2016 is filed by the owner of the vehicle, because liability fastened on the
owner. On what ground?
On ground that the rider of the motorcycle was not having the valid driving license as on that day. But the charge sheet is filed.
So you are also questioning the same thing, or you are on the
Yes.
enhancement also?
Enhancement, they filed, my lord, some other advocate has
Only
filed.
you're saying you're for the claimant.
I am for the owner of the vehicle.
Then in that case also you are liable. Pay and recovery is not an order for you.
Pay and recovery is not order for the fastening the liability on me is questioned in this matter.
On the ground?
Fasten the liability on
What ground?
on the ground that the charge sheet is filed against the person who is a different. The court comes to the conclusion that that person is not riding the motorcycle as on that day. It is the person was riding the motorcycle was different. So he did not have the.
Where is the counsel? This is matter after
21.
My lordship, in the judgment of the 17 of the para, my lordship, para of 17 of the judgment, my lordship, is contrary to the.
That's what, he has to be there. Claimant certificate. Yes.
For the appellant in 2 appeals which are filed by insurance company, and another appeal is filed by.
You are on what ground? You are on what ground?
My grounds, my lord, we have taken the contention that the disease, that the claimants are not they are.
You are on the
they are
quantum or
traveling in the
liability?
vehicle.
Huh?
They are traveling in the lorry as a passenger in the goods vehicle.
And what is the finding of the court?
Finding of the court, my lord, it is said that they are the victims and they are suffered the.
No.
They are not the passengers
Oh.
of the vehicle. They sustained
In the
the
accident.
accident due to hit by the
What
lorry.
is the,
But in
what
another
the charge sheet
case,
says?
in another, there are 3 appeals. There are 3 cases. So in one of the case, that has been settled before local.
So,
and
my
the
lord,
liability is admitted
so they
and
cannot
it is
question
complied, my lord. So
What
our
about
appeal,
this?
or these appeals may not sustain.
His appeal has to be heard. It's a case of death.
My lord, it's a case of injury, my lord.
Where is the
My lord,
table?
my lord, in first case, my lord, serial number 20, 735 bar
No, these
2016.
two are not two different cases. It is one by the, oh, there are two.
Two different cases.
No,
Like
Srinivasan,
same accident, 3 persons are involved.
no, same accident.
Yes.
There are
15,
two
12.
appeals by the insurance company.
Two
Yes,
appeals.
And one appeal by you.
Yes.
Yes.
In another claimant, my lord, has not
You're
preferred
not.
any appeal.
So only in 735, we have to look at the enhancement.
Yes, my lord, correct.
Where is the table?
Lord, Lord, the claimant has sustained, my lord, regarding the injuries, head injury has sustained. Lord, neurophysical psychological assessment was done by the NIMANS. Paragraph number 11, my lord.
Still look at the other,
Chart, my lord.
yes, pain and suffering.
Lord, pain and suffering.
What is the injury?
My lord, head injury. My lord, he has sustained, my lord, head injury and neurological assessment was made by the NIMANS and then and has given the assessment of 49% disability, neurological defect, my lord.
So pain and suffering will grant another 25,000.
My lord, kindly appreciate, my lord, before that, my lord.
50,000
if I
is
could-
granted, my lord.
How many days he was in hospital?
My lord, he was unconscious for 49 days, my lord, unconscious.
Thereafter?
2 months, my lord,
57,
he was under
57.
treatment.
And thereafter, my lord, he has taken, my lord, second time he was readmitted.
So altogether, how many days in hospital?
My lord, 57 plus 65 days, my lord.
Medical expenses?
My lord, medical expenses as per bills, my lord, is awarded.
Why medical expenses for this much of 35,000?
My lord, he has taken treatment, my lord, at government hospitals.
Hospital.
Yes, come to the
Lord.
doctor's evidence.
Lord, doctor, evidence, my lord. Paragraph number 12, my lord, I'll.
Yes.
Lord, I'll read
para 11.
page number 12, my lord, from the middle. That on 27/7/2015 and on 31/7/2015, the patient brought before further treatment and he was suggested to undergo psychological assessment and rehabilitation. Even on 25/7/2015, the neuropsychological treatment was conducted and found inadequate functioning following motor speed, mental speed, focus, attention, and other 8 deformities. It is in the opinion of the medical officer that as per the guidelines of Ministry of Social Justice and Empowerment, the patient is having disability of 49% of neuropsychological assessment. The patient need further medicines and also attendant to take care of him. Normally, 95% of the patient would recover within 6 months and remaining 5% is recover within 2 years. Here, the patient, even after the lapse of 2.5 years, the same position is continued. So there is no chances of recovery and disability seems to be permanent. Neuropsychological assessment document marked as exhibit C1 and medical history is as per exhibit C2. Even after cross-examination, the medical officer in detail, there is nothing elicited from the mouth to disbelieve the gravity of the injuries and percentage of disability. Here in the case, the petitioner counsel filed the petition through the petitioner himself by giving his signature. Since the petitioner is not in a position to speak properly, the next friend of the petitioner, who is the mother of the petitioner, is examined. When the petitioner is unable to understand the things, it is the duty of the counsel to file the petition.
Court had taken 100% disability. What else you want?
My lord, 100% disability is not taken. My lord, though observation is made, while taking, my lord, only 49% is taken. My lord.
What is the income?
My lord, 6,500 is taken.
Which year?
My lord,
11?
13. 13.
2013, then it has to be 8,000.
2013.
So loss of future income.
My lord, 100% has to be taken. In case of 100%, my lord, future prospects also need to be taken.
That's what,
Yes, my lord.
40% is 3,200.
Yes. 10,000, so 11, 8.
Into 12, what is the multiplier? 18.
18, my lord.
It comes to 24 lakhs 19,200.
Lord, attendance charges, my lord,
Then next will come to the next. Then attendance charges, you said so that incidental charges I have granted 65,000.
my lord, attendant, my lord, he need an attendant
No,
throughout
that
his
is a
life.
different, that way will come.
Yes, ma'am.
Future
Ah,
medical expenses, what is the evidence?
My lord, doctor says, my lord, he need further surgery, but so far as the exact amount, my lord,
Then if without even saying the court has already granted, that will
1
not.
lakh is granted.
Huh?
1 lakh is granted already.
What's happening in the court? There should be some future medical expenses is already granted.
yes.
Loss of marriage prospects.
50,000 is granted.
Lord, now also, my lord, he is bedridden. Lord, he need a attendant, my lord, some
We'll grant 1 lakh.
publish.
Then, on every, no loss of amenities under that caption, nothing is required and everything is 100% given.
Yes, ma'am.
So then coming to the attendant
Attendant
charges,
charges, my lord.
when it is 100% we have taken,
Yes, ma'am.
judgment of that, what is that? Kajal and all, that Kajal only?
Yes.
Kajal or in that, those judgments,
Yes,
that also is calculated in terms of multiplier.
Multiplier only, my lord. Yes, ma'am. At least, my lord, the 5,000 rupees if it is taken attendant.
5,000 into 12, what is his age?
My lord,
18.
18.
Mr.
10 lakh 80,000.
Get more than 50 lakhs.
There are several heads. I'm not repeating all that.
Yes, ma'am.
Pain and suffering 75,000, incidental expenses 65, medical expenses 35,000, lot of loss of future income 24 lakhs 19,200, future medical expenses 1 lakh, loss of marriage prospects 1 lakh, attendant charges 10 lakh 80,000.
Yes, ma'am.
Remaining other heads I'm not adding.
Publish.
It's coming to 57 lakhs 84,200. Correct?
Yes, ma'am.
against 11 lakhs,
25,960.
25,960. What is an MVC number in MFA 25555?
572/40.
572.
22.
572 of
2014.
2000.
then MFA 1869?
Same thing, same. The present appeal by him.
In that the numbers are there? No.
No, same number, say in the same appeal, same person.
How can it be same?
No, my lord, we have challenged the award.
There
He
are-
has filed an aspect.
Yes.
That is
Sir,
that
ಅದಲ್ಲದೆ
number
ಇನ್ನೊಂದು
you are
appeal
saying.
ಇದೆ. The other appeal.
Give me the number. That is what I
Yes.
want.
Another MEC number 1849.
You the file.
1869/17 is 1178.
Because that is what you are supposed to write and assist the court.
Yes. 1869/17 is.
No, anyhow, I am looking at it. Give the first file. This is on 730. Agreed by the award passed in MVC 572 of 2014. Both the insurance company as well as the claimants are before this court. Insurance company's appeal is MFA 735 of, claimant's appeal is MFA 735 of 2016. And the insurance company's appeal is MFA number 2555 of 2016. The insurance company's appeal is on the ground that the injured are the inmates of the lorry, and the insurance company is not liable to pay the compensation. When counsel appearing for the claimant submits that in respect to the very same accident, the insurance company has accepted the liability and paid the compensation.
In MFA.
That is in
MFA number 3.
3723 of 2015.
3723 of 2015 MFA. In the light of the same, now the insurance company's appeal has to be dismissed. When counsel appearing for the appellant insurance company does not dispute the fact. Hence now the court has to only consider the appeal filed by the claimant seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. It is the evidence of the doctor that where do you get that?
Paragraph.
Paragraph
12.
number 11, my lord.
Page 13 of the judgment.
Page number 2.
The doctor is examined as PW2. The petitioner the claimant had sustained suture wound over the left frontal region with underlying fracture, swelling on the left elbow. A surgery was conducted at Nimhans Hospital on 18/12/2012 and he was discharged on 6/1/2013. It is stated by the doctor that the patient was unconscious even the date of discharge and tube was fixed for breathing purpose. It was advised to take further treatment in any general hospital for the convenience of the attendants. Again, the patient was brought to Nimhans on 15/3/2013 for follow-up treatment. On examination, it was found that the patient started to recognize the family members and oral feeding and stammering in speaking. Then on 25/7/2015 and on 31/7/2015, the patient brought for further treatment and was suggested to undertake neuropsychological assessment and rehabilitation. On 25/7/2015, neuropsychological treatment also conducted and found inadequate functions following motor speed, mental speed, focus, attention, and other 8 deformities. It is the opinion of the medical officer that as per the guidelines of the Ministry of Social Justice and Empowerment, the patient is having disability of 49% of the neuropsychological assessment. The patient needs further medicine and also attendance to take care of him. It is stated that normally 95% of the patients would recover within 6 months and remain 5% recover within 2 years. Here, in this case, the patient, even after the lapse of 2.5 years, the same position is continued. There are no chances of recovery and disability seems to be permanent. The tribunal
The next
has
page.
held that though the petition is moving, it is only with the help of his mother and he is unable to do his personal work independently. He is unable to speak properly, he is unable to understand the things. Merely because the petition is moving along with his mother, it does not mean that there is no disability as expressed by the medical officer or any less disability as contended by the second respondent counsel. When there is a deficiency in the motor speed, mental speed and other deformities as mentioned in the case sheet, the court cannot reduce the percentage of disability as doing with respect to the other organs by reducing 1/3 by comparing to the whole body. The whole body is controlled by the brain. When there is a difficulty in the brain itself, accepting the percentage of the disability as appointed by the medical officer is proper. The Honorable High Court in the decision reported High Court has opined that as there is 100% disability to the injured since the injured was semi-unconscious. In this case also, petitioner, the claimant, though he is physically moving, his brain is not responding properly. Even his physical appearance also speaks the same thing. The same will be seriously affected to his marital status. And accordingly, court has the court has considered the disability at 49% and granted the compensation as per the table given below at page number 23. Extract the table. When counsel appearing for the claimant submits that, though it is stated with the doctor that it is 49% disability, but in fact, these even the evidence goes to show that he is not in a position to talk. Is not in the petitioner is not able to do anything, and he is going around. Only he is able to walk along with the mother. He is not in a position to work independently. And there is a deficiency in motor speed, mental speed, and other deformities. In those circumstances, as rightly observed by the court, it amounts to 100% disability. However, the court has not, the age of the boy as on the date was 16 years, and the court, 16 years, and the court, though having felt that, or having observed, having mentioned about the judgment of the High Court, but however has taken only 49% disability. In the considered opinion of this court, this is a case of 100% disability. Hence, this court is taking the disability at 100%. This accident had taken place in the year 2012, and the court had taken what?
6,500.
2000, not 12, you said 2013.
Well, my lord, it's 18/12/2012, my lord, almost 2013.
As though it is the accident had taken place on 18/12/2012. This court is taking the income as applicable to 2013, that is 8,000. Future prospects at 40% comes to 3,200. Then his income is 11,200 into 12 into 18 is 24,19,200. Coming to the future medical expenses, the court had granted 1 lakh, and this court is not interfering with the same. No, leave that. The pain and suffering, incidental expenses, medical. What is discussed first? Only future. It comes to 24,19,200 towards pain and suffering. Considering the injuries, this court is granting 75,000. Incidental expenses as it was in the hospital for 65 days. This court is granting 65,000. Medical expenses as it is. Future medical expenses, court has awarded 1 lakh, and this court is not interfering. Loss of marriage prospects, this court is granting 1 lakh. Coming to the attendant charges, as he requires complete assistance toward his life, as laid down by the apex court in Kajol's case. In Kajol's case, have the citation.
Another judgment also.
In so and so, give that judgment in so and so. considering the attendant expenses at 5,000 into 12 into 18. This quote is granting 10 lakhs 80,000. 80,000. Then loss of income to the parents during later period for 6 months into 8, 48,000. In the light of the law laid down in Mekala or so and so, 10,000. Altogether, 3784 200 plus 48. It comes to 38,000, 38 lakhs, 32,200. Accordingly, the appeal of the insurance company is dismissed, and the appeal MFA number so and so, and the appeal of the claimant is partly allowed by enhancing the compensation from 11 lakh 25,960 to 38 lakh 32,200. This amount, what was the conditions laid down by the court?
Lord, 50%, my lord, to be deposited for a period of 5 years, my lord.
No, we'll ask him to deposit the amount because he is too young and it takes a lot of time.
Yes, my lord. My lord,
Not for 5 years. It should be there. Like only whenever it is required, an application should be filed for him and the entire amount.
Lord, 50 or 60%, my lord.
75% of the amount shall be deposited in a nationalized, in a fixed deposit in a nationalized bank, and whenever the remaining amount shall be they permitted to withdraw, and whenever any expenses for any expenses of the claimant, if they have to withdraw the amount, they shall move the court and seek appropriate permission.
Move the trial court.
Before the trial court. The appeal, the amount in deposit shall be forthwith transferred to the court. Then coming to the next, it's a common order, and it's only one. This MFA number 1869 of 2017 is filed, questioning an award passed in MVC number 1178 of 2014 in respect to the very same accident, same the first para. So nothing survives for consultation. Accordingly dismissed. The amount in deposit shall be forthwith transferred. Take this. Yes. What you do is the entire list post it tomorrow, because once that first batch, if it collapses, then we'll deal with this.
25 after vacation.
Which one?
35.
35.
25.
1 minute. 35. Yes, 35 after vacation.
25 minutes.
25.
24 also.
24 after vacation.
50.
25 after vacation.
50 and 56. 50 and 56.
1 minute. 50.
1 minute.
1 minute. 1 minute. I'll do one thing. I'll only call page wise 50 and
56.
50, 50, 50
is there for dismissal.
After vacation.
50 and
56.
56 was posted for dismissal.
56
After vacation.
after vacation.
56 was posted for dismissal, madam. 56 dismissal ಗೆ post ಆಗಿತ್ತು ಸುಮ್ಮನೆ ಬರ್ಲಿಲ್ಲ ಬಂದಿರ್ಲಿಲ್ಲ ಅಂತ.
Want it to be argued before vacation? To argue this matter tomorrow.
Not tomorrow, Monday or Tuesday.
Will any appear virtually and argue? Because it's an appeal file. Tomorrow we'll keep this matter tomorrow.
21 my lord.
22
I will call. If you have anything, you can make a mention. Yes, 22 to 27.
21 my lord.
22 my lord. 22 after
20.
21 my lord.
It's already 21 is adjourned already.
22 my lord. 21
22.
after vacation.
Yes, after vacation.
21 also after
24
vacation.
also.
24.
After vacation.
It's already adjourned in the
Yes,
morning
yes.
itself. 23. 26.
25, 26 after vacation, madam.
Huh?
After vacation.
26 after vacation. 27. Why you are asking your appeals after vacation? Let it be there in the list tomorrow, 26 and 27. Tomorrow. Yes,
Millard,
28.
Millard, 21, Millard, after vacation. I have to.
Yes, 21 after vacation.
But
28.
28, I apply for respondent for, I request for after vacation,
After
28.
vacation. Yes.
Please, ma'am.
30. 30 after vacation. 33.
32 tomorrow, my lord. 32 tomorrow. I am
30.
ready. 32.
32 urgent already. Oh, Mahesh has already sought in the morning itself.
Sorry.
33. 33 after vacation. Yes, 36.
36 after vacation, my lord.
Yes, 36 after vacation. 38.
38 would it be on Monday?
Monday it can't be taken up after vacation. Yes, either it is tomorrow or after vacation.
Tomorrow it could be.
Huh? 38 tomorrow. Yes, 39. After vacation, 40. After vacation. Yes, after vacation. Same. Same. After vacation. 46. After vacation, 47. After vacation. Yes, after vacation, 48.
Tomorrow, 48 minutes will be taken tomorrow.
Tomorrow, 48 is 49. After vacation. After vacation. After vacation.
Tomorrow, my lord, I'm for the appellant.
54. Vacation. Yes, Pradeep, 54.
Yes, my lord, ready. Tomorrow.
54 tomorrow.
54.
Then why are you not, why are you keeping quiet?
No,
55.
I'm seeing other
I'm
file.
thinking like you people want adjournment. 55.
55, my lord, I had to take
Yes,
steps, my lord.
Huh?
I had to take steps to R2.
Then 55 after vacation. Then. Yes, 57. Tomorrow. 58.
58, my lord, only interest reduction, my lord, 8% to 6% could be disposed of now.
Now itself.
7.5% instead of.
58. The appeal is filed by the insurance company questioning the award passed by the tribunal in so and so, so and so. Only on the ground that.
Quantum.
Only
quantum.
Only on the, only on interest.
Interest.
Only on the ground that the tribunal has granted interest at what percent?
7.5%.
7.5% instead of 6%.
6%.
Accordingly.
That's what I'm not pressing that. I'm not pressing that.
They are only said so. Accordingly, the appeal of the insurance company is partly allowed by reducing the rate of interest from 7.5 to
6%.
6%.
Amount in deposit may be transferred.
Amount in deposit shall be forthwith. Yes, then.
LCR may be transferred. LCR may be.
So many orders you see, then again you ask it. You don't have to ask. 59.
It's a
What
case
about
of
this?
murder, my lord. It's committed to.
Yes, this
converted to
after
accident.
vacation.